Angelica, you are the host now.
Hello, can anybody hear me?
Yes, I do.
This is Mary Lee Souls, and I'm having difficulty getting on with my video connection. So I'm on the phone right now. The next thing I'm going to try is to restart the router. My apologies.
Okay. Thanks for letting me know, Miss Souls.
I'm in the same place doing the same thing that I did yesterday. I have no idea why this is a problem this morning.
The mysteries of the internet. I don't know. Okay, well, we're going to get started in 3 or 4 minutes. So I'm just going to stop my video until then.
Okay, thank you.
Good morning, Madam Hearing Examiner. Just checking to see from our witness room that you can see and hear for later when we bring on the other witnesses.
Yeah, it shows the microphone working. Yeah.
Oh.
I think she's on now. Hello, can you hear us?
Yes.
Thank you.
Okay, thank you. Good morning. How are you doing?
Good morning. A little bit of a hectic morning, but
Yes.
we're here.
All right. We're just going to turn this camera off until Renee Gonzalez is on as a witness.
Okay, thank you.
Good morning, everyone. This is Anastasia Stevens. Madam Hearing Examiner, when I signed on, can you hear me?
Yes.
When I signed on, I got a notice that you were controlling mutes and unmutes. Are you doing that today?
Not intentionally.
Okay, well. I also apologize for being a minute late because I was trying to sign until last week's pre-hearing conference.
Well, I will say that according to my laptop, it's exactly 9 a.m. right now. Now that's different from the time on my phone, which I tend to think is a better time, but I'm just using my laptop time. So we're going to start.
Are you at the commission?
No.
Oh, we've had that problem before with hearing exam. Maybe it's the state of New Mexico system that is 2 minutes behind the rest of the world.
I think it might be, but I think we're ready to get started now. There's no one in the waiting room. Okay, so we are on the record this morning in PRC case number 23 22-00093 UT, the El Paso Electric Company application for its energy efficiency plan. We're going to get started this morning with EPE's next witness.
Morning, Madam Hearing Examiner. Jeff Wexler, first time I'm making an appearance in this particular hearing, and EPE calls Wayne Oliver, who I believe is already on Zoom.
Yes, I'm on, Mr. Wexler.
I would ask that anyone who isn't actively participating, if they're not needed, can go ahead and turn their video off just to reduce the bandwidth on this. It's appreciated. Thank you. Go ahead.
Madam Hearing Examiner, would you like to swear the witness or have him sworn?
Ms. Gonzalez, can you swear Mr. Oliver in?
Raise your right hand, please. Do you solemnly do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good morning, Mr. Oliver.
Good morning.
Could you please state and spell your name for the record?
Yes, my name is Wayne Oliver, W-A-Y-N-E-O-L-I-V-E-R.
And you have produced both direct and rebuttal testimony in this case, is that correct?
That's correct.
Do you have that before you?
Yes, I do.
So let's turn first to your direct testimony, which has been previously identified as EPE Exhibit 5. Was that testimony produced by you or under your direct supervision?
Yes, it was.
Do you have any corrections?
Not on my direct testimony.
Is the direct testimony EPE Exhibit 5 true and correct to the best of your knowledge?
Yes, it is.
If you were asked the same questions that are posed in Exhibit 5 today, would you give the same answers?
Yes.
And your testimony has already been admitted. So then turning to EPE Exhibit 6, your rebuttal testimony, Mr. Oliver, do you have that before you?
Yes, I do.
Was that testimony produced by you or under your direct supervision?
Yes, it was.
Do you have any corrections to your rebuttal testimony?
Yes, I have 4 corrections.
Very well.
Right.
And Madam Hearing Examiner, before I ask Mr. Oliver to walk us through those, I believe there's at least one of these corrections that was not made on the red line, and I understand that's not directly in line with your order, but these were things that were found later by Mr. Oliver and that do impact the meaning of his testimony. And with that as a pretext, if I may allow Mr. Oliver to proceed.
Yes, please do.
Mr. Oliver, if you could point out the corrections, please.
Yes, the first correction is on page 6, line 4. And it should say, instead of January 14th, it should be June 14th.
Very well. And we see that is already listed on was previously marked by EPE. Could you move to the next correction?
Yes, the next one is on page 11. And on line 4. And I believe this is one I discovered yesterday. So this one may not have been on the original changes. And the date April 11th actually should be April 22nd.
Is this, sorry for the interruption, but are we using the page numbers of the rebuttal testimony or the date stamping?
I guess it's the rebuttal testimony. The date stamping would be page 013.
And I'm sorry, so that date, April 11, 2022 should be changed to?
It should be changed, April 11th should be changed to April 2022.
I'm sorry, April 20th or April 20th?
April 22nd, April 20th. April.
Thank you.
What's
your next correction, Mr. Oliver?
My next correction is on page 13, line 6. Let's see. And that would be on page 015 of the date stamp. And it's, as I mentioned, line 6, the last word 4 should be 2.
All right, and that one is also previously marked by EPE. And so what's the last of your 4 changes?
The last is on page 17 and line 2,
And this would be page 19 of the Bates stamp,
correct.
please.
And the word is should be in.
And I understand those are all the corrections that you have. Is that correct?
That's correct.
With those changes, Mr. Oliver, is the rebuttal testimony EPE exhibit number 6 true and correct to the best of your knowledge?
Yes, it is.
And if asked the same questions today that are posed in EPE exhibit 6, would you give the same answers?
Yes, I would.
Madam Hearing Examiner, I understand these have been previously admitted, subject to affirmation, and with that, unless there's any questions, we tender Mr. Oliver for cross-examination.
Thank you very much, Mr. Wexler. Office of the Attorney General. Do we have counsel with us today from the Office of the Attorney General?
Madam Hearing Examiner, I have been in contact with Mr. Elliott. He was unaware that we were starting an hour early today, so he'll be here in a few minutes.
Okay, thank you very much, Mr. Herman.
All right.
Why don't we then move to the City of Las Cruces, Ms. Stevens?
Thank you, Madam Hearing Examiner. Good morning, Mr. Oliver. How are you?
Good morning, Ms. Stevens. How are you doing?
I'm okay. I'd like to, you were pretty lucky yesterday. I don't know whether you were watching the whole thing, but you didn't get too many questions to put to you.
That's good. That's a good thing, right?
A lot of overlap between your testimony and Mr. Martinez's that I would have asked you about anyway. So start with your direct testimony. And this is Bates stamped. These are going to be hard because they're Bates stamped. Oops. So it's pages 710. See, there's no number on this, in page 710. Bates stamp pages 710 to 711. When you supervise your responsibilities, and this is summary of the statement of work that you've attached to your testimony, right?
Right.
So the second, number 2A on line 14 through 16, review and comment on the draft RFP. You didn't attach the RFP itself to your testimony, did you?
No, I did not.
And the company, Mr. Martinez, didn't either.
I'm not sure of that. I don't know if that's. I don't
Would
know
you?
if that's
We ended city witness Ms. LaRock ended up adding the company's RFP to her testimony because it wasn't together. So would you please open CLC exhibit number 1?
okay. I'm sorry here. This might take a few minutes.
Yeah.
Anastasia, while we have a second, I just want to say Mr. Elliott is in the waiting room.
Thank you.
Have a better view.
Okay, Ms. Stevens, I
Madam
have,
Hearing Examiner,
I have Ms.
Yes.
Lott.
excuse me, this is Mary Lee Souls. I think I'm also in the waiting room.
Yeah, I have
Yes,
admitted you.
thank you.
You're welcome.
Thank you. I'm going to turn this off then. Thank you.
Is everybody here now? Yeah. Okay. We're ready to go. So have you got CLC exhibit 1 open?
I do.
And would you turn to page 75 of that document?
Okay, I have that.
And is that the company's RFP labeled exhibit LL1?
Yes.
So I'd like you to compare the introduction section of the of the RFP itself to your direct testimony. The introduction begins on page 79. And I'll explain just so anybody's anxious that somehow mysteriously putting the footers on for the date stamping, a lot of the formatting disappeared, but Ms. Olson and I conferred about this and decided that it was acceptable that the little pictures of El Paso Electric and stuff like that didn't require a replacement. So is that correct? Oh, actually, is Ms.
No,
Olson-
Mr.
just Mr. Wexler on. I'm sorry. So anyway, page 79 of 129, and let's go then back to your testimony at, whoops, your testimony at page 708.
Okay, I have my a printed copy of my testimony because
Oh,
switch back and forth may be a challenge here, so that's why. you don't
yeah. And Mr. Oliver, do you have I know that the company had problems too with those footers. Does your direct testimony that you actually have on paper, does it have ordinary like page numbers in the center, or just the footer numbers, or dates numbers?
Well, no, it's good. This one has the page numbers in the center. The center
because
bottom, center bottom.
the one I'm looking at has just the Bates number, so we are going to have to struggle a little bit here. I hope that we can figure that out, or learn to do quick arithmetic in our heads.
Yeah, if you could actually give me the question and the
okay. So you're looking at. I'm just wondering whether your points 1 to 3 on in your testimony are basically the 3 bullet points in the introduction of the RFP verbatim. Is that true?
I would have to. That's subject to check. They should be similar. They look similar. I'm not sure if they're verbatim or not.
Did you draft this portion of the RFP yourself, or did you review it after somebody else at El Paso Electric drafted it?
No, El Paso Electric prepared the first draft, and I reviewed the first draft and provided comments.
And were your comments in the nature of substantive ideas about how to make a better RFP process, or were they copy editing? To put it mildly.
It was probably a combination, as I recall. But I don't remember the exact breakdown of which ones were edits and which how many were substantive comments.
Well, let's just focus on these 3, but which are testimony or the RFP. Number 1, resources to support a short-term capacity need of 40 megawatts in 2022, growing to 90 megawatts in 2020.
I'm sorry. Number 1, resources to support a short-term.
Short-term capacity need of 40 megawatts in 2022, growing to 90 megawatts in 2024.
That part is correct.
What was your role? See that? What was your role, if any, in actually determining whether El Paso had a short-term capacity need of 40 megawatts, growing to 90 megawatts?
I didn't verify those results. If that's what you're asking about, that wasn't part of our scope of work as the independent evaluator.
And is the same true of the bullet point, or number 2, or the second bullet point, a long-term capacity resource of approximately 90 to 100 megawatts no later than May 1st, 2025?
That's yes, it is.
And that phrase that comply with the requirements of the New Mexico Renewable Energy Act and Rule 572. Did you did you have any questions of the company as to what that meant?
Not specifically. I was aware of the the regulations in general, but I think like you asked before. I mean, this looks like it's verbatim from the RFP, and it's typical as in our role as independent evaluator that we're not part of generally the integrated resource planning process, which generates these the need analysis for the RFPs. So I didn't go back and verify these numbers. I basically identified what Epe'S requirements were as listed in the RFP.
So you did not verify what was listed in the IRP. Is that your testimony?
I didn't independently go back and verify that El Paso Electric had a short-term need of 40 megawatts growing to 90 megawatts, or a long-term need of 90 megawatts to 110 megawatts. That's generally part of the utility's responsibility, and that's part of the IRP process. And generally, if it comes out of the IRP process, it's already been vetted through through the regulatory process, and through intervener groups and participation groups.
And the same is true of your third item, the 175 megawatts online by December, megawatt hours online by December 2024 to meet the REAs and Rule 572's requirement of 40%. Is that right?
That's correct. Yes.
And have you at any point looked at Epe'S IRP that underlies the RFP? And we're going to get crazy with the acronyms here, but have you looked at the IRP that underlies this RFP?
I haven't read it in detail. I can't say that I've gone through it in any kind of detail. I just skimmed the executive summary basically, but I wasn't part of the IRP, so I didn't review it in detail to verify the information.
Okay. So you cannot say that you saw that there is a stated capacity need of 40 megawatts, short-term capacity need of 40 megawatts, or a long-term capacity need of 90 to 110 megawatts, or a long-term renewable energy need of 175 megawatts stated explicitly in that IRP, can you?
I have, as I mentioned before, I haven't verified those results. And that's typical of our role. We don't verify the results of an IRP and what the utility procures. That's generally before we get involved in the process.
What is your understanding of the 90 to 110 megawatt capacity, long-term capacity requirement? Is in your understanding, is that measured by effective load carrying capacity, ELCC, or by more traditional peak hour of the year standard?
Well, I was aware in discussing with El Paso Electric that the need was based on ELCC values. That's the reliable capacity requirement.
And do you believe that standard was conveyed, since you did review the RFP? Try to take this slow here. Do you believe that was conveyed to the bidders in the RFP?
Yes, it was. The part of the RFP process is the question and answers that the bidders have the opportunity to ask questions, and the company responds to those questions. And those questions were posted on the website. And one of the questions basically, was asked what the ELCC, what the values were the requirements were, and the company answered that question.
Would you turn to CLC exhibit number 1, Ms. LaRocque's testimony at the exhibit 1 at page 86 of 125?
This is still the RFP?
This is still the RFP.
Okay.
It's 86 of 125 of her. I mean, I don't know whether you're looking at it. In this case, the 86 matches the also the little box on top of the PDF document on the toolbar. Might be easier to use.
Right. I have that. Okay.
Okay. So you said that there was questions and answers on the ELCC thing. Did you, when you reviewed the draft, this paragraph seems to talk in, if you look at the last 2 sentences of that first long paragraph.
Okay.
I'm looking at the beginning with furthermore, to quantify the capacity contribution of different energy resources, EPE will also evaluate proposals based on the effective load carrying capacity, ELCC of the resources. The ELCC of, see that?
Yes.
It's actually three sentences up. So do you think that this, when you read this, when you review this, first of all, did you make any recommendations, edits, comments on this particular paragraph?
I don't recall. I don't recall if I did or not. But I do notice in this paragraph that, if the word also is what you're referring to, it looks like above that says EPE's evaluation will include a review of expected annual outputs and profiles, et cetera.
I'm sorry,
So
please slow down. EPE's evaluation included.
Okay, I'm sorry. EPE's will consider a combination. Well, I'm sorry. No, I'm sorry. EPE.
I think we're going the same place, Mr. Oliver, and it's that word also that you picked up. And I'm just wondering whether that creates ambiguity about the whole request.
Yeah, if you above that, I guess when I started before, EPE's evaluation will include a review of expected annual output profiles and dispatchability, and talks about flexibility, peak usage, that type of thing. So I looked at the word also as just being this would be another factor that's going to be considered among all the factors that are identified in that paragraph.
So that I think are you saying then that the ELCC and the stated capacity needs of 90 to 110 megawatt hours are not necessarily stating that we are all looking for 90 to 110 megawatts ELCC, but that the ELCC is a form of analysis?
I'm sorry, could you repeat that? I'm confused by that question. I'm sorry.
Okay, so are you saying, is it your take on your interpretation of this, that when they asked for 90 to 110 megawatt for its summer, and it's going to the top, third line, 90 to 110 megawatt of capacity resources, so it's summer 2025 summer peak, and then you go to the bottom and say EPE will also evaluate proposals based on the ELCC. Are those like two different requirements, sort of? Peak, summer peak, and then ELCC, or are they one and the same, or are they different?
The issue is with effective load carrying capability, ELCC, it basically, it looks at how much, what the capacity value is of a particular resource and what the utility needs to meet those requirements. So this looks at, how much, reliable capacity that resource can provide. So as Mr. Martinez mentioned yesterday, a storage project would have a capacity of, close to 100%. Whereas a wind or solar project would have an ELCC value that's lower than that. It's, that I believe what's included in the response to the question about ELCC values, that EP responded that for solar it's between 38 and 43%, and for wind it's 27 to 28%. Meaning, if someone has a 100 megawatt wind project, that project based on the ELCC values would only be able to provide 27 to 28 megawatts of reliable capacity, not 100 megawatts.
And reliable capacity, that's a year-round or a summer peak concept?
I'm not sure exactly how EP has done that, but I know that they did retain E3 to conduct a study. So I believe, I don't know exactly what the time frame is that's based on. You probably should ask Mr. Martinez about that.
As far as the Carne project, you understand that that's 65 megawatts of battery storage and 130 megawatts of solar PV, right?
100 megawatts of nameplate of solar PV. Yes.
130.
130, I'm sorry. Yeah, 130 megawatts. That's only nameplate. That's the issue. It can't, that project can't provide 130 megawatts of reliable capacity because it's an intermittent. So it's only available when it's available.
Yeah.
And you generally look at your load profiles to determine what that value is. And in this case, from the analysis that EP has done, it would be 38 to 43% of the nameplate, not 100% of the nameplate.
And there's I don't know whether you were listening yesterday, but there were some questions about curtailment. So I just wondered whether when you look at this ELCC analysis, do you take into consideration the fact that a solar facility, whether paired with battery or not, may on a bright sunny afternoon be producing at least as much as its nameplate capacity? Is that part of the evaluation process?
Well, curtailment deals with the energy output from that project and not the capacity.
Okay. All right, I understand that. So I think we can set this aside so I can close this and see your face again, because I've got two screens here and I'm locked you off.
I have two computers, so that's why I'm looking
Two
back.
computers. Oh, how many sets of computers have you got?
Well, I don't use them all the time, believe me. Only for this.
Only for this. Okay. So going back to the size of the Carne project, I understand what you're talking about, the reliable capacity, but as far as peak capacity at 130 megawatts of solar and 65 of battery, couldn't that potentially be, and I know that the peak of the unit isn't necessarily the peak hour of the year, but couldn't that possibly be interpreted as close to 195 megawatts of peak capacity as opposed to, reliable capacity?
No, a few reasons. One is generally whatever the capacity is of the combined resource is generally limited by your interconnection capacity. So if I secure a long-term, large generator interconnection agreement that
I'm
has.
sorry, if I secure a long-term,
a large generator interconnection agreement, an LGIA, that will have a limit on what can be delivered into the system. So you can't theoretically go over that limit. The other thing is that the peak is generally, later in the day or even at night, and the sun doesn't shine during that time. So or much of the output is available during that time. So you're generally not going to get that much output, except maybe during the noon hours or something like that, which is not the peak. So that's where all the values come in terms of what how much reliable capacity you can project from the ELCC values. The other thing is the more solar you have on the system, those the capacity value is going to decline over time. That's what's happened in California, where the capacity value of solar is under is around 10% now. So it's because there's so much solar on the system.
So do you know what the interconnect value amount of the Carney project is?
I do not.
Is that something that's included in bids that you evaluate in a case like this?
Yeah, they generally discuss what the status of their arrangements are. I don't recall what their interconnection agreement called for, or their interconnection application.
And in the bids that the storage and the solar and storage or wind and storage bids that you saw, that you in this case, was it typical? Without since you can't quote specific, was it typical to set the an interconnection at the nameplate value of the renewable unit, or at some combination of the renewable plus the battery storage?
Yeah, generally, what I've seen in a lot of other states is that the solar is generally you might set it at the solar capacity. It's hard to say because some projects, sometimes the bidders will bid 100 megawatts of, this is an example, 100 megawatts of solar and 100 megawatts of battery. And solar, will charge that battery during the day, and the battery would be the limiting factor there. So it really depends. But when you generally have a smaller system, like say in this case where 130, 65 for the battery, it would generally be set at probably the 130, I would think, but I don't recall exactly what it was.
Okay. The ELC, before letting ELCC drop, I have just one question. Did EPE, did the EPE team use the ELCC values throughout the analysis of the bids when they were doing LCOE and plexus runs and everything, or did they mix and match nameplate or interconnection capacity versus ELCC?
Well, no, for the LCOE numbers, you really, you're looking at cost, so it doesn't really get into the value. And that's one of the big weaknesses of using using LCOE, levelized cost of energy, because it doesn't consider the value of that project. It only considers the cost. So you're only getting one side of the story. But the Plexos, when the Plexos model was run, the ELCC values that were calculated by E3 and adopted by EPE were included in the Plexos run. So when the evaluation was done to look at the least cost portfolio of resources, it did consider the ELCC values.
And as far as the LCOE, this is why I've been told at the New Mexico Supreme Court that they just don't want to see people from the PRC because we all talk in endless acronyms. They don't know what they are. So the lowest cost of energy, the LCOE, does the ELCC have any impact on the total estimated energy output, which is a factor in obviously the levelized cost of energy?
No, it's capacity. So it's the capacity value that we're looking at here with the LCC.
Okay. Now, given that the company requested 90 to 110 megawatts of capacity, and do you understand that the Carney is estimated to be 121? Have you seen, is that the number that you're familiar with?
Right. I'm familiar with that number. Yes.
Yeah, that's less than 130, which is the maximum that we comes out of the. So is the 121 compared to 90 to 110? Was that any sort of a red flag to you that the project might be a little oversized?
No, because it's, I think I'm sure it was Mr. Martinez, Mr. Novella yesterday mentioned it's difficult to match because it's capacity can be a little bit lumpy, and it's very hard to exactly match the capacities of the project. Now there was a fairly robust shortlist that had different sizes of projects. So, and those projects were evaluated to see if you could get closer. But either the costs were higher or you couldn't meet the full requirements with those projects.
I'm sorry, you can meet the
full requirements. So that's one of the issues. You generally, it's just going to be very difficult to exactly match the capacity and energy requirements that you're looking for.
I'm sorry, that's the exact capacity and energy
requirements.
I was going to ask you about the smaller bids. Did EPE receive a bid for a smaller variation of the Carney project?
Yes, I believe it was one. I'm not. No, let's see.
And was that?
I'm not 100% sure of that. I think there might have been, but I don't recall exactly. Because I know there was some projects that bid, different sizes. And
when projects, whether it was Carney or somebody else, bid different sizes, did EPE evaluate the different sizes in the Plexos runs, or did they thin it down somehow?
No, I believe they did for some projects. I don't know. I don't recall which ones, but there were a number of all the projects were run through the variations, and the projects themselves were run through the Plexos model. And was your testimony there that every project was run with the alternatives, or just some of them? I don't know. I'm not sure exactly which ones were run with alternatives or not. But there were, I forgot the exact number offhand, but there were like 13 proposals, I think, that were selected for the short list, and then 12 proposals, and then there were, I think, 17 alternatives in total. So I believe all 17 were run. But I can't go back and exactly verify which ones those were. Going back to your testimony, your direct testimony at page 708, which is the same page we were on before, if you haven't moved it.
It's page 6 on the testimony, Mr. Oliver.
708.
I'm sorry, Mr. Wex, I didn't catch what you said.
Yeah, I was pointing out that the bait stamp page 708 is page 6 on the testimony, which Mr. Oliver is using.
Okay.
And I'm looking at your bullet, your item number 3. Do you understand that the Carney project is projected to provide 398,343 megawatts of energy in the first year?
Yeah, somebody could check. That sounds right.
Did that number did that number compare to the 175,000 megawatts stated in your item 3? Did that raise any red flags for you?
No, I guess, the way I sort of looked at it is that the 40 megawatts, I guess, was the target. And, if you go over that, you're producing more more renewable energy to reduce emissions. I looked at that as I guess, a positive overall.
And does the modeling take into consideration, excuse me, cost savings for displacing conventional generation with renewable energy?
Yes, it does.
And do you know whether the company has provided any estimates in this case of how customers might actually end up saving by paying for all that energy at $29.96 in addition to the capacity charges?
I don't. You probably should ask Mr. Martinez that question. I don't know what the number is, but generally the portfolio optimization models, that's what they're designed to do. Is you basically plug in different resources, and you look at the capacity value and the energy value, and to determine which mix of resources is going to provide the overall lowest system cost for the benefit of the customer. So it's a combination generally of energy savings and capacity value.
I'm sorry, so it's generally a combination.
Of energy savings and capacity value.
And do you understand, Mr. Oliver, that Epe'S is describing this as the first case in which they're systematically procuring capacity as well as renewable energy specifically for the New Mexico jurisdiction?
Yes, I guess in the past, as my understanding has been, they procured resources for capacity and energy in the past, but I guess it was part of the entire system as opposed to this.
I'm sorry, part of the entire system.
As opposed to the New Mexico portion separately.
So the Plexus modeling that was done to choose select choices in this RFP, did that look at the entire system, or did that somehow do an evaluation of the benefits specifically to the New Mexico jurisdiction?
I believe Mr. Martinez answered that yesterday, as I recall. And I thought he, ask him again on that, but I'd
like your opinion, because I know that you reviewed the modeling.
Right. I believe it was on the New Mexico system separately.
Okay. And would that make a difference? If it was not done on the New Mexico system separately? Well, tell me how it would be done in the New Mexico system separately. What differences would you see in your results if it were done on the New Mexico system only, as opposed to EPE wide?
I don't know what the results would be. I'm not sure. I can't even speculate on that.
And when we go, we go into your
again, I think that's a question for Mr. Martinez, because you're getting into the individual, nuts and bolts of the EP system and the resources and the, and the costs and that type of thing. I'm not, that up to speed on exactly what those are.
Well, Mr. Oliver, I think part of your role here is as the independent evaluator is to sort of, review and bless the results of the evaluation process. Is that, I don't want to sound cynical, but is that kind of what you do?
Yes, that's what I did. If you read my report, I go through that in detail about what we did. The question you asked me was whether or not I can tell whether or not, what the costs were and the benefits were, or whatever the case is, different system versus one system. I don't know that. I don't know if, I'm not, I didn't run the model. I didn't, as part of the EP team, I reviewed the model and reviewed the results. That's my role.
So you reviewed the results without knowing what they were evaluating? I guess, how can you review the results without knowing what the inputs are and what the objective is.
Well, there's a lot of data that goes into the models that you know, for the individual resources and the loads and that type of thing. And, you know, in this model, the Plexos model is a very, very complex model. I've been involved as IE on several solicitations that have used Plexos. So I'm familiar with how the Plexos model works and the type of inputs. And that's how I review. You know, does it make sense? Does it, you know, is it rational, the results that come out of it? And I ask a lot of questions of the utilities to make sure that the evaluation results are consistent. What I don't do is I don't go in and toggle the switches and change the numbers. That's not my role. So, you know, that I didn't do. That's why I don't know all the data that's in that model from EPE's perspective.
Worked with it. You said you've worked with companies who've used the Plexos model before. Were any of those companies multi-jurisdictional ones that had sort of two different sets of ratepayers to address or, you know, take care of?
Well, one of the utilities we've worked on is IE through the Utah. We worked for the Utah Commission as IE on the Pacific Corp case, and so Pacific Corp is one that I worked with on that. And my understanding that Pacific Corp has different utility systems, but they evaluate the bids on a integrated system.
Do you think that's what happened here?
My understanding is that and I don't know, I can't get into the reasons why it's separate or not, but I don't know what the justification is or why it's, you know, I know there's 2 RFPs and the RFPs were evaluated separately. The bids were evaluated separately.
And you're the IE for the Texas, sort of simultaneous Texas RFP, is that right?
Well, it wasn't simultaneous. It actually started, you know, 4 months after
I thought it was a little closer.
after the New Mexico.
And if we could, without necessarily turning to, because I think you're probably familiar with this, in your IE report, you talk about the EDF proposal and the fact that was bid into Texas and New Mexico and had been selected. Is it correct that you testify that it had been, by the time the best and final offers, the belated round of best and final offers in New Mexico were going on, with the EDF offer had already been selected in Texas for negotiations? Is that your testimony?
It had been selected for the, in Texas, yes, to begin negotiations.
And is it your testimony also that despite that, it was evaluated in the best and final round in New Mexico?
Yes, it was.
And when these Plexos models were run, having been selected initially in Texas and then being run through as a possibility in New Mexico, did the modeling treat that as a Texas resource that would be there in the future, or did it double up? Would the model have doubled up on it because if it was a system-wide modeling process?
No, I believe that the model wouldn't double up on that resource. It evaluated the EDF, the resource for, relative to Kane and the other shortlisted.
I'm sorry, relative to
Kane.
Oh, Carney.
Yeah, and the other shortlisted resources.
And the other which resources?
Shortlisted resources.
More generally, Mr. Oliver, for the modeling, the way it was modeled, did the model assume future additions for Texas? Because this goes to the problem that the two RFPs going on simultaneously. Did the modeling for New Mexico, modeling under this RFP, here I go again. Did it assume future additions in Texas?
I don't recall. You should ask Mr. Martinez those questions on the specifics of the model.
Let me see. Now you made a correction to your testimony about the April 22nd date for Desri's alternative proposal. If you go to your own report, it's easiest to make math really worse. The border on the report kills the numbers, kills the base stamp numbers. So I'm going to look for, I think the easiest way to do this is to look for footnote 23.
Okay.
Because that is, and
I have that.
got it. So I'm on page 83 of 93 of the PDF, right?
Right. Yep.
So here you have information about the change in ownership of Gale had informing EP that Desri had completed acquisition of the
I'm
Carney.
sorry, so you have information about the change in ownership of,
That Gale had informed El Paso Electric that Desri had completed an acquisition of the Carney project.
Right.
What level of involvement did you have in communicate at that point in time after the first round of selections were made? What personal involvement did you have in communications between the bidders and El Paso Electric?
Well, I would be copied on the emails from El Paso Electric would forward those to me, and that's how I knew about the letter from Galehead. Galehead and Desri were partners on this project initially.
And were you copied on? And then you talk about the April 22nd communication. And were you here yet? Were you watching yesterday?
Yes, it was.
So you saw that April 22nd communication is in the record. Are you familiar with Mr. Martinez's testimony that April 11th, Desri indicated that they wanted to discuss market challenges? I'm just wondering, did you have an April 11th communication as well, or were you only getting some of the communications between the parties?
I didn't have April 11th. That's why I initially had April 11th in my my rebuttal testimony, because I had in my mind that it was April 11th. But then when I went back and looked at my report on page, on the next page, I had April 22nd when EP contacted.
Mhm.
So that's why I changed. That's why that was consistent with my report.
So is it your understanding that there was or was not some sort of April 11th preliminary contact between Desri and El Paso Electric?
I wasn't sure of the date, but the negotiations had already started, but we weren't involved at all in the negotiation process.
Oh, okay. That I didn't understand that. I appreciate your saying that. So then going back to your report, which we now have in front of us, at least I do. So on April 22nd, that was the first time. It says EPE contacted Merrimack Energy to inform the IE that Desri had proposed to revise their proposal. So that was the first. Was that the first communication, direct request for your help after the bids were selected in February?
Well, we had some discussions, I think, before then, if I recall. it wasn't, things didn't go silent for that period of time.
I'm sorry, things didn't go south?
Silent.
Oh,
I did review the notification letters to the bidders. And I did review the Plexos runs during that period. But any negotiations with the bidders, I wasn't involved in. And it may have been that the 11th, I remember the date of the 11th sticking in my mind, but I wasn't sure. I was thinking that the 11th was when Desiree provided the document to EPE.
You just said that negotiations with the bidders, were they just to your knowledge, was EPE just negotiating with Desiree or Galehead at that period from, during March to April?
I believe they were, yes.
Now on the bottom of the paragraph there on page 84 of 93, the paragraph that it starts with April 22nd. If you go the short paragraph after that, that says, as a result, the bidder proposed to increase the PPA energy price from the original price of $19.29 per megawatt hour to $29.96 per megawatt hour, etc. Yep. Does this refer to the April 22nd communication?
No, that should be I believe the best and final offer, I believe. I know that was the best and final offer, as I recall, but I think that's what that was referring to.
So how did you react to the fact that on April 22nd, EPE, you received on April 22nd, you received a copy of the presentation or not?
Yes, I believe I received a copy that day.
The full document that we have the one page in the record from.
Right.
I have been, and you agree that the prices both for energy and capacity for the battery storage were lower in that April 22nd communication than they were in the final best and final. Is that right? Right,
but it was, that was just I think an indicative number that was put together because they were describing which components were increasing. So I didn't look at that as the final offer or another offer. I think it was indicative more than anything.
Once the PPAs, here we go again. I'm going to say this out: best and final offers as opposed to BAFOs, because we've got enough acronym. Once the best and final offers were in, did you have anything to do with the negotiation of the final contract with Desiree?
No. I wasn't involved in negotiations at all.
Okay. That's probably it. Oh, here. Let's go to your rebuttal testimony, please.
Okay. Okay.
Yeah, let me find this. Oh, I'm too far down this one. Well, I'm sorry, I've lost my place in here. Yeah, okay, I'm on page 9 of 82 or page 7 of your rebuttal testimony. 9 in the date stamp.
Okay. Okay, yes, I have. That.
And you criticize city witness Lisa LaRock on the grounds that you believe she was suggesting that the only way to do this correctly was to do two separate RFPs. Is that your position?
Yes, that's my understanding of what Ms. LaRock testified to on a couple of occasions in her testimony.
And
I'm sorry, I didn't hear the very last thing you said.
On a couple of occasions in her testimony.
Did you note in her testimony the concern that a combined procurement of this size and nature should be treated as the company had done in case 19-00348 UT and sought approval under Commission Rule 551? Did you pick up on that portion of her testimony?
No, I don't, I don't have the background, I guess, in the rules and the specifics of those. So I was more focused on what she mentioned and, in her testimony about the two separate RFPs. That's what I was focused on.
So you were focusing on the RFPs, not the regulatory approval process. Is that fair to say?
That's correct, yes.
I think. Oh, yeah. And now you're rebuttal about Mr. Reyes. And this begins on page 15 of your rebuttal, page 17 of 82.
Page 17.
Right.
Okay.
And moving on to page, and here you discuss his comparisons to the P&M bids that were rejected, right?
Right.
You do not mention the P&M bid that was accepted, is that right? Just the ones that were rejected by P&M?
Right, because he cited these three resources as benchmarks.
I'm sorry, I need your answer again.
He cited these three resources, or these two resources and three options as his benchmark assessment.
And on page 18 of your testimony, 20 of the Bates, you're questioning Mr. Reyes's testimony on the grounds that it's on line 7, that he only compared initial year prices and has not conducted a net present value calculation over the contract term. First of all, did EPE or you yourself through EPE ask the city whether Mr. Reyes had conducted such an evaluation?
No, because he wasn't part of his testimony. So I mean, he specifically mentioned, he identified or made his comparison using the initial year prices, and that was all. He didn't even reference the escalation rates.
So you assumed that he had not done any sort of year over net present value or consideration of the future increases?
I didn't see it. I didn't see anything as part of his testimony as an exhibit or anything. So I assumed he hadn't done it.
Now what now you are citing those same prices, and you've actually got the P&M report in your testimony. Did you perform a net present value calculation?
No, not directly, but I did review his analysis in those bids, and found that all the projects he was talking about, and concluded that he, not only was he using the initial year prices without the escalation, but he was also comparing apples and oranges, because when you evaluate storage and storage and solar, there's a number of factors that are going to drive the pricing, and including the duration of the storage, and the the escalation rates, and also the amount of storage relative to the solar capacity. So, he's mixing and matching things here that you can't really compare on a levelized cost basis.
Would you please turn to page 64 of 82? I'm not sure why it says 82 and it's 83 on the top. This is the P&M summary of the bids.
Okay. Equal. Okay.
And the top one, the Trisco Solar, that was
I'm sorry, please repeat your question. I'm sorry, I missed it.
the top item on that chart, Trisco Storage, Trisco Solar. That is the one project that P&M accepted and went forward with. Is that right?
That's my understanding. Yes.
And that one does not have escalators in the prices, correct?
That's correct.
And the prices that P&M, well, let's start with the original prices. The $668 per kilowatt month. That's very similar to the original Carne bid.
I'm sorry, to the original.
Carne bid.
As I recall, it was fairly close. The capacities component.
And the original Trisco bid of $19.13 per megawatt hour, is that also quite close to the original Carne bid?
As I recall, it was fairly close. Yes.
And do you see that the price increase percentages there that were bid to P&M were 26.5% and 23.5%?
Yes.
And do you agree that the increases of the Carne bids were in the neighborhood of 56%?
I don't remember the exact percent, but they were higher. I mean, this is a very good project. This is the Trisco project is is one of the lower cost projects I've seen. And we do a lot of, you asked before about whether I did my own, a separate study, but one of the things we have done is we were involved in solicitations throughout the United States, and we have been since, number of years, but during the period from 2021 to now, we've been involved in a lot of different areas of the country, and this project is very competitive. I mean, I think what I've seen is the pricing in New Mexico has been attractive. I think the Cane project is attractive relative to what I've seen other parts of the country as well.
Ms. Stevens, I just wanted to note that we've actually reached the end of your time. If you want to wrap it up, you can have a couple of minutes.
I think I have just one question here. So I'm just moving on to the ones that were rejected by P&M on the same chart. Let's go with the lowest cost one, the Hickory energy storage option A. No, it's option B. And that was at $840. The new price is $848 per kilowatt month. Is that right? You see that?
Well, that's the original price. That's the first year price, escalating by 2.5% a year.
Right. And I'm just wondering, can you just eyeball how many years how many years it would take at a 2.5 escalation rate to get to 1099, which is the Carne price?
No, I
Which
can't.
is the what? I'm sorry, which is the what?
The Carne price.
No, I don't know how many years it would take. I do want to point out though, that when I talked about the comparison of projects on an equal basis, if you look at the Hickory projects, it's 150 megawatt solar and a 40 megawatt battery versus Connie, which is 130 megawatt solar and a 65 megawatt battery. This is basically a little over 25% of the size of the solar project, whereas for Connie, the battery is 50% the size. So there's more, it's a different project. They're not the same projects. And that's why I'm saying you're comparing apples and oranges to here. And it makes it really challenging to say, this one's better than that one. If I was looking at these and I was selecting between this project and Connie, I probably would take one of each, for the short list because they're different. And that's just and then you run it through the Plexos model to determine which one's going to provide the best value to the system, in terms of the lowest system reasonable costs. And that's how you determine which projects are the best for the customers, not through this analysis, not through the LCOE analysis. It's not effective unless it's apples to apples.
Madam Hearing Examiner, may I ask one question more? I know I'm over my time, but I think this is a useful one to the commission. It's very general, but it's a novel question that I didn't get in.
Yes, go ahead.
Yeah. So I on your comparison of projects, you talk about the level 10 figures.
Yes.
I have to find page 21 of 82.
Okay.
I'm just, we've not seen level 10 before. I mean, Lazard's all the time, right? But level 10, what can you tell us about, what can you tell us, the commission, about what level 10 measures and how your familiarity with level 10, why this would be reliable? And I'll start with a very simple question as to whether these are bid price, when you call them index prices, are they index prices for bids or are they index prices for selected contracts?
Well, it's my understanding, and if you look at the level 10 descriptions, what they do is they have clients that are involved in contracts. And some of those clients are utilities. I think some are, companies like Amazon or, Google that are doing contracts for these projects. And they put together a database of those contracts every quarter. And they come up with these indices for solar and for wind costs. And they do it, and in some cases, if you buy the full, you can get the executive summaries online for free. But the full-blown assessment of all the ISOs and that type of thing would cost quite a bit of money. So we just get the executive summaries, and when we do benchmarks, we would look at these benchmarks and compare against what we know from our involvement in the market as an IE, and they've been pretty close with what we've been seeing in the marketplace. And in fact, the Q4 2022 index came out today, and if you added that number in, it'd be 4566. So you can see that solar prices keep going up; they're not going down. They're continuing to escalate based on their latest cost information, which actually verifies some of what we're seeing when we look at capital costs of solar projects that are being submitted in utility solicitations as build own transfer agreements or those types of things. So this matches what we're seeing, and that's why I feel kind of comfortable using it, because it's the trends are pretty consistent and the magnitude.
So that's why I feel comfortable.
Because the trends are consistent and the magnitude is matching fairly closely.
So you mentioned
So I think we're done. Thank you, Ms. Stevens. That
Okay,
was the
thank
last
you.
question. At this point, we can turn, I think I saw, and I want to apologize, Mr. Elliott. I thought that everyone was in the Zoom when we discussed changing the time to 9 a.m. today. So my apologies that you didn't get that information. Would you like to cross-examine Mr. Oliver? Mr. Elliott? Well, perhaps Mr. Elliott is not currently in the room. So,
Sorry, my
Oh.
my apologies. I have no questions, Madam Hearing Examiner. Thank you.
okay, thank you very much. Next, we have Ms. Souls. Are you going to have, can you give us an estimate of how long you might spend with Mr. Oliver?
Madam Hearing Examiner, I have no questions for Mr. Oliver. Ms. Stevens covered the questions I was prepared to ask.
Okay, thank you, Ms. Souls. Mr. Downs. I
I have no
Mr.
questions, Madam Hearing Examiner.
Thank you, Mr. Downs. Mr. Herman, Doña Ana County.
Yes, I have a couple of questions. Thank you. Good morning, Mr. Oliver. My name is Keith Herman. I'm outside counsel for Doña Ana County. How are you doing today?
Good morning, Mr. Hearn. How are you?
I'm doing well. Thank you for asking. Excuse me. What materials did you review for in preparation of your direct and rebuttal testimonies?
Well, for my rebuttal, I read the testimony of all the witnesses, and then for direct, it was more of focus on what our scope of work was and the role we provided and my conclusions from the report that I included in the testimony. And in preparation of that, obviously, we've been involved in the RFP, so I reviewed all the bids. I reviewed the comments, provided comments on the RFP documents and the questions and answers. Just I don't know what else I can say.
Oh no, I'm just. I was just curious. In your role as an independent evaluator, have you only been contracted by the utilities?
No, it varies. Like we're like for Pacific Corp. I work for I've been contracted by the Utah Commission. In California, we worked for all three utilities in California, and we were selected by the utility, but with the approval of the Energy Division. So the Energy Division has to approve us, and then we were on basically we were part of a group of IEs for each utility. It's like three IEs for each utility, and for every assignment, the utility will select one of the IEs, and then it has to be it's subject to approval of the Energy Division. And same thing in Arizona, we were selected by the commission as one of several IEs for both utilities. Although I've only worked for Epe'S. So
in those processes, the utilities don't necessarily have the ability to choose you directly. Sometimes it's done with the approval, sometimes it's off of a short list.
And sometimes it is directly by the utility. Yeah, sometimes it is. We would do work on Entergy solicitations, and we were selected by Entergy. And every state that they're involved in is different. So we have to, like in Louisiana, we have to be approved by the commission in Louisiana.
Mm-hmm. During one of your responses to Ms. Stevens, you mentioned that you asked a lot of questions to EPE during your review. What sort of questions would you ask EPE?
Well, usually what we do is we put together an issues list to start the process. And, that would really include, the evaluation process and methodology, um, the ELCC analysis, that type of thing. We get into that.
ELCC?
The effective load carrying capability.
Uh-huh.
That was done. The forecasts, the inputs, I mean, not sorry, the inputs of the forecast of key variables. We generally, go through that information. Transmission issues are always, major considerations in the evaluation. So we talk about that. One of the things I'm always very sensitive to is the relationship in any of these solicitations between the utility-owned project and PPA. So we always ask for the models that the utilities would use to do that analysis to make sure that all costs are appropriately accounted for. Because if that doesn't happen, then utility projects could be successful relative to a PPA that has to absorb all those costs. So we get into all a lot of those issues. Another area we focused on was what are the basically the safeguards that EPE was putting in place, given that the self-builds can bid in the process.
I'm sorry, what can bid in the process?
Self-build projects, they'll be owned by EPE, so that there's basically fences in place or walls in place to prevent any sharing of information. We get involved in that quite a bit. The confidentiality agreements are in place and that type of thing. What we haven't been involved in with EPE, as I mentioned, we do with other utilities, is get involved in the contract negotiation process. So some of the other utilities we do, and some we don't. California requires that we monitor the negotiations. So we get involved in reviewing the contracts and asking questions on contract provisions and that type of thing relative to industry standards. So a lot of what we do is really focus on what the utility is proposing versus industry standards on some of these issues, and raise questions about that.
Okay, thank you for that. Is EPE the only New Mexico company you've worked for?
Yes.
So you haven't provided any other testimony in any other cases before the New Mexico Public Regulation Commission?
No, I haven't.
Well, thank you for that. That's all I had.
Thank you.
All right, thank you, Mr. Herman. Ms. Regensburg?
Good morning. No, the staff does not have any questions, Madam Hearing Examiner. Thank you.
All right, thank you very much. I do have one or two questions for you, Mr. Oliver.
Okay.
Could you tell me where the Plexos process comes from?
The modeling, who owns the model, or I think it's the company called Exemplar. Right? It's Exemplar, I believe it is. But the Plexos model is interesting because it's basically become a standard in the industry. It's within the past few years. It's been used widely in utilities in Europe and in Australia and in other areas. But we're seeing now that it's really taking over the U.S. market. And one of the major reasons is that Plexos is one of the few models that has been effective in evaluating storage resources. When we did work on the Pacific Corp, the 2020 RFP, and they were using a different model at the time, and they had to use an Epe'S model in conjunction with that model to evaluate storage, and created some issues in terms of the effectiveness of the evaluation. Then they are now using Plexos for their 2022 RFP, which we're the independent evaluator on as well. And they're using Plexos because now that when bidders submit a profile for storage, Plexos will basically run that profile and select the value and select how that project would be dispatched to determine the value of that resource. So it really is, it's a very complex model, but it's now becoming very popular in the industry.
So when were all of the bids that were received by EPE input into the Plexos model, or was there some cutoff or some discrimination in determining which bids would be sub input?
No, not all the bids. With an all source solicitation, a common process is that, you do your screens initially. So if you like, we've had some processes, even like the 2017 EP solicitation had 500 and something bids. So you couldn't run all those through Plexos. It would take a long time. So what we generally do is, or what the utilities generally do is, they'll basically, when the bids come in, they'll put them in categories or buckets. So the solar bids will compete against the solar bids, the wind bids against the wind bids. Where the problem comes in at storage, like I mentioned, storage is a little bit more of a challenge. Storage and solar plus storage is a little bit more of a challenge. But what you try to do is select the best bids in each of those categories, and then input those into Plexos to do the evaluation. And that's what happened for EPE solicitation. When the bids came in, they were initially run through the spreadsheet model that they looked at the LCOE calculations, and the best bids were then selected. And there was a robust short list. There was a large number of bids in the short list, half of the bids basically, and then it included solar, included wind plus storage, solar plus storage, standalone storage, demand response. There were a number of different options, and all those were run through Plexos once the short list was selected.
And who made the cut, kind of, as far as which bids were going to go through the Plexos evaluation?
Well, EPE in conjunction with reviewing it with us, and we had some questions and comments about some of the bids, and who should be on and who shouldn't be on, that type of thing. Where were the cutoff points? Like when you get to the break points, when you look at okay, so this bidder is has a 20% price advantage over the next best one. That might be a good break point. You might select any bids that are better than that bid to put on the list. So it's
when you're saying better, can you tell me what you mean?
A lower LCOE value and a more viable project. So we generally look at these projects not only from the perspective of the LCOEs, but you also look at them from the viability of the project. Do they have site control? Do they have an interconnection agreement in place? Are they financially viable? Do they have equipment lined up? Like one of the things with looking at the bids that EPE had, we thought the Kane project and EDF had very viable projects. They were pretty far along in the process relative to some of the other bids. So that had an impact in terms of the selection of the resources as well.
And are those the viability? Those are criteria that are outside of the Plexos process, or are those also evaluated by the Plexos process?
No, that's outside the Plexos process.
And that would, you said that would include maybe what credit, stability, credit values, or
right, financial capability. If a company has a credit rating, that would be included. NEP also adds into transmission costs onto the pricing as well. They do that analysis internally.
and then does Plexos come out with like a number? Is that what the end result is? And then you just get a list and each one has a different number?
Yeah, and the number that comes out is the the present value of total system costs. So then you can compare, that, what is the system cost with this project in versus another project in or a portfolio of projects in, and which, so you're looking for that, that portfolio that has the lowest system costs ideally. And, that project, if that's a viable combination of projects, then you're likely to make that selection. That portfolio will be the portfolio selected. But that's, and you're looking at it from the perspective of the customer cost, because it's total system cost, which would be, reflected in customer rates. It's really an optimization model. I guess that's the other point that maybe I didn't raise. It optimizes the whole system. How does is talking about Ms. Stevens. It could be that you have all the renewable energy coming into the mix, and what that generally would do, it could displace higher gas costs, for example, and as opposed to or the gas projects might run less if they're inefficient, and there's cost savings attributed to that. Some of the utilities we work with have very old fleet of resources, and the renewable projects that they're procuring is really having a substantial benefit to their their system energy costs, basically their overall system energy costs.
And when you received the increased prices from for the Carne project, was the Plexus model rerun or not?
No, it was. Yes, once the best and final prices came in, all the best and final bids were rerun, and the Carne project was selected again. So it was selected twice, basically. It was the top shortlisted project, and then the best project.
I'm sorry, I didn't hear the last thing you said. The top.
The top project, it was a top project selected for the short list, and then there was also the top project selected for the best and final process.
And so how many, or I guess then there were several bids that were rerun in the best and final?
Yeah, if I have a minute, I can just check the report. We had the numbers in the report, I think.
Oh, okay, thank you.
I believe it was 9 bids. Let's see. Yeah, 9 bids submitted best and final offers. And one
that
bid,
was in your direct testimony, then exhibit 5. Correct?
Is it 5?
Your direct testimony is exhibit EPE exhibit 5.
Oh, right. That's exhibit 1. So this would be let me see. I'm sorry. It would be WJO-4, exhibit 4 to my direct testimony would be our report. And it goes through the whole process from start to finish in terms of what decisions were made, and and how it all evolved, and numbers of bidders and that type of thing.
And I think my last question, is the cost or the Plexos for using the Plexos model wrapped into the overall cost of the project that then went through the process of identifying what the total cost would be under the rate rider?
Well,
Which may not be a question for you, actually. But.
Right. I was going to say, I'm not sure I can answer that one. I don't know.
All right. I don't have any more questions. Thank you very much, Mr. Oliver.
Thank you.
And so I'll turn that back to you, Mr. Wexler, for any redirect.
Yeah, 3 short areas for redirect. First, Mr. Oliver, picking up right where you left off with the hearing examiner, can you look please at EPE Exhibit 5, and I'm looking at your final report, which is WJO-4. And I just want to point out the parts that are relevant to the hearing examiner's questions. So if you look with me first at what looks to be page 701 of Exhibit 5, and right in the middle of the
I'm not sure. I don't have that yet. Let me just see if I can.
Okay, it's your final report. So it's WJO-4, and the bait stamp number is 701. And right in the middle of the page, or towards the bottom of the page, there's a heading, Evaluation of Proposals.
Okay, that's okay. I have that. Yes.
And so here you were talking with the hearing examiner about the process of shortlisting, evaluating those proposals, and then the Plexos modeling. And if you turn the page to page 702, does this describe that process that you were just discussing with the hearing examiner?
The Plexos modeling process?
The
whole
evaluation proposals, the shortlist selection, and the Plexos modeling.
Oh, yes, it does. That's yes.
And if you turn a couple of pages, Mr. Oliver, then to what at the bottom of the page looks like is 705. And really there's just a heading there that says best and final offers. And you turn to page 706, you can see the description of how those best and final offers were done, the 9 bidders that you identified, and then under the heading updated Plexos runs. And that describes the way the best and final offers were evaluated using the Plexos modeling. Is that correct?
That's correct. Yes.
All right. Second line, brief line of question that I have for you, Mr. Oliver. That you were asked by Mr. Herman a question about.
May I object? I don't want to interpose an objection, but before you move on to the next topic, Mr. Wexler, the page numbers you were giving, 701 is the cover page of his direct testimony. So I think all those numbers were wrong. Unless there are two bait stamps versions floating around. And I understand it's really hard to see through the blue line, the dark blue border, but I just want the record not to be erroneous. But do you see what I'm saying?
Well, I do.
First page.
Yeah, I do see what you're saying. And yeah, I thought it was 701, but let's get the record correct. And I appreciate you raising that.
It's hard to tell. I don't know.
Okay. Well, can I ask this? Are we on what's identified at least by Adobe Acrobat numbering as page 81 of 93 for page 701? Because it looks to me like it's 701 for page 81 of 93 on the Acrobat menu line.
I believe that's right, Madam Hearing Examiner, and it says it has 2 headings on it. The first is extension of shortlist selection, and the second is evaluation of proposal.
Great. So I think the numbering is, I believe that's page 701 as far as I can tell.
I'm looking at Madam Harrington. I'm looking at the last page before that report, the end of WJO3, and that says page 754 of 821. I don't know whether these are like in the 880s. What would look like?
Well, I don't want to. I mean, I understand
Yeah,
what page we're on and what we're discussing, and it's consistent with those headings. You know, whether there's an overall problem with the Bates numbering is not really something I want to spend a lot of time discussing. I mean, we're definitely in Mr. Oliver's direct testimony, exhibit 5, and we're in exhibit WJO4.
That's correct, Madam Hearing Examiner, and I believe that you have correctly identified the parts of that final report. And so, with your permission, I'll move on to the next line of questions.
Thank you.
So very briefly, Mr. Oliver, my next question for you was when you were asked by Mr. Herman about your participation in other cases in New Mexico, I thought you had indicated that you had not testified before the commission before. And just to clarify, you have not testified for any utilities other than El Paso Electric. Is that right?
Oh, that's correct. That's what I interpreted the question to be. So I made a
Right.
mistake.
Now
Sorry.
you have actually testified before the New Mexico Public Regulation Commission on behalf of El Paso Electric in other cases.
Yes, I have.
And then just overall, you're asked a number of questions about the overall process. Now, based on your review, questions you were given today, what you heard yesterday, do you stand by your determination that the solicitation process and assessment was fair, consistent, comprehensive, and unbiased?
Yes, I do.
No further questions.
Okay, is there any recross based on the redirect? And I would start with the Office of the Attorney General.
No, thank you, Madam Hearing Examiner.
Thank you, Mr. Elliott. City of Las Cruces.
None for me. Thank you, Madam Hearing Examiner.
Thank you. Ms. Souls,
No, thank you.
Mr. Downs,
No, thank you.
Tonya Ana County.
No, thank you, Madam Examiner.
Finally, staff, Ms. Regensburg.
No, no, thank you, Madam Hearing Examiner.
Well, then I think that we're at a good point to take a break. According to my laptop, it's 10:42. So we will recommence in 8 minutes, wherever that is on your own clock, but it'll be 8 minutes from now, 10:50 on my laptop time.
Madam Examiner, do you have any estimate on when we're going to take our lunch break today?
I don't know if Ms. Gonzalez has any preferences. I would defer to her. I would say probably around 12:15 to 1 o'clock. If that works for everyone.
Yes, thank you.
All right, thank you, everyone. I will see you in about 8 minutes. All right, we are going to go back on the record in 22-00093 UT. We just finished with EPE witness Wayne Oliver and Mr. Wexler. Can you identify the next witness that EPE is presenting, or Miss Olson?
Madam Hearing Examiner, yes, I'll be presenting this witness. The next witness we call is Mr. Rene Gonzalez.
All right. Ms. Gonzalez, can you swear in Mr. Gonzalez?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Go ahead, Ms. Olson.
Good morning, Mr. Gonzalez. Can you please state and spell your name for the record?
Good morning. My name is Rene Gonzalez. That's RENEGONZALEZ.
And Mr. Gonzalez, what is your current profession?
I'm a supervisor in the Rates and Regulatory Department.
I've got too many binders here. Do you have before you your pre-filed direct and rebuttal testimony, which have been marked as EPE exhibits number 7 and 8?
Yes, I do.
And let's start with your direct testimony. Was that direct testimony drafted by you or under your direct supervision?
Yes, it was.
And do you have any corrections to that direct testimony?
I do not.
And is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
It is, with one point that I hope to address during this hearing.
Okay. And is that a change in position that you identified in your rebuttal testimony?
Indirectly. It's an oversight on my part on an exhibit.
Okay. If you were asked the same questions in your testimony, would you give the same answers under oath?
I would.
And turning to your rebuttal testimony, was that rebuttal testimony drafted by you or under your supervision?
It was.
And do you have any corrections to your rebuttal testimony?
I do.
And can you please walk us through those corrections?
Yes. On page 9, line 19, it previously read large cap and the cap. I've simply added a comma after large cap. On page 10, line 19, there was an additional period and space after approved tariff, and I've corrected for that.
Okay.
On page 12, line 13, I've replaced the year 2023 with the word cumulative.
Okay.
On page 13, line 17, the reference that says RFG-1R is simply changed to RFG-1.
Okay.
On page 14, at line 2, I've added a $sign to the $23,404 reference.
Okay.
At page 15, line 11, I've added a space between the initial two words of the question, do you,
Okay,
page 16, line 5, 4 and 5. It said next rendering, and I've changed that to say next filing, rendering.
okay,
Finally, at line 11, it said order, comma, applicable rules, and I changed that to say order and applicable rules.
okay. Thank you, Mr. Gonzalez. I'll also note that there were some issues with the footers on the exhibit RFG 1R, 2R, and affirmation. They were all identified as rebuttal testimony, so I struck that and corrected it to identify the exhibit. So you'll see that on the exhibit that's entered into the record.
Thank you.
Thank you, Mr. Gonzalez. With those corrections, is your rebuttal testimony true and accurate to the best of your knowledge and belief?
Yes,
And if you were asked those same questions today under oath, would your answers be the same?
yes,
And Madam Hearing Examiner, I understand these exhibits have already been entered in the record, so we tender Mr. Gonzalez for cross-examination.
Okay. And just for future reference, really these kind of minor grammatical corrections really do not need to be made at this point. I don't think it's necessarily a productive use of anyone's time.
Okay.
But at this time, we'll turn to the Office of the Attorney General. Do you have any questions, Mr. Elliott, for Mr. Gonzalez?
Thank you, Madam Hearing Examiner. No, we do not have any questions. Thank you.
Okay. City of Las Cruces, Ms. Stevens.
Yes, I do. Thank you, Madam Hearing Examiner. Good morning, Mr. Gonzalez. I'm Anastasia Stevens for the City of Las Cruces. And I didn't mean to do this, but I'm going to start with one of the questions in your rebuttal that you just changed your testimony about. Or you just made a typographical correction, but it highlighted. This is page 16 of 30.
Ms. Stevens, you're seem to be lagging a little bit.
I am?
There's something going on. I'm
Really, because I'm not having that problem. I don't know whether
I can hear you.
Maybe it's your problem, Madam Hearing Examiner.
I also have that. You cut in and out a little bit. I don't know what it is.
Oh.
Yeah.
All I guess I can do is try to talk slowly and let somebody scream at me if there's a problem.
Okay.
I'm not hearing it at all. So
all right. Why don't we go ahead? Maybe it's something.
Okay. So Mr. Gonzalez, we're at page 16 of 30 in your rebuttal testimony. It's that last sentence on where you made the change on lines 4 to 5. Finally, it is anticipated that the rate rider methodology will be changed in the next filing, rendering such an argument unnecessary, as it also indicates. Is this a reference to the rulemaking that was going on at the time that you filed your testimony?
It is.
And are you aware of the final version of the rule that was issued? Oh dear. I believe it was 2 Wednesdays ago, a week ago. Are you aware of some changes in the final rule that related to the rate rider phase out provisions?
I understand some changes were made, yes.
So is your testimony still, given those changes, is your testimony still that the company anticipates the rate rider methodology will be changed next year.
Anticipates the what methodology?
The rate rider methodology will be changed next year.
Not necessarily that it'll be changed, but it'll certainly be addressed. That's my understanding.
Okay. And also in your direct testimony, there's some discussion of the DG rec issue.
Yes, ma'am.
And were you here for yesterday's testimony?
I was, yes.
Is your testimony in your direct testimony about DG Rex, does that still reflect El Paso Electric's position?
Is there a particular line and page number?
Just in general, the way you approached it.
Madam Examiner, I'm objecting to the question as vague.
Can you be a little more specific, Ms.
Yeah, if I
Stevens?
can.
Go ahead and identify, if you can, where in Mr. Gonzalez's testimony you're referring.
Yeah, well, the section of your testimony starts at page 15 of your direct, page 810 of 821, Bates stamped.
I'm there.
And moving on to the next page. Lines 6 through 7. Based on your knowledge of the amended Rule 572 and the testimony of Epe'S other witnesses yesterday, are you testifying that DG Rex will be continued to be recorded and retired for RPS compliance purposes?
Yes.
And are you changing the number of DG Rex that will continue to be retired for purposes? And then here we are at moving on to page 812. There's a question of that on lines 12 through 15 that quantifies the Rex.
Yes, I'm restating the amount of RECs that are anticipated for the 2023 rate year, as well as the 2024, which is just an illustrative number.
Okay, what I need to know. Now let's go start with your direct. Start at the beginning. Well, actually it's page 8 of your direct. Oh,
I'm sorry, it's page what?
Page 803.
Thank you. I'm ready.
Okay, I'm not. I'd like to talk to you about the rate rider, the actual cost of the rate rider.
Yes, ma'am.
And mostly, I'd like to, keep a finger, so we're looking, mainly let's turn to RFG4. I think we can just look at that rather than look at the testimony. I'd like to talk to you about the impact on customers. RFG4 that's the bill comparison document, right? Or bill impact statement.
Is that page 818 of 821?
It is. And this exhibit shows that El Paso Electric is proposing to increase the RPS cost rider by 24.5% from 2022 to 2023. Is that right?
That's correct.
which will increase the annual average residential customers total bill by 1.8% in the summer months and by 1.5% in the non-summer months. Is that right?
Yes,
And that's the total bill, not the rider.
that's correct.
And this increase in rates to the customers, that's not the result of any new resource procurements, is it?
It's not, it's largely the result of the decrease associated with the return of CRLEF funds. If we look at the proposed rate versus the rate prior to that additional exclusion, the difference is actually 6.6%.
Upward.
Correct. Yes, ma'am.
And has EPA provided any projections of the RPS cost rider and its effect on residential customers' bills once the proposed Carney project is in commercial operation?
Not to my knowledge.
Do you know what the annual costs for Carney are going to be?
I do not.
Do you know what the billing, what the charges under Carney are?
I can visit Mr. Martinez's testimony if you'd like. And
Yeah, well, if you'd like, I would just ask you to do the quick calculations of what the, yeah, if you look at Mr. Martinez's testimony, I think we can do this very quickly.
I would offer that this filing is for the 2023 rate year and has the illustrative demonstration of 2024, whereas it's my understanding that Carney, at least the COD for Carney, is not until 25, and therefore my exhibits and testimony are limited to just these 2 years.
Do you believe, however, that the rate impact on customers is irrelevant?
I'm sorry, what?
Is irrelevant to this proceeding?
Well, certainly not. I believe it's a concern.
Okay. Well, then why don't we go look at Mr. Martinez's figures? And I think that, there are a lot of places we can find this, but sounds like you're familiar
I'm at his
with
direct testimony if that is where you'd like to go.
Sure.
But if you reference this to Carney in there.
I was going to suggest if you know the price, our go-to place has been his little table in the VM3 plan, but
The
you have
initial VM3. Okay.
Actually it's not going to show. I take that back. It's not going to show up. It's going to be in one of his charts that go out to 2026 would be a bet. And there've been multiple versions of those, but the energy and capacity numbers don't change. Is that right?
I believe there's a couple of adjustments that he made in his rebuttal testimony.
Okay, here's a really good, useful, it is VM, it's a VM1, his plan, his direct testimony. I'm on page 450 of 821. I think this one might do it for us.
Okay.
Yeah, I know. I don't know. How can I move at the top?
Can you please mute? Is this EPE IT support? Can you mute your microphone? Thank you. Go ahead, Miss Stevens.
So, Mr. Gonzalez, can you give us the numbers based on that chart? 29, and to figure out the cost, you would multiply the $29.96 per megawatt hour times the 398,343 megawatt hours expected. All right.
Mm-hmm.
Madam Hearing Examiner, rather than try to make Mr. Gonzalez analyze this and on the stand, which may get confusing in the record, EPE would be happy to supplement the record if that would be helpful to the commission after the hearing.
So Ms.
It's
Stevens,
very simple.
are you trying to get at what the rate rider impact might be in 2025 and going forward if the Carney project is approved? Is that where you're going with this?
Yes, ma'am. I want Mr. Gonzalez, who talks about rate impacts, to have that figure in mind so we can give some sense of the rate impact. It's a very,
Well,
all
I
you
really
do is
think this is,
multiply about 3 numbers.
I think this is speculative, and I think if you want to ask for that information, we should talk about whether or not it should be provided outside of the hearing.
It's probably already in my witness's testimony. I just wanted their witness to be confident that that was the right number.
If Ms. Stevens has a place to point Mr. Gonzalez to, he could look at the numbers she is referring to.
All I'm asking him to do, because he volunteered to do it, essentially, is to multiply the $29.96 at $29.99 times the energy, proposed energy, and the kilowatt months times the kilowatts times the months. It's and then add the 2 numbers. It's the simplest of arithmetic, and I think we've spent more time. Mr. Gonzalez probably could have done this about 10 times over in the time we've been sitting here discussing it. He did volunteer. He offered to do this because he understands that it's a very simple calculation.
I don't object to him punching numbers into a calculator and telling you what those numbers say. I object to having him create a new analysis on this stand.
Ms. Stevens, I really think that this is not for this particular proceeding. You know,
What proceed, Madam Hearing Examiner? He is here asking you to. They are here asking the commission to approve this project, to approve all the costs for 20 years, and they're not telling the commission a word about what it's going to cost customers. I think it is of extraordinary relevance.
And you have
and
that.
I would respond that we're not seeking cost recovery of the Carney through the 2023 or 2024 rider, and inclusion of those costs can be addressed at such time EPE has costs.
Well, can exclusion of the cost be approved, considered? Then that is a specious, to use the term that your witness used against my witness. That's a specious argument, because once it's decided in this case, the dollars are fixed. Unless there's a different interpretation of the Renewable Energy Act that I don't know about, this approval approves the cost in perpetuity. Everything that comes pouring out of that contract is going to end up in coming out of ratepayers' pockets. And I cannot see how that is not extraordinarily important information.
Madam Hearing Examiner, I would just respond that Ms. Stevens is correct. Actual costs are recoverable under the statute. We don't know what those actual costs are. And as you've pointed out, Ms. Stevens is having Mr. Gonzalez do a speculative calculation on the stand. And as I've previously offered, if that information would be helpful for the record, EPE can provide that as a supplement to the record through a bench request response, or however the commission would like to deal with it. But I continue to object to him trying to do that analysis on the stand.
Okay. I'll consider issuing a bench request for that information, Ms. Stevens. So why don't you go ahead and move on?
Okay. I will just ask a hypothetical question then, Mr. Gonzalez. if a 24.5% increase in the rate rider amounts to a 1.5% increase in winter bills, would a 245% increase in the rate rider produce a 15% increase in winter bills?
Would you mind repeating the question?
Yeah. So your exhibit and your testimony show that 24% increase in the rate rider, the surcharge, the rate 38, carries out to a 1.5% increase in the winter months, 1.8% increase in total bills, right?
Yes.
And I'm asking if that were multiplied by 10, a factor of 10, so that it was a 245% increase in the rate rider, would that also increase the percentage effect on bills by a factor of 10 and make that a 15% increase?
I'm objecting to this, that there's a lack of foundation in the record for this. It's asking Mr. Gonzalez to do the math on this stand. It's not clear where this is going.
All I'm asking is whether he can ratio up whether one can ratio up from his RFG4, that those numbers stay in a proportionate manner. I don't think I'm asking him to do a calculation.
I'm going to allow a question. Go ahead, Mr. Gonzalez.
In a roundabout way, yes, but not exactly as you express. And the reason for that is that RPS rider costs are included in the EU ERF. And so the EU ERF changes as well. And given when future costs are in there, you won't have a proportional or exactly proportional to this current circumstance.
The EU ERF, isn't that the efficient use of energy rate factor? And you said that what you're saying is that is a percentage of bills, right?
It is.
So if the bill goes up more, that percentage will also go up?
It depends on where the EU ERF factor is.
Well, let's assume a constant, assume whatever EU ERF factor you assumed in this RFG4, would it be proportionate or would it be disproportionate?
Relatively speaking, it would be somewhat proportionate.
Okay, thank you. So were you watching the hearing yesterday? I think you were.
Yes, ma'am.
And Mr. Martinez deferred rate-related questions to you. It's the old, you're
Sure.
you want the next letters. You just testified that you don't know the rate, you haven't calculated the rate effect of Carne on customers for purposes of the even the RPS cost rider. Can you address the methodology that other than would you agree that the company's intention and expectation, if the Carne project is approved, would be that all of the costs that it incurs for Carne under the PPA and the ESA, here we are with more acronyms, would go through the RPS cost rider directly to New Mexico customers?
If we continue to have an RPS rider at that time period, yes.
Yeah. And Mr. Martinez, the questions that Mr. Martinez deferred to you had to do with the overall rate effect. And I'm just asking you whether you have any knowledge of how EPE would offset, if and how EPE would offset those additional costs for Carney through the rate rider by changes in other aspects of its rates that it charges customers.
I believe you're inquiring about two things. One, its impact on the RPS rider, and two, its relative impact on the cost of service associated with a rate case in New Mexico.
Probably. And would there also be a third, Mr. Gonzalez, the fuel clause? Yeah. An FPPCAC?
Certainly if we're passing costs through there, yes.
So what can you speak to, as Mr. Martinez suggested, the way that the company will alter its rate collections, or will see changes in its rate collections as a result of adding Carney?
I would first address the RPS, which is my purpose here today. If you look at VM3, where we include our procurement costs for our future rider in this.
Give me a second here, because I closed that when we got past the other thing.
Sure.
VM3, you're talking about exhibit VM3, right?
Yes, ma'am. And that is a part of Mr. Martinez.
Right.
Yeah. I would anticipate that Carney costs would first of all be included here. And as you know, this exhibit is linked to how we calculate the rate were we to have a rider at that time. And so if there's an increase in cost here, it follows that you would see an increase in the rate.
And the cost of service side, would we see some sort of corresponding decrease because we're getting a lot of energy and capacity through Carney?
I'm hesitant to delve out of my own area of experience, but I believe that what will change, and I think was in part testified to by Mr. Novella, is that the allocation associated with the New Mexico jurisdiction would change. And specifically what I'm referring to is generation. It remains to be seen if it impacts transmission as well, but the allocation for generation costs in a general rate case would shift. And in this case, I believe that it's difficult to predict. It depends on, you know, when the rate case is done relative to the COD date for Carney. I mean, I couldn't tell you. It has a lot to do with the test case year that is applied during the next general rate case.
And would that apply to all generation costs? Or let me put the question differently. Given that the company is claiming that that Carney would provide 121 megawatts of effective load carrying capacity, would that reduce? Would there be a 1-for-1 reduction in the other capacity that EPE has been allocated historically from its existing resources, from the total company resources?
From the, I'm sorry, from the
Total company resources?
From what I understand about the operation, and again, I'm tiptoeing in an area that I've learned secondhand, that's really dependent upon what happens throughout the course of that test year. I mean, there could be any number of circumstances that shift the amount of needed generation, whether on a short-term or long-term basis. I think there's a lot of factors that impact that. I would hazard a guess that it's not exactly one-to-one.
What about the fuel clause?
I'm not completely familiar with how it is that we pass those costs through there, but if you're asking in the context of if we were to pass the cost through the fuel clause as opposed to through an RPS rider, the cost would obviously be proportionally larger. I couldn't say just to what degree, because that's dependent upon the amount of energy.
So basically, you can't estimate now. I mean, you're neither estimating now the added costs for Carne or the potential savings from the basic cost of service. Is that your testimony in a nutshell?
I'm not, but as our legal representative pointed out, we would be happy to provide whatever is requested to demonstrate what we can.
Let's go on to the reconciliations and adjustments. A lot of your testimony here. So if I understand correctly, well, first of all, let's go to your direct. Let me close Mr. Martinez's. Let's go to your direct testimony at pages 11 to 12, which are, I'm sorry for having this mishmash of Bates numbers, but the Bates numbers are so low on the page that it's easier to look when there's a real number. 806 to 807. Bates stamped.
I'm there, thank you.
Okay, yeah. So, your testimony seems to be stating, I'm looking specifically at the question on line 14 on page 12. You seem to be saying that the after the Supreme Court ruled on the old appeal relating to the CRLEF amounts, oh, there we go with another acronym, that you made an adjustment for 0.7 million in rec procurement costs. Is that your position?
For the time period of November 2019 through December of 2020, yes, it's approximately 0.7.
Now, if we go to your exhibit, exhibit RFG 2, which is at page 816. Oh, no, actually, I'll take you to Mr. Provencio's CLC exhibit 3, please. And it's exhibit JFP1.
I'm there.
Yeah, these are, while you're there, Mr. Gonzalez, can you affirm that these are all, each of these little blocks on this exhibit are taken from your testimonies, your exhibits in prior cases?
With the exception of the second one from the top, it was initially provided, but there was an adjustment to the stipulation. And I'm sorry, but in that case, it was a contested stipulation. So on, I believe, December the 7th of 2020, as visible in the eDocket website of the NMPRC, we filed a correction to this particular exhibit. And I don't want to call it a correction. It was an agreement.
So, and that was the $23,404
Yes,
revision?
yes. So with that exception, I would say, yes, absolutely. These are my exhibits during those time periods.
And you just said though that the 0.7 million or 700,000 was CRLEF from
November of
Just-
2019.
November 2019, got
Correct.
it,
Through December of 2020.
and what about 2021? I'm looking at the third block on this screen.
Yes, not to be left out. My direct testimony addresses that, I believe, 2 questions later. I have to go back there, but so, bear with me. And I admit I've reread this, and I think a couple of adjectives might make it a bit clearer, but nevertheless, I do include it in my testimony.
Can we agree that the total amount that is intended to be, it's in your, I believe it's in your rebuttal, page 6, of going back to page 6 of your testimony, direct, which is, I'm going to really rotate you. Going back to page 6 of your direct, which is
801.
801. Let me see where it is. It's in the rebuttal. Just look on page. Maybe it's in the rebuttal. Hold on a second. I'm looking for the figure of 1,304,900.
I'm sorry, please start all over with that number. I really messed it up.
Look, I'm looking for the number, and I think it must be in your rebuttal. $1,304,920.71. And that it must be in your rebuttal because I know my notes says. Do you agree that that is the amount that the sum of that's the amount that should be refunded to customers relating to the CRLEF before interest?
No, it's actually a bit larger.
The bit larger number, is that your number of $1,320,213?
Yes, ma'am.
And that was based on projected revenues?
No.
What-
The anticipated procurement costs are one thing, but the amount collected is entirely another. In this instance, the revenue, which reflects what you anticipate to collect and is the actual number, is slightly larger. And so therefore we're returning a slightly larger amount.
At the end of the day, Mr. Gonzalez, isn't the whole purpose of the RPS cost rider reconciliation process to match actual revenues with actual costs?
Yes, it is.
And that's kind of required by the Renewable Energy Act that says that you'll collect your reasonable costs.
Absolutely.
So why then would you not be aiming to recover the actual amounts, refund the actual, assuming that it all washes out eventually, why would you not want to be refunding the actual amounts that were booked? I guess if we look at RFG 2, or JFP 1, the column with the CRLEF cost, that's what the company was booking and not turning once the order was once the stay order took place during the Supreme Court case, that's what the company was booking as a kind of a trust account to pay over to CRLEF, right?
Well, let me state this another way. If we estimate costs to be $1, but they're 10, and I'm telling you I'm returning your 10, I mean, that's really what we're looking at here. We're returning more than the cost in acknowledgement that the final amounts that we actually billed customers is modestly higher. And that's really the only point that I tried to make.
Is your background in accounting, Mr. Gonzalez?
I've worked in accounting, but no, I don't have a degree in accounting.
Okay, I'm just curious because it sounds, I'm thinking accounting and that you would want to match every penny to the penny rather than do something that's a little high, a little low. Okay, well, I now I hear you. Okay, so do you agree that when the final reconciliation of the CRLEF cost is done, that there will be a interest element that was part of the stipulation in case 21?
I do, yes, ma'am.
0100111. Okay. And that doesn't show up in this year's calculations, does it?
It does not. The reconciliation of 2022 will occur in the 2023 plan year. So a few months from now.
A few months, very few months. That's the way we're going here. Okay, good. Let's move on to page 809 of your testimony.
Direct?
You're direct, yes.
I'm ready.
And also pages 15 to 16 of your rebuttal testimony. This is where you talk about carrying charges. Now, and I think we're talking about carrying charges generally, not the specific provision for carrying charges that was applied to the CRLEF amount. Is it the company's position that the agreement in case number, this in the stipulation in case number 2100111 UT to apply carrying charges at the commission approved customer deposit interest rate carries over into the 2023 plan for collections in 2024 and beyond? The 2023 filing, next year's filing. Actually, this year's filing. Does it carry over into this filing?
Madam Hearing Examiner, I'm going to object.
I'm going to start this over again because it's confusing. Is it the company's interpretation of the stipulation in the last REA case that the calculation of carrying cost automatically applies for the riders that we are discussing right now that'll take effect during 2023?
It applies to the 2022 year reconciliation. So the 1.37 is what is ordered by the commission and applies to 2022 because the 2023 plan year filing includes 2022. Insofar as that's true, yes, it does carry over. But would that particular 1.37 be used? And I'm not sure if you're asking this, but would that particular 1.37 apply to a future year? No, I don't believe so, unless it's ordered by the commission.
And that's, I appreciate that answer, but I think what I'm asking you is whether you're assuming that the methodology, that the agreement to apply any carrying charges carries over from the last stipulation into this case for the next rider. I'm just a little unclear about the intent of your testimony.
Madam Hearing Examiner, I think there's some confusion because there's two separate agreements regarding carrying charges. And so if Ms. Stevens could clarify which agreement she's talking about.
I think I said this earlier, that we're now talking about the general carrying charge provision, not this special one for CRLEF amounts.
Okay, is that clear to you, Mr. Gonzalez?
I believe if I might try to add some clarity here, I believe you might be referring to a question and answer that I have within my rebuttal testimony, wherein I indicate that there is precedence essentially for having used the commission ordered customer deposit as opposed to a recommendation for a return on equity or a weighted average cost of capital. Is that, are we on the same page?
Well, yeah, that is the testimony I'm talking about. I'm not sure whether your testimony relates there to the level of the carrying charge or even the existence and the authority for carrying charge. And that's what I'm just trying to get at. Is your interpretation that the carrying charge provision from the last stipulation carries over into this case? I'm surprised that I'm not clear about it, but I'm not. I just think it's a very simple question.
I believe Mr. Provencio's testimony essentially says, you know, just because we had a commission approved charge based upon the customer deposit doesn't mean that we can't make a recommendation, to which I have no dispute. But having worked on the cost of service and understanding that there are industry standards for what you are allowed to earn a fair rate of return on, I felt it prudent to comment, we don't earn a weighted average cost of capital. He suggests essentially that we are over collecting deliberately, and that in doing so, we then are earning money, and that is inaccurate.
I'm really trying to get at a much simpler question, Mr. Gonzalez,
Sure.
which is, are you, since it's not stated expressly anywhere in your filing, are you assuming that there will be a carrying charge for the 2023 rider that's to be approved in this docket?
No, but I believe it's a recommendation by the city of CLC.
So the company did not request to have any carrying charge. Is that your position?
I really don't have a position. My statement was really just to acknowledge that there are general standards that certainly we use in terms of what we can and can't include in the general rate case. And I'm sorry if that digresses from the topic. I think you've asked the question 3 different ways to effectively ask if it impacts the 2023 year. And
let me ask this a slightly different way, Mr. Gonzalez. If the commission said nothing at all about carrying charges, if Madam Hearing Examiner didn't mention it all in her recommended decision, and the commission didn't say it in their final order because it was not specifically requested by the company in its first application or its amended application, would you, as the person who does this accounting, would you assume that the carrying charge provisions approved in the case 21-00111 UT stipulation were still in place for 2023, or would you assume that they had expired? That's all I'm trying to get from you.
I'd assume they've expired because that particular ruling was related to the return of CRLEF funds, and we agreed.
No, I'm not talking about the one for CRLEF. I'm talking about the one that, the generic one that started with a balance of 0. Remember that one?
But it's my understanding that was precipitated by the return of CRLEF funds.
Okay, I'm not going to go any farther because it's not worth asking. But you're not making a request to have
I'm not.
carrying charges in this case. Okay, that clarifies for me. Thank you. Let's go on to the large customer adjustment. In your rebuttal testimony at page 9,
I'm there.
okay. That's the question and answer on the bottom of the page. You described this as a policy issue addressed by Mr. Novella. And I'm wondering whether, and since you're the supervisor in the rates department, where your role fits into the large customer adjustment. We move on to pages 10 to 11. You do give at the bottom of page 10, carrying over to page 11, you do give an opinion that EPE complied with the commission approved tariff. Is that right?
Yes, I do.
Refer to Mr. Novella. And so as the supervisor of rates, are you familiar with rate 38 in serious annual permutations?
And serious, I'm sorry.
Are you familiar with rate 38 as in its various annual permutations?
You mean the changes in the rate?
No, are you familiar with the tariff? Is that part of your job to know?
Absolutely, yes.
Tariff.
It is
Okay.
the crux of my testimony.
Okay, well, let's look, well, sometimes there's a difference between calculating the numbers that go into rates and the actual tariffs. See, that's
Sure.
Can you look at CLC exhibits 7 and 8, please?
I'm looking at exhibit 7.
Okay. And is exhibit 8, I'm sorry, I thought I had this open on my screen and it went away.
I have it as well.
Okay. So now you've got the two, and these are the two tariffs. Would you agree these are the two tariffs that were in effect during the time that Mr. Provencio is recommending that costs be refunded to non-formerly large cap customers?
I agree. Exhibit 7 corresponds to 2019 rate year, and exhibit 8 corresponds to 2020 rate year. Yes, those appear to be the tariffs.
And looking at the tariffs, is there any language in there that would allow EPE to discount rates to customers who are no longer subject to what is described as the statutory cap on billing for certain large customers?
There is a stipulation just below each of the tariffs indicating 2% of pre-tax charges, if that's what.
Well, it says doesn't that 2% of pre-tax charges say customers subject to large customer cap?
Yes.
And doesn't then the explanation of that below that say statutory cap?
It does. The bold says statutory cap on billing for certain large customers.
Okay. And do you believe that once the law changed, there was still a statutory cap in place?
I I don't offer testimony on this, but I did listen to testimony yesterday. I believe this was addressed by Mr. Novella. And I would simply say what I've also said in my rebuttal testimony. We followed the approved tariff, the commission approved tariff. And it's my understanding based on Mr. Novella's testimony, and I have a small excerpt on it too. We offered to attempt to try and correct that, but I believe given the complexities at the time, it was decided not, we had to withdraw that.
Can you point to me on this tariff, the language that says that overrides the fact that says that you can cap charges to customers when there is no longer a statutory cap?
I don't believe we can, but I think the commission can, and that's what happened here.
Well, just reading the language itself, would a customer, if a customer were brand new, and I think you did add a fifth customer after this law changed, right?
Yes, ma'am.
Would a brand new customer who'd never seen this before, you believe the customer would consider themselves subject to the large when there's a quotation to a statute in the applicability, there's a phrase customer subject to large customer cap, and there's a description of the large customer cap as a statutory cap. Do you believe that confers on EPE or the commission the right to give a statutory cap discount to customers when there is no longer a statutory cap in place?
Madam Hearing Examiner, I'm going to object to that as a compound question. It's also asking for speculation.
I think she could object on the grounds it calls for a legal conclusion, but it's not that compound. It's walking through the language and asking him whether he has an opinion.
I heard a number of assumptions and questions built into the compound question that you just asked.
It's the language in this tariff. It's all three clauses in this tariff. The applicability limitations of section 62.16.4A2, the customer subject to large customer cap, and the statutory cap on billing for certain large customers that refers to a rule. And I'm just wondering whether you believe that when there's no longer a statutory cap in statute, whether, well, I'll ask this as two questions, whether EPE, I think you just said EPE can't override the statute, but the commission can. Is that your position?
I believe that's exactly what occurred here.
Okay, thank you. Let's move on then. The annual reconciliation question. And
All right, I just want you to know, Ms. Stevens, you have 5 minutes remaining.
okay. So I believe in your testimony, your rebuttal testimony, Mr. Gonzalez, you seem to be agreeing that the cumulative difference is an overcollection, as Mr. Provencio testified, to about $279,000. Is that right?
Yes, and I think you might be referring to a specific part of my testimony.
Yeah.
Mind providing me the
I'm on pages 10 to 11 of your direct, and then in your rebuttal, it is. In the rebuttal, it is.
You're talking about page 805 to 806 of the Bates stamp pages, Ms. Stevens?
Hold on, I was cruising through it. 80.
or 12 of 30.
Well, she's asking, the hearing examiner asking that one. I'm talking about, yes, pages 805 to 806 of the direct, and page, and then we see on your rebuttal at page 12 of 30, you concur that the 256, I believe is 265. Maybe converted them. Oh, the net, no, you concur in the 256,000 net or cumulative over collection. And then on page 14, the short question answer, you say that you oppose using a cumulative reconciliation methodology. Is that right?
Yes.
So you're agreeing to the numbers, but you're disagreeing with the methodology. So let's very quickly turn to JFP1. Hope you've still got it there. I hope I've still got it here. And under this methodology, can you tell me, let's do what the previous methodology was. And it looks like after the first year, you had a net under collection of 1.6 over collection of 1.6 million, and that was credited in the 2 years later in the third block. It says from May 5th, 2021 application, right?
The 2020 reconciliation for the 2021 plan year. Yes.
Right. And now where, and so you're doing it, you're skipping over years, what you're saying your methodology is. You're doing every alternating years of reconciliation. Where does the 657,000 under collection from over collection from the reconciliation for 2019, the second block on a page, where does that show up on your on this year's, which is the last block on the page? Why haven't you subtracted at minimum the 657,000 from that to reflect what you did in the previous reconciliation?
It's a good question. Thank you for the question. Indeed, it was the rebuttal testimony that helped flesh out that I inadvertently did not include that. Back to the 256,000, what I agree to is that Mr. Provencio's addition of the over and under collections does amount to the $256,275.65. I do not agree that that is the amount applicable to an annual reconciliation, and the correct amount is actually just over 171,000 when you account for what you just pointed out, the previously applied over collection of $657,000 within the rider applicable to this reconciliation, or the very bottom exhibit or table within exhibit JFP1. And so I'm acknowledging a mistake from my direct testimony.
And is that in your rebuttal testimony?
It's not. It's another area of haste in trying to meet the rebuttal response time period. And so I feel compelled to address it now.
And have you recalculated the rider?
The rider in effect goes down as a result of the reduction. The reconciliation balance still is an under collection, but the rider itself goes down.
And where does the $427,000 from the second block, the second from the bottom block, the reconciliation of 2020 renewable energy?
That is next year, or shall we say a few months down the road for the 2023 plan filing.
And is that taken out of the 829,000 figure also?
It is not. It will be
Why not?
built into, well, the 427,000 is actually embedded in the current 2022 rates. So revenue is adjusted for that in 2022. But the reconciliation and next year's filing, so the 2023 plan year, which includes the reconciliation of 2023, needs this adjustment to account for the fact that it's embedded in rates for 2022. So it does skip a year.
So earlier in your testimony, Mr. Gonzalez, you got in your oral testimony, you were fairly emotional, fairly heated and emotional about saying that Mr. Provencio was wrong in suggesting that EPE has been collecting a lot of money and should be paying interest on it because they always run an over collection. Aren't you just proving that point that we're perpetually the EPE is perpetually in arrears to the ratepayers here?
I'm going to object to this as argumentative.
I'm going to allow it. Go ahead, Mr. Gonzalez.
I think with the adjustment that we've just discussed, here we have a year that actually has an under collection.
That's an annual under collection. Isn't that an under collection because what you just said, at least a part of that under collection is because that $657,000, I mean, it should have been there.
Yes, and prior to that, the under collection is, as you see it there, the 829, which admittedly needs the adjustment of 657,000. My point is just simply that here we have a year wherein we have an under recovery and not an over.
And the reason that one of the reasons that you had an under recovery was because the rate rider was designed to have an under recovery to make up for the previous over recovery. Is that right?
To be clear, we are not changing any standard. We simply are measuring costs against revenue. The difference is what it is, and it's applied to the rate. We have now 3 completed reconciled years, if you include this one, in which we have applied this and reconciled 1 year and applied it to the next.
And is it your testimony, is it your position that Mr. Provencio and Ms. Souls are not doing what you just said and comparing revenues to costs?
I believe they are, but they both refer to a cumulative reconciliation. I don't see that either one is actually recommending a cumulative reconciliation, but we have each participated in the last 3 years, a 1-year reconciliation, which is how the rate is actually applied. And so I have no dispute with the cumulative amounts, but it certainly doesn't conform with what we've been doing.
Would you agree that what you were doing?
Miss Stevens, I think your time is up.
Okay, I will stop.
Much.
Thank you.
Thank you.
I appreciate it, Mr. Gonzalez. I appreciate it, Ms. Anaya Allen, and I think it's lunchtime, isn't it? Or maybe it's not. Maybe there are other people who've been going through. I'll turn off my sound.
Okay. Well, I had suggested that we would go to lunch at 12:15. I don't know whether Ms. Souls, you would be next. Would you be able to complete your testimony or your cross-examination? Or do you think you need more time than that remaining before lunch?
Madam Hearing Examiner, I think Ms. Stevens asked all the questions I wanted to ask Mr. Gonzalez. My head's spinning. I have no further questions for him. Thank you.
Thank you. Mr. Downs?
I have no questions for him. Thank you, Madam Hearing Examiner.
Okay. Doña Ana County, Mr. Herman?
No questions, Madam Hearing Examiner.
Thank you. And staff, Ms. Regensburg?
This is Brad Borman. I do have some questions for.
Oh, go ahead, Mr. Borman.
Hi. And I should be able to finish them, if not by 12:15, by shortly thereafter. So.
Go ahead.
Good afternoon, Mr. Gonzalez.
Good afternoon, Mr. Warren.
Could you please turn to your rebuttal testimony on page 11?
I'm there.
Okay, beginning on line 14, you have a Q&A that begins there. You respond to Mr. Provencio's testimony about cumulative accounting of costs and revenues in the reconciliation process, right?
Yes, sir, I do.
Okay, and in your response, you state, among other things, that the argument that cumulative accounting results in more accurate or correct accounting is mathematically incorrect, right?
I do state that.
Okay.
I don't say that cumulative is incorrect. I state that it's incorrect to assert that cumulative is any different than a one-year reconciliation, certainly in the long run.
Okay, you're saying that it's not necessarily more accurate.
Exactly.
Okay. And you further explain that the associative property in mathematics disproves this argument and says that regrouping numbers being added will produce the same sum, right?
Yes, I do.
Okay. So then, and I just want to make sure this is clear, do I understand correctly then that you were saying that the reconciliation results ought to be the same whether you perform the cumulative accounting method or the year-to-year method that you have been using?
Yes, maybe not in that exact instance because, you know, a one-year reconciliation will result in something, and then it takes time to catch up to what cumulatively has occurred.
So you're saying, if I understand correctly, that over time it'll be the same, but not necessarily in a smaller time frame.
Right. Nothing is lost, is what I'm saying.
Okay. And then now, if you go to page 12, line 11.
I'm there.
You there? You concur that that the net over collection of $256,275.65 is the correct amount that should be incorporated into the 2023 RPS cost rider calculation, right?
I had a correction to my testimony when I started. The 2023 was changed to cumulative.
Yeah, I see that.
Okay.
But you're saying that number is the correct amount, right?
I'm saying that mathematically that is correct. If you add the over and under collections represented in JFP1 on the far right column, you will arrive at $256,275. No dispute.
Okay. And is that net over collection amount different than what you had originally included?
It is. My original conclusion for the 2023 rate had an $829,000 under collection, and my ending testimony with Ms. Stevens was to correct for the fact that I neglected to include the over collection from 2019 that was embedded into the applicable rate year for this. Let me actually refer to the specific exhibit. If you look at the very last table on JFP1, it is the 2021 reconciliation, and the cost rider applicable in 2021 included or had embedded in it the over collection. And so therefore I needed to make an adjustment, lowering costs and effectively changing the under collection from 829,000 to approximately 171. And I'll stipulate, this may be something that hearing examiner Allen may want as a part of the bench request, and we happy to provide that.
Well, and I guess what I'm trying to get at here, and you can answer this, I hope, is that the difference in the amount of net over collection that you corrected and the amount originally identified, is that a difference resulting from utilizing the cumulative accounting method?
It is not. It is not. In fact, it's just primarily a mistake on my part, the 171,000 is the correct under recovery and consistent with what we've done in prior years.
Okay, thank you. I have no further questions.
Thank you, sir.
Okay, thank you, Mr. Borman. I think we will go ahead and break for lunch now. When we get back, I'd like to start by discussing those two items as bench requests. One would be, the calculation of the overall costs of the Kearney project. And the second would be the impact of the failure to include the 657,000 from the 2020 calculation that was reflected in JFP 1.
Yes.
So we'll kind of hammer those out as our first order of business when we get back, and then go to redirect as needed.
Very well.
Okay.
Enjoy your
All
lunch.
right. Thank you, everyone. We are going to be on lunch break for 45 minutes until 1 p.m. All right. Good afternoon, everyone. We are going back on the record in 22-00093. I think we're going to start with, I think we still have a minute or two. I don't see Miss Olson. Oh, Miss Olson, you are here. Okay. So we're going to start with nailing down the 2 bench requests that were discussed during Mr. Gonzalez testimony. So the first was a calculation that Ms. Stevens was looking for that would take the cost per kilowatt hour for the Kearney project and multiply it out by, you know, the expected production during the course of the year. Mr. Gonzalez, can you go ahead and describe your understanding of the calculation, and let's see if we can all have agreement on that?
I think Ms. Stevens would like to have a bill impact, and so I would be essentially recreating what we do now. That is, take the procurement costs associated with that rate year that includes the Kearney project and other PPAs that we have, including distributed generation, and then applying that with the same methodology, which also utilizes forecasted energy to arrive at a rate. And that rate then just translates into a simple bill calculation.
Madam Hearing Examiner, may I ask for clarification?
Yes, Ms. Souls.
Are you asking for the rate impact of just the Kearney project, or are you asking for one, I think Mr. Hernandez said, and other PPAs?
Mr. Gonzalez? Are you referring to Mr. Gonzalez?
I thought I heard you ask for something different from what I thought I heard, I'm sorry, Mr. Gonzalez say. Yes, ma'am.
I was trying to, it's not my really bench request per se, but you know, EPE offered to conduct or perform some calculation based on what Ms. Stevens was requesting. And so Mr. Gonzalez was presenting what he considered to be what Ms. Stevens was asking for, which would be what would be the bill impact, you know, so it's a little bit broader than I thought Ms. Stevens was requesting. I thought Ms. Stevens was just trying to get at what the overall annualized cost of running the Kearney project would be, as opposed to what how that might be distributed amongst ratepayers.
Madam Hearing Examiner, may I explain where I was going?
Yes.
It's helpful.
Go ahead.
So I think that this may not be what you would like to see, but I guess objective here suggestion would be that Mr. Gonzalez take the cost figures associated, go to Mr. Martinez's 2026 table VM, whatever it is, 1RS, the supplemental one, the last one that he says the latest and greatest. Take 2026 because that's the first full year for Kearney as well as Buena Vista and Hecate, and run and estimate the rider for that year, and then do the rate comparison that he did, Mr. Gonzalez did in his, I think it's Exhibit 4, is the right one? You know, that has the billing impact, so that you could see basically the net change, the overall impact on customers. It's a little unclear what the starting point would be, whether it would be last year, which is how he did. I think that's how he did the Exhibit 4 now, right? Did you use, I think he used either 2021 or 2022 cost as his basis, as his starting point. But find a historical starting point that we understand and doesn't have any of those facilities, Hecate, Buena Vista, or Carne, and then compare it. I mean, the number is going to be, it shows up. So I think it shows up somewhere. Maybe it was in the pleadings, but in the other case, but the number is going to be big. So, and if he wants to, if you would like to do like,
I mean, I have a little bit of a problem with that because it's not taking into account multiple other factors, which might be, you know, the decommissioning that was discussed yesterday of some of the facilities like the Rio Grande facility. And so, you know, you're not, I don't see us redoing a brand new rate case here in this bench request. My understanding of what you asked for during your cross-examination of Mr. Gonzalez was that you wanted him to multiply, you know, the adjusted, the $20 some figure per kilowatt hour by the number of kilowatt hours that could be produced at the Carne facility. And you were asking for a fairly simple calculation, not something that was going to recreate an entire rate rider. I don't think we're looking at recreating a rate rider because I think there are way too many variables involved to do that.
Well, you could either do it by adding just the Carne cost, or you could again jump all the way forward to 2026 if you're looking at what the RPS rider is. What I think you've raised there, and which, you know, the company has repeatedly said they don't know the value of, is that in fact, there will be some reductions to the fuel. If you look at RFG 4, there will be some maybe changes in the fuel clause, and they may be after the next rate case, there may be some changes in base rates, but that was just assuming the status quo on the other factors.
Ms. Olson, do you have any comment on this?
Well, Madam Hearing Examiner, you articulated my concern if, you know, for example, in every REA filing, we provide the rate rider that we intend to go into effect the following year, and then we provide for illustrative purposes the following year rate rider. And it sounds like Ms. Stevens is asking to provide for illustrative purposes a hypothetical rate rider that would go into effect in several years. And we can't really do the customer bill impact because you're right, that includes a number of factors, including factors that are unknown. And so I do, while I'm sure Mr. Gonzalez is capable of doing that, I don't know that it would provide any value and may provide a lot of confusion and misinformation. I think our options are to provide exactly what you've suggested, what the cost of just the Carne project is expected to be, or I don't know. I just don't see any value in providing a future rate rider. There's also the concern that the rule is kind of in flux and we don't know what the commission's ultimately going to do in a rulemaking on the rider. So.
Okay, so I think then my bench request is going to be to calculate the cost of the Carne project on its own without any other added, you know, the annualized cost of running the Carne project essentially, which is just going to be what EPE is going to pay per kilowatt hour times the number of kilowatt hours that are going to be produced that EPE is obligated to pay for, without trying to break that down into any kind of impact on customer bills.
And Madam
And that
Hearing
will
Examiner,
also include the capacity, right?
I can't hear Ms. Stevens. You say capacity, and
That
then
would
what?
also include the energy charge and the capacity charge under the rate rider, which was what I was trying to get Mr. Gonzalez to do that very simple calculation, but it would be
Yes,
the,
it can include those items.
And Madam Hearing Examiner, just one point of clarification, is that a 1 year or what's a,
Just let's do 1 year, just an annualized, just 1 year. 365 days.
And I'll just-
starting
go ahead, sorry.
as the figures are currently set out in the contract, the existing contract, right?
And I'll just check with Mr. Gonzalez if he has clarity from that or if there's any additional questions he has.
I'm fine. I understand.
And then I apologize. There was some discussion of a second bench request. Can we which I'm not clear on, so maybe we
yeah, you have my notes from just before lunch say it had to do with the failure to include 657,000.
right.
But I don't, that's all I grasped. So
My understanding was that Mr. Gonzalez identified that there was an error in his reconciliation calculation that changes the amount he's including, or he proposes is appropriate to include for the reconciliation adjustment. And so I would propose providing a new calculation and updated rate. I think Mr. Gonzalez can clarify, reflecting the adjustment that he thinks is correct.
Okay, so this would impact the rate that is currently in review, correct?
Yeah, advice notice, or the
sixth revised rate, number 38, cost RPS cost writer. So this would
That's
impact. Is that right, Mr. Gonzalez?
Yes,
That
ma'am.
This recalculation would result in a revision of the proposed RPS cost writer.
Yes, ma'am.
may I ask a question, Ms. Stevens? Would that be like visions of exhibits RFG 2 and RFG 3 and maybe RFG 4, the bill comparison? I'm not sure whether RFG 4 is necessary, but it looks like it's like really simple RFG 3.
They complement each other. I anticipate providing
All three of them?
Yes, ma'am.
Okay. All right, and then with this coming a week from today, next Tuesday.
Absolutely. Works.
Madam Hearing Examiner, I just have one point of clarification on the second bench request.
Yes.
Go
ahead.
EPE also had agreed in rebuttal testimony to provide a credit regarding the Buena Vista 2 amount that was included in the procurement cost. And so I don't know if you would prefer us to provide a fully revised rate reflecting our rebuttal position, or if you just want us to reflect the changes to the reconciliation adjustment.
I think it would be appropriate to do both because ultimately that is what the commission would be looking at in terms of its approval for this application.
Can I add that should also then include VM3? That's where we list the cost, and so for clarity's sake.
A revised VM3?
Yes, ma'am.
Mm-hmm. Yeah, yes, please. Okay. All right, so I think those are the two bench requests. We'd ask for those to be available on February 7th.
Agreed.
All right. Did you have any redirect, Ms. Olson, of Mr. Gonzalez?
I just have very brief redirect.
Go ahead.
Okay. Sorry, just give me 1 second. Okay. So Mr. Gonzalez, I think we've come to an agreement that 256, 275 is the net cumulative, sorry, the cumulative net over collection amount. Is that correct?
Yes.
And Ms. Stevens asked you about the 427,060 that was, I think, the over recovery from 2022. Is that correct?
Over recovery from the 2020 reconciliation. Yes.
427,60 from the 2020
Yes.
reconciliation. And has that amount been returned to customers
Yes.
through the 2022 writer?
Yes.
And so the amount to include that you're proposing to include as a reconciliation amount in the 2023 writer for the 2022 reconciliation is the 171,655 you mentioned in your cross-examination.
Yes.
And will that reduce the customer bill impact that Ms. Stevens questioned you about?
It will.
Present direct case, excuse me. The bill impact presented in your direct case.
I'm sorry, the bill impact for?
It will reduce the customer bill impact from what was presented in your direct case. Is that correct?
Yes, that's correct.
That's all the questions that I had. Thank you, Mr. Gonzalez.
Okay,
Thank
thank you. In the same order, is there any recross based on the redirect from the Attorney General?
No, no, Madam Hearing Examiner, thank you.
From the City of Las Cruces?
No questions. Thank you, Madam Hearing Examiner. Thank you, Mr. Gonzalez.
Thank you.
Ms. Souls?
Yes, ma'am, I actually do have a question.
Go ahead.
Mr. Gonzalez, when Ms. Olson asked you about the amount from 2020, she said, has that amount been returned to customers in the 2022 rider? And you responded, yes. Do you recall that?
Yes, ma'am.
You haven't done a reconciliation for the 2022 rider yet, have you?
We have not.
Would it be more appropriate to represent that as you attempted to return it in the 2022 rider, but you won't know for sure until you reconcile?
I understand the nature of your question. I will tell you that the rate was built to return or to take into account that over amount. It is true when 2022 gets reconciled, there may be some difference, but I would point out that the rider also encompasses the return of the CRLEF funds. And so it's not just a simple item embedded in there, but sure, I could qualify that by saying that subject to verification with the reconciliation, that would be confirmed. And certainly now that the rider is still in effect, it's January the 31st.
Will you do a reconciliation for 2022 when you have all of the 2022 information?
Yes, ma'am.
Even though the rider won't have changed, you can still reconcile 2022, am I correct?
Yes, ma'am.
And that reconciliation will include both how effectively you returned the 2020 amounts and provided for the other things that you attempted to do when you created that rate for 2022. Is that correct?
Yes. I believe that it's the desire of many here that the CRLEF costs in particular be itemized, if you will. And some request was made through an RFI about the nature of where we are today. And so it'll be further developed with additional information. Yes, ma'am.
Okay, thank you very much.
Thank you.
Great. Mr. Downs.
I have no questions. Thank you, Madam Hearing Examiner.
Doña Ana County, Mr. Herman.
Nothing for Doña Ana.
Thank you. Staff, Mr. Borman.
Staff has no recross.
Thank you. I have no further questions at this time, and so I believe that Mr. Gonzalez may be released today.
Thank you very much. Have a good afternoon.
Thank you, Mr. Gonzalez. Ms. Olson, who's your next witness?
Our next witness will be Mr. Dave Hawkins. Jeff Wexler will be presenting him, and I think it'll just take us a second to switch over the hearing room.
Go ahead. Okay, go ahead whenever you're ready, Mr. Wexler.
Mr. Hawkins, can you hear me? You must be on, because we cannot hear you.
Right,
How's
we
that?
do need, thank you, Mr.
Better.
Hawkins. We will start with having Ms. Gonzalez swear in Mr. Hawkins.
Raise your right hand, sir. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good afternoon, Mr. Hawkins.
Good afternoon.
Can you please state your name and spell it for the record?
Sure. David Hawkins, David Hawkins.
Do you have before you what's been previously marked as EPE exhibit number 9?
I do.
Is that the rebuttal testimony that you caused to be filed in this case?
It is.
Was that rebuttal testimony produced by you or under your direct supervision?
Yes,
Do you have any corrections?
I do not.
Is the rebuttal testimony in EPE exhibit 9 true and correct to the best of your knowledge?
Yes,
If you were asked the questions that are posed in EPE rebuttal exhibit 9 today, would you give the same answers under oath?
I would.
Madam Hearing Examiner, I understand that this has already been admitted subject to affirmation, and we would now tender Mr. Hawkins for cross-examination.
Thank you, Mr. Wexler. Mr. Elliott, does the Attorney General's office have any cross-examination for Mr. Hawkins?
We do not. Thank you very much, Madam Hearing Examiner.
You're welcome. City of Las Cruces, Ms. Stevens.
Just a tiny bit. Hello, Mr. Hawkins, how are you?
I'm doing well. How are you doing?
Okay. Since your testimony doesn't have much to say, I'm not going to hit everything that they've deferred to you as the only guy who has technical knowledge in the field. Returning to your testimony, your one question about Lisa LaRocque's testimony on behalf of the city, and you take the position, you interpret her testimony as saying, page 6 of your rebuttal, you seem to interpret her testimony as saying that LaRocque complains that the Kearney project is too large and the company should seek different procurements for RPS and capacity purposes. I'd like to talk to you about the latter, whether she actually recommended that separate procurements. And would you open her exhibit? It's CLC exhibit 1. And
I'm getting there. Sorry.
yeah.
Okay.
Okay, and page 43 of 125, actually paginated 41, 43 in the PDF.
43 of 125.
Right.
Okay, I'm there.
Okay. When you made that statement in your rebuttal testimony, were you referring to this question and answer? Why wasn't it wise for EPE to seek both capacity and renewable energy to fulfill the 2025 RPS requirement of 40% renewable energy in a single RFP? Was that the basis of your testimony?
I'm sorry. So were you reading to me the first line there?
I was reading to you the question, actually.
Oh, the question. Okay, I'm sorry. I have the answer in front of me. I wasn't wise. Yeah, I think that was part of it. You know, there, as I read through it, I think she suggests down at the bottom, or she acknowledges the efficiencies of one RFP, and so yes, I think it's in this area, particularly where I discussed in my testimony that she might be seeking a different methodology for procuring RPS and capacity requirements. And
did you read her testimony under the heading of new regulatory issues at page 69 of 125?
69 of 125, let me go there. Is it the top of the page?
It's, pardon, it's, there's are you on page 69? It starts with an answer.
It starts with an answer. So is it the question above it?
Okay. Yeah. And I'm wondering whether you took into consideration in your testimony, Ms. LaRocque's testimony here about beginning at line 5 through line 10.
May I read that now? Just
Yeah, please take your time.
yeah, I see that. I think I disagree with her math on line 5, but yeah, I see what she has
Yeah,
there.
line 5. Oh,
Yeah.
okay. So now, Mr. Hawkins, you didn't personally testify in case 19-348, did you?
348 was the you got to give me the
PPAs.
information. The numbers aren't in my head. 348 being the original LT PPA.
Right.
Yes, I didn't testify on that.
But you did testify in the what we called the companion case 19-00349 UT, the CCN for Newman Unit 6.
I did.
So in that instance, out of a single procurement, the company chose to file 2 different dockets. Is that right?
It appears so. I don't know the reasoning why, but yes, I would agree with that.
And if you don't know the reason, do you understand? Do you understand her point that Rule 551 did work for a mixture of a capacity and REA resource, approval of a resource that included capacity and renewable energy to be applied to the REA?
I understand. If you're asking if I understood that storage costs could be applied to the REA, yes.
No, I'm not asking you that because I don't think at that point storage costs could be applied to the. Well, I say I'll take that back. I'm asking you whether you understand the idea that, and you can see this looking at your own the company's breakdown of costs that goes through the RPS rider, that the company has that any utility may seek approval for a resource that includes renewable energy and do that in a different format, but still ask for and be allowed to apply the associated RECs to its RPS compliance.
And it's me and the way my mind works, but could you break that up?
Okay, yeah. But well, how about some examples? Macho Springs, that's a PPA, right?
It is a PPA.
And did the company seek approval of that as a PPA under Rule 551, or did it seek approval of that in an annual RPS case?
I don't know the answer without looking at it.
And I think you do reflect that for Buena Vista 1 and Hecate 1, the approvals were obtained in a Rule 551 case, and the RECs are applied to RPS anyway.
What are applied? I'm sorry.
Are applied to RPS anyway, is that right?
Were you talking about BV1 or BV2?
One. Well,
One being the storage project. That sounds right to me that was the LT TPA.
I'm sorry. Please repeat your answer.
That sounds correct to me, that they would have been under the LT TPA approval.
Do you know what the time period for LTPPA approvals is under Rule 551, Mr. Hawkins?
Are you asking me the time prove the length of the agreement or how long?
No. The time for the commission to handle an application.
I'm not sure about what time the commission is. I won't say required. They can do whatever they want as far as I know, but to respond.
I think I'll ask you just one of the many technical questions that were referred to you, but this is a big one. how does EPE envision operating Carne in a way that will, so Mr. Martinez testified about the expectations regarding the allocation of curtailments. And he said that that wouldn't be, you were here yesterday, and he said that that would not be what would happen in the field. Right? Do you agree with that?
Yeah, I think if I remember the question and answer yesterday, there was some question about whether Carne would be individually looked at for dispatch for reliability purposes, if I paraphrased correctly the question.
Sort of, yeah. I mean, there was a more general discussion about the actual dispatch. You got the magic word because you're the engineer here.
Yeah.
Nobody used that word all day yesterday.
Yeah. So we look at. Go ahead.
So the question was, how, the dispatch and how do you, if you first of all, how would you dispatch it, and given Mr. Martinez's testimony about sort of a jurisdictional allocation of curtailments, and this is where you get back into your vice president hat, Mr. Hawkins, how do you see that being used? What mechanisms do you see to make sure that ratepayers, New Mexico ratepayers, don't pay a whole lot of money for Carne and not get a reasonable amount of credit for the other aspects, including curtailments and displaced generation?
So, Madam Hearing Examiner, I just want to make sure.
I know that's a really big question, but I guess I know that you can give me big answers, because
I don't object to him answering the question, provided he understands it. So
yeah,
I think it's up to the witness to let us know whether or not he needs
Yeah, I mean, my
clarification.
understanding is maybe an explanation of how EPE balances its loads and resources and what role Carne plays in that process.
Yeah, that would be the first step, and then how it comes through in money to ratepayers. But yeah, tell us about the mechanic, the operational mechanics.
Sure. Well, part of our obligations we fall under a operational jurisdiction, which is the NERC, North American Energy Reliability Corporation. And within that, we also fall under oversight from the Southwest Power Pool as a reliability coordinator. And we have an obligation to make sure our generation, which is PPAs, generators, we see DG as a load on our system. We don't see it as generator. It comes through as reduced load. But we have an obligation to balance our generation resources with load. If they are out of balance by a certain degree, you need to bring those in balance by a certain amount of time. So typically on a normal day, sunny day, we are planning the next day's resources based on projections of solar resources, projections of load. And we are able to come into balance for those resources as we plan the next day. There are instances where weather may change, or whether load is just lower, for example, of what we forecasted regardless of weather, that we need to reduce our generation levels. And we do that typically. We can reduce our generators. We can take generators offline. That's usually the first process. I can't recall a time, there may be, I just can't recall a time where we've actually curtailed PPA agreements, these large utility scale solar projects, or anything within our control. The EP will be entering into the California Energy Imbalance Market, which is set up to give utilities and those that participate an additional tool for helping to balance particularly renewable or wind resources, intermittent resources within the hour. So if load drops within the hour, there is a market such that we would not have to curtail any solar resources. But just overall, we don't look at a particular contract. We don't look at a particular resource unless there is a transmission concern and that particular resource is contributing to a transmission overload. But in general, we would look to manage and not have to curtail renewable resources through the day-ahead process, through removing other generators online, or through the energy imbalance market. Did I get there?
Yeah, well, we're really close. So in the event that, that's been your experience before adding, 130 megawatts in Carney, and I guess it's what is 101 total of Buena Vista, 150 for Hecate. So your situation on the ground is going to be quite different by 2025, isn't it, or 2026?
I'm sorry, quite different in 2025
or 2026.
Am I good? I can respond. Yeah, no, it does change the amount of renewables that we have online. But like I said, the day ahead process by which we set up the next day still makes that manageable. So to the extent we have additional resources, that allows us to take other resources offline on say a non-peak day. And so, we can add renewables in the spring and maybe subtract other resources that were providing energy over that period. We can forward sell the projected amount of those resources as well to manage that.
And that would be what we non-technical people call an off-system sale?
Those would be through off-system sales, but they wouldn't be from the energy from the renewables serving the customers. To do that, we'd actually have to buy transmission wheeling out of our system, where that would likely come from is the Palo Verde resources. That's where there's a liquid market hub for that type of transaction.
So do I understand what you're saying is that to do this daily balancing when there's a lot more renewables online, you will reduce loads reduce generation where you can. That would be the gas, right? Because you can't stop the sun from shining on the solar panels. Is that right?
You're right. We can't stop the sun from shining on solar panels.
And you can't turn Palo Verde on and off at will. They wouldn't be happy with that.
No, I don't even know that we have the rights to. Yeah.
So it's you would adjust the local gas generation, and then the curtailment issue arises when you've got more solar and you have to pick.
Sure. So in setting up the day and projecting the load, we would look at what we would call, in this case, a must-take resource, which would be the renewable resources, and accommodate that through our other generation.
And before we go into what the actual allocation of or decisions on how to do the curtailments, let's see, the must-take raises the inevitable question, Mr. Hawkins, of must run. And will you, with more solar on the system, will your historical approach to the must-run gas units as the sort of last resort backup, will that change? Will those numbers decline, or will they rise because there's potentially even more volatility with the solar?
Well, I suppose it depends on the time of the year. We do need a certain amount of local generation to support the system through voltage support or frequency support. We need to be able to plan for the loss of a major transmission line. These are all studies that take place that are system operations, hourly at least, maybe I believe even intra-hour, on using actual load, actual generations, and then what if scenarios are calculated. And if we violate any of those scenarios, you need to correct those. And if that means adding local generation, that's what we do. So maybe a long-winded answer is saying it depends on the time of the year. So when you look at Palo Verde Unit 3, for example, a zero carbon resource that is no longer part of the mix for serving our residential customers, that lowers must take because that is not supporting our local voltage levels. But like you said, it's a nuclear unit. We can't ramp up, we can't ramp down. We will be filing for abandonment of Rio Grande 7 and either Newman 1 or Newman 2, I believe, before the commercial operation date of Newman 6, which is a Texas resource that is quick start, that is certainly capable of coming online if there's a large drop in renewable generation. And we have multiple, what they call LMS generators, that are capable of coming online within 10 minutes. So I know Newman 6 is a Texas resource, but it's, as a system overall, we have a lot more tools in our tool belt to manage changes that we didn't have previously.
So now I appreciate all that information, but now I'm going to get you to the question that ties into Mr. Martinez's testimony is, say under all these circumstances, there's just so much solar coming in that you have to curtail it on a given day. You haven't been able to manage it because the sun doesn't go away just because you don't need energy. How then would you make the decisions as to which PPAs, and this includes a little bit of, I guess, company-owned facilities, would be curtailed first, actually physically in practice curtailed, as opposed to the cost allocation?
I'm sorry, as opposed to the
cost allocation methodology, just what would physically happen in reality?
Well, in reality, we would submit those resources into the energy imbalance market in an attempt to avoid any curtailments. But beyond that, if there was the possibility that we had over generation, and what I mean by that, more generation than load, and we've taken all the other necessary steps to turn off generation that can be turned off. What we see at system operations is solar in general. So we would instruct what I envision, since we haven't done this, is a pro rata reduction for reliability reasons. I don't think so what we're really talking about here is a decision that needs to be made quickly to come into compliance with certain regulatory reliability standards. And so, for example, if they say we need 75 megawatts reduced, there would be a pro rata reduction, is the way I envision it.
So you would actually tell each of the, however many it is, half a dozen, ways actually to reduce, or now are we moving from the realm of physical plant to accounting treatment.
I'm sorry, to
Accounting treatment.
Are we asking our operators to do accounting treatment?
No, you said you would do it on a pro rata basis, and I think that in past cases, that's not necessarily whether people have said, I'm under the impression that you would pick maybe one or two, not that you would do it across the board.
Well, in pro rata could also mean throughout the course of the year in an even distribution.
Oh.
However,
Let's do the 1 day scenario, just to educate us.
yeah, so as I mentioned, we have not had to do this in memory. And I believe we do have some capability from system operations to send signals to the operators of the plants. And I think that just needs to be more fully developed as we're taking on these additional resources.
And now we're going to start talking about the cost element. So if you have ability to send signals and actually tell facilities to turn off, would you do that based on the pricing or other terms of the contract? Or again, would you do some sort of a prorating just to be in some sort of way fair?
Given a little thought to this, because I think things change with the introduction of the production tax credit. And so the curtailment of those resources, I believe, has a different impact than just paying for the energy that wasn't produced. I believe in, I would subject to check, but I believe there's provisions when you go beyond the allotted curtailments that are allowed in the contract, there may be provisions for production tax credits. And I think that ultimately the curtailments would have to take into account the overall economics.
Are you talking specifically about the Carne contract there with the PTRs?
I subject to check. I mean, all our other agreements would have been prior to the production tax credit of solar. So yeah.
That's what I thought. That's what I thought. I just wanted to confirm my own understanding.
Yeah.
And now in this side, now the question that I think Mr. Novella kind of passed you from a rate making standpoint, how, and you kind of explained how you would do this to be economical, I guess, from a kind of a global standpoint, but how then would it filter down to the rates that New Mexico customers pay, given that you have the RPS rider that says you can collect everything under the contract for certain contracts, but then you have things like Buena Vista 1 and Hecate 1 and Macho Springs that are not under the RPS rider and are treated basically through the fuel clause.
I'm sorry, RPS rider of?
Are treated basically through the fuel clause. Are you?
Waiting for the all clear. I'm not. I watched all clear to answer. No,
He's much more considerate of the hearing as a court reporter than I am. Thank you, Mr. Bucket.
No, I watched Mr. Novella's testimony yesterday. I don't recall that he would have passed on to me as a expert in rate making or cost allocation at the residential or jurisdictional level.
Maybe it was Mr. Martinez. He was getting. So no, do you have as a high level executive who spends a fair amount of time at the PRC, like it or not, do you have anything to say about how the rate recovery would be handled?
Well, I object to this question, Your Honor. I've tried to be patient and I understand that some issues were deferred to Mr. Hawkins, but he is not a rate expert. His expertise is in operations and resources. And I don't think that it's going to do anybody any service to have Mr. Hawkins answering rate questions.
All I'm asking for is for him to say what he's comfortable with. If he wants to stop at this point, he'll stop at this point.
I'll stop at this point.
Okay, thank you very much, Mr. Hawkins. Good to see you again.
Thank you.
Thank you, Ms. Stevens. Ms. Souls? Any cross-examination for Mr. Hawkins?
Yes, ma'am.
Go ahead.
Hello, Mr. Hawkins.
Hi, Ms. Souls. How are you doing?
I'm good, thank you. I hope you are too.
I am. Thank you.
Would you please go to your rebuttal testimony at page 7 of 17?
Okay, I'm there.
And beginning at line 9, you claim that you have responsibilities related to the resource procurement process, that you've been directly involved in the procurement process at El Paso Electric. That's your testimony, correct?
That's correct.
Were you directly involved in the negotiations that resulted in the proposed CARNE purchase power agreement and energy storage agreement?
Yes, I was involved time to time. I did not make all of the negotiation meetings between parties, but yes, I would generally say I was involved.
And what was your role then?
Negotiation. It was typical negotiation.
Okay, if you would go to page 11 of 17.
Okay, I'm there.
Where you are responding to the Attorney General's recommendation number 2. What was recommendation number 2?
I'm going to go to, if I may, can we refer to testimony of Ms. Click?
Yes, you may.
Okay.
I think you'll find that on page 7 of 33 of Ms. Glick's testimony.
Is this just so may I read to you what I read as number 2 to make sure the commission
I think that'd be a good idea.
I'm sorry. Just to make sure we're on the same page, I read them as a summarization of Ms. Click's recommendations. Is that the page?
Unless you think you were referring to some other recommendation number 2.
It is probably that too, but also I know she has testimony specific to each recommendation as well, but I would prefer probably to go down to her specific recommendations.
And I'm sorry, what page is that on of Ms. Glick's testimony?
I am scrolling rapidly. I will.
I thought I heard Ms. Souls say it was page 33, which I didn't, I thought maybe I misheard.
And Ms. Souls, maybe that's it. I'm recalling for some reason maybe it was a summary of it, but okay. So yes, it is regard to that, but I thought she had some specific recommendations in regard to item number 2, which I can't find off the top of my head at this point.
All right, so would you share with us what that recommendation is so that that's on the record and specific to what your testimony is saying?
Yeah, I apologize. As I read my own testimony, it says on page 18 of her direct testimony. So let me go to page 18. Okay, so believe on line 5 is where the recommendation of Ms. Glick for her second recommendation begins on line 5 through 9.
And for the record, what is that recommendation?
Would you like me to read the recommendation?
I believe you should. Yes, sir.
Second, in both initial PPAs and PPA amendments, EPE should provide clear and transparent information on the amount of damages, how they are calculated, and the time period of replacement energy covered. This will allow the commission to better weigh the cost of the power and the risks imposed on ratepayers.
And is that what you're responding to in your testimony?
And if I may here, Madam Hearing Examiner, I can see that the quoted language in Mr. Hawkins' testimony at lines 17 to 19 tracks page 18, lines 19 to 21 of Ms. Glick's testimony, beginning with, at a
Fourth.
minimum, I recommend.
Right. So perhaps more the fourth recommendation and not the second. Is that, Mr. Hawkins, can you provide some clarity on which recommendation you were responding to that discussed reports on construction progress?
Yeah, I think both of the recommendations suggest more transparency with the commission. And so as far as reporting to the commission, and I have testimony that I guess will be taken up in a future proceeding that's, suggests we will provide monthly updates to the commission.
In relation to the Carney project, so and here is where I was confused, because if you would go back to page 7.
I'm sorry, of Ms. Glick's testimony or my testimony?
I think I mean Ms. Glick's testimony. Give me a moment. She had itemized her recommendations under, oh, and of course I'm in yours, not hers, which is why I can't find it. Give me a moment, please. All right, on page 7 of 33 of Ms. Glick's testimony, she offers an itemized list of recommendations. Is it your conclusion that this itemized list do not match the itemized list at the end of her testimony?
Oh, I don't know that I've said that. I would have to review it. I don't know that I've come to that conclusion.
All right. Here on page 7 of her testimony, she says, number 2, the commission should require increased transparency of the analysis behind why the cost of the Carney PPA went up from the price bid in the initial PPA. Do you see that?
I do.
So let me ask the question that I thought was related to your testimony.
Probably.
Did you conduct such an analysis of the Carney PPA?
Well, I believe Mr. Martinez may have presented that in one of his exhibits and has talked extensively about that. And so is your question, should it be provided? And I guess my answer is it was provided.
Very well. Then let's go to, I'm going back to your testimony. At page 12 of 17. Beginning at line 19, where you respond to NMAG recommendation number 3. Now,
Yes.
my first question needs to be, which recommendation number 3, the one in the early list or the one later in her testimony?
I believe it's number 3 on page 7.
All right.
Ms. Glick's page 7.
And would you agree that this says in this and all future PPAs, with this meaning the Carnate PPA?
That's what I understand, that this would refer to Carney.
And your testimony on page 12 of your rebuttal testimony seems to be putting the emphasis on all future PPAs. Is that correct?
I am emphasizing all future PPAs.
So in regards to the Carney PPA, could we talk about that in relation to her recommendation? Starting with EPE to explicitly outline the conditions under which renegotiation of a PPA commercial operation date is permitted without breaching the contract.
I'm going to
Yes.
object to that question as vague and calling for a legal conclusion. The terms under which the COD can be changed, amendments to the PPA, the Carney PPA can be made, are spelled out in the Carney PPA itself. I mean, it's already signed and presented to the commission.
Thank you. Then let's go to the Carney PPA. I think you'll find it as Exhibit VM4 within Mr. Martinez' direct testimony, as which I have as EPE Exhibit 3. And I believe it begins on page 454 of 821. Please let me know when you're there.
Yeah, I'm opening up a new, I guess I can't. It looks like I have to jump back and forth.
Yeah, that.
And I'm sorry, do you have the exhibit number or is it in this?
So the Bates number would be 470 of 454 of 821. I'm sorry, 454 of 821.
Of Mr. Martinez's testimony?
His direct testimony, yes, sir.
Okay, that's what I was looking for. Thank you. Is there an exhibit? I'm seeing up to 309 on my exhibit.
The Bates
4.
number is down in the bottom left-hand corner. If you're looking at it's the PDF number that would be of 309 pages. Go to page 63 of 309.
Okay, I'm there.
And do you recognize this as the Carney PPA that we're talking about?
Yes.
Would you please go to, it's the Bates number, 470 of 821, and let me know when you're there.
All right, I'm there.
There's a term on this page, interconnection agreement, which references an interconnection agreement effective as of May 29, 2022. Do you see that?
I do.
And does such an interconnection agreement exist?
I know that FERC recently accepted a new interconnection agreement, I believe in January of this year, in January 2023. There were some revisions made. So this is all subject to check, but I believe the May 29, 2022 interconnection agreement may have been with Galehead, a third party, and the interconnection agreement was taken over by Desiree. That's my recollection, but I may be subject to check on that.
Am I correct that El Paso Electric has not provided a copy of the interconnection agreement as part of this filing?
There's been a lot of discovery. I'm not sure of what was provided.
The one that you referenced in January, would that be the one that would be duly executed by Desiree and EPE?
That one is accessible on the FERC website. It may be unexecuted by Desiree. I believe FERC accepted the unexecuted filing.
Is the reference interconnection agreement general in the form of a FERC large generator interconnection agreement?
That's my understanding.
And what responsibilities does El Paso Electric have in fulfilling the interconnection agreement?
Objection, Your Honor. Again, I've tried to be patient, but we're well beyond Mr. Hawkins' scope of his testimony. I mean, now we're into the details of the Carne PPA, which was presented as part of Mr. Martinez's testimony, not Mr. Hawkins.
Madam Hearing Examiner, Mr. Martinez deferred to Mr. Hawkins all of my questions regarding this PPA.
I don't recall any deferring of contract terms to Mr. Hawkins.
Well, I'm not sure that Mr. Martinez deferring to Mr. Hawkins provide some type of, are you suggesting waiver of the general requirement that the cross-examination be related to the direct testimony?
Madam Hearing Examiner, I had been asking Mr. Hawkins about his rebuttal testimony, where he was rebutting recommendations of Ms. Debbie Glick, the Attorney General's witness. And her recommendations had to do with this contract and circumstances where delay damages or postponement of the contract without amendment could occur.
The interconnection agreement? I didn't see that in her.
Then give me a moment, if you will, and perhaps we can circle back to this. Mr. Hawkins, there's another term on this page, interconnection delay, which references the meaning set forth in section 3.6.1. Do you see that?
Yes.
Could we go to section 3.6.1? I believe it's on page 481 of 821. Let me know when you're there.
Wait, what?
Did you say 481?
484?
It may be 484. We're back to, this is hard to see, 3.6.1. 484 looks like it would be right.
Okay, I'm at 3.6.1.
Would you agree that according to the paragraph B under section 3.6.1, an interconnection delay is any delay associated with the interconnection of the generating facility up to a maximum of 180 days.
Protection Foundation calls for a legal conclusion. We can all read what 3.6.1 says.
I mean, Ms. Souls, are you asking him to agree that that's what it says in 3.6.1, or do you have a question? Because that's not really a question to have him acknowledge that you read what is written in 3.6.1.
So, Madam Hearing Examiner, I ask your tolerance. I am not an attorney. But I'd like to ask Mr. Hawkins if this section 3.6 regarding extension, basically, do you read that as permitting extension of up to 360 days for interconnection delay and force majeure without a renegotiation and without delay damages?
And Madam Hearing Examiner, I mean, my concern is this isn't a subject that Mr. Hawkins prepared for today because it's not within the scope of his testimony. And it's really, again, asking to examine contract terms.
Madam Hearing Examiner, Mr. Hawkins said that he was part of these negotiations. And when I asked about the circumstances under which the contract could be delayed, he was the one who said we needed to look at the contract.
Well, I think the point here is that the contract says what it says. And so I'm not sure really where you're going with this. Are your concerns that the contract is too liberal in allowing delays? Because that's a point that you could argue in briefing. I'm not sure that there's a question here for Mr. Hawkins.
So I would go back to what we had talked about previously. He was rebutting Ms. Glick's testimony and her recommendation, which was specifically related to this, which was the commission should require El Paso Electric to explicitly outline the conditions under which renegotiation of a PPA commercial operation date is permitted without breaching the contract, incurring damages, or otherwise requiring a formal PPA amendment.
I think the contract speaks for itself. I think you could also ask Ms. Glick what her concerns are with respect to how the contract addresses those issues.
Yes, ma'am, and I will do that. I know that she was not part of the negotiation and Mr. Hawkins was. Mr. Hawkins, was it the intent in the negotiation to provide that much leniency in terms of delaying the commercial operation date without damages?
And Your Honor, I'm really not trying to be difficult here. I don't know that I can allow Mr. Hawkins in a public setting to talk about the intent of negotiations, which gets into confidential back and forth between the parties. And so I object to that.
I'm going to sustain the objection, but I think Mr. Hawkins could be asked whether or not this contract clause 3.6.1 is in fact what was negotiated as part of the contract.
Mr. Hawkins, would you answer that question, please?
Yes, 3.6.1 was negotiated as part of the contract.
Why don't you move forward, Ms. Souls?
There is a section on the following page that's related to solar capacity shortfall damages.
I'm sorry. Can you tell me what document when you say on the
We're
following?
still in the Carne PPA. It would be section 3.8.
Okay.
And what's your understanding of what a solar capacity shortfall would be?
I am reading it. It's been a while since I've reviewed the contract. I think it's explanatory. I mean, it refers back to a solar capacity shortfall damages as, I believe, as a definition, unless the definition is contained within 3.8. But I think it talks about, you know, if they declare commercial operation date without reaching the full guaranteed solar capacity.
So for example, if they declared a commercial operation date and they only had 10 megawatts of solar in place, would that be in this category?
I think there are other terms regarding they cannot go, they also have to meet milestones under the LGIA, which would not allow them to declare a commercial operation date. If you're talking about 10% or so of the total output. So I think this is interpreted more so that they've done what they can as far as equipment, and they've obligated, they've fulfilled whatever they could to get to commercial operation, and they're not there. There's certain penalties associated that are identified here as a dollar amount per megawatt.
A dollar amount per megawatt after the 180-day delayed solar capacity
Well,
provided?
I think now you're probably, you know, this is where I would hire my contract lawyer to help me come in and sort these things out. So when we negotiate these agreements, there are attorneys present, and words mean some things to better understanding to certain professions than other professions. So you know, I can only tell you what words are in front of us, but the actual of how this would be reconciled, you know, it's the words are there, and it's for someone that I'm sure people could take different positions on to debate.
Very well. You referenced that LGIA contract. That's the interconnection contract we touched on a moment ago.
Yes, I'm sorry. LGIA is an acronym for Large Generation Interconnection Agreement.
Very well. What responsibilities does El Paso Electric have in fulfilling the interconnection agreement?
Outside the scope.
Doesn't the Carne PPA reference the interconnection agreement?
I don't.
I know. I believe Ms.
apologize.
Souls, the issue is whether or not it's within the scope of Mr. Hawkins' direct testimony. We're not, I mean, the entire PPA contract, I'm not sure that that's really what the scope of Mr. Hawkins' direct testimony is. So what from Mr. Hawkins' direct testimony are you relating this question to about the interconnection agreement?
I'm trying to understand how interconnection delays affect the commercial operation date and delays for the Carne project.
I mean, these are questions really, I think, for Ms. Glick, because Ms. Glick is the one who brought up these issues around delays of the commercial operation date and her concerns about whether or not there should be reporting to the commission when there are any delays in the commercial operation date and what the effects of those are.
Then forgive me, because I understood all of that to go back to what the PPA for Carne actually says.
Well, Mr. Hawkins' testimony is about whether or not EPE agrees that the recommendations from Ms. Glick should be adopted. I mean, if you have some questions for him about is direct testimony and EPE's position on the Attorney General's recommendations, I think, you should go forward with those.
Then let's go back to Ms. Glick's testimony, Mr. Hawkins, if you would, and her item number 3. And I believe you agreed that the phrase "in this PPA," we're talking about the Carney PPA, correct?
Yes, I believe, as I interpret her language there, I interpreted her language to mean in the Carney PPA.
And do you believe the commission should require you, El Paso Electric, to explicitly outline these conditions in the Carney PPA?
Under which a renegotiation is permitted?
Without breaching the contract, incurring damages, or otherwise requiring a formal PPA amendment. I think the rest of that phrase is also critical.
Yeah, I think like I said, I think this is, there are potentially so many reasons why the parties could come together. It's worthy of discussion. But, what is the reason for the renegotiation? Is it supply chain? What is it? Is the party going to default? What is the timeline? Is the project expected to go online in a month? Is it expected to go online in 3 or 4 years? I think these are all questions that, we would readily participate in a rulemaking to help answer, but I don't think it's as simple as made out to be as tell me when you would renegotiate and when you wouldn't, because I just can't foresee all the circumstances that may come up.
Would you agree that the COD for Carney, as it's currently defined, is May 1st, 2025?
That sounds right, yes.
And would you agree that for New Mexico ratepayers, there's a lot at stake in that date? Meeting the 40% RPS, perhaps, or costs for replacement energy if that doesn't happen?
Oh, I assure you, all of our projects that we bring on, not just the Carney, have impact on our operations, on our customers. Yes.
Very well. Let's move on. The interconnection for Carney, is that already in place?
You're talking about what I refer to as the LGIA? Is that?
No, the actual physical interconnection.
I don't believe so.
Will that interconnection for Carney be only for Carney, or will there be sharing with another interconnection facility?
I'm going off my recollection. As I said, it's a public document on the FERC website, but as I recall, it will be a dedicated interconnection point on an existing El Paso Electric transmission line.
Will the interconnection be able to handle the total potential output of Carney of 195 megawatts?
The interconnection agreement does not allow for it to exceed 130 megawatts at any given hour.
And why is that?
Because that was what Carney applied for in their interconnection agreement.
Won't such a limitation prevent El Paso Electric's New Mexico customers from realizing full benefit of the Carney capacity potential?
In the contract, I don't think you'll find that the battery can be dispatched on top of the solar output beyond the 130 megawatt capability.
Specific to Carney or for every solar plus battery facility?
They would all individually need to be negotiated. So, I mean, if someone wanted to present something that was solar plus battery, that was something that we could negotiate, but that's not what was presented here.
Very well. When would construction of the interconnection begin?
You'd have to refer to the document. I don't have the document in front of me.
How long is it likely to take?
Again, we'd have to refer to the document.
And that's a document we don't have. We can go look for FERC. Madam Hearing Examiner, is there a way to ask you to take administrative notice or in some other way tie that contract, that interconnection agreement to this determination?
I believe that it could be offered as an exhibit when you put on your case, Ms. Souls, if you wish to download it from the FERC website.
Since until this moment, I didn't know that there was a new one in January. I had no idea that it would be relevant to this case. And so what options does that leave me?
To download it, to mark it, to submit it as a proposed exhibit, and to bring it in as part of your case.
So when I am called to testify is when I would do that?
Correct. Yes. But obviously,
right.
you know, we are beyond the date that exhibits were to be identified and offered. I understand your explanation for why you would not have done that prior, you know, consistent with the pre-hearing order. So I'm not excluding it from consideration as an exhibit. You just have to demonstrate its relevance.
Thank you. No, I appreciate that.
Sure. Yes.
All right, at this point, I'd like to take you to some questions that were deferred to you from yesterday's testimony. Which I thought was right here. Victor Martinez in his testimony was talking about his changes to his calculations of how El Paso Electric would meet the 20% renewable energy requirement in 2023. And he referenced the Buena Vista 2 project as being possibly in commercial operation by the end of January. And when I asked him questions about that, he ended up referring them to you. Is it correct that Buena Vista 2 is not in operation as we speak?
It's not in commercial operation. That's correct as we speak. It's still performing testing.
And what is the nature of the problem that it's not in operation when apparently the NextEra people thought it should be in operation before the end of 2022?
Objection, assumes facts not in evidence. I didn't hear the witness say anything about a problem.
Ms. Souls.
So there's obviously some intertwining of the circumstances regarding Buena Vista 2. It became very relevant to this case because it's critical to El Paso Electric meeting the 2023 RPS requirement of 20%. And so I'm trying to understand if this is a continuing issue with testing or if there's something else that is causing difficulty with this.
I mean, my recollection of the testimony yesterday was that Buena Vista 2 is expected to go online on April 1, and that at 10,400 RECs were being credited from Buena Vista 2 for the remainder of the year. I'm not sure. Can you explain further what your concern is?
My recollection was that Mr. Martinez didn't really know that he had been previously told by the end of January. He was aware that it was not in commercial operation because of testing. He was conservative in his estimates, he said, when he assumed April 1st. And I'd like to know what Mr. Hawkins' estimate is.
Okay, because
And,
actually my notes show that Mr. Martinez reference to Mr. Hawkins was in relation to the Hecate project, not Buena Vista 2, but I might not have noted that down necessarily. And did you have something, Mr. Wexler?
Well, my only point, Madam Hearing Examiner, I apologize for interrupting, is I don't mind Ms. Sewell's asking Mr. Hawkins about his estimate and of when Buena Vista will come online, or whether Mr. Hawkins believes there's a problem, but I don't think it's accurate to say that anybody has testified that there is a problem. If anything, it's going online faster than anticipated.
I'll sustain the objection, but you may, Ms. Souls, ask Mr. Hawkins about when it's anticipated that Buena Vista 2 is going to be in operation.
Mr. Hawkins, would you answer that question, please?
And can you state your question? Sorry.
When do you anticipate Buena Vista 2 to be in commercial operations?
When they resolve whatever issues they're going through as they're looking to bring it to commercial operation.
Are you familiar with what those issues are?
I know there is a communications with the metering between the solar and El Paso's metering that needs to be resolved. And whether that's typical in testing and issues that need to be resolved or unusual, I couldn't tell you. I believe El Paso has its experts out in the field, and Nextera has their experts in the field to resolve the issue.
Are you confident that April 1st will be the latest date that it will be in commercial operation?
If I was a betting man, I would say by April 1st, yes.
And what's the status with Buena Vista 1?
I believe we have updated communication from Nextera saying February 28th of 2023.
And how is it that Buena Vista 1 would be different from Buena Vista 2 at this point?
I'm not sure what you mean by how are they different.
If the communications that you were describing are the issue, is that the same issue for Buena Vista 1 as it is for Buena Vista 2?
To the extent it is, it's probably an issue that they would have an idea on how to resolve once they're bringing Buena Vista 2 online. To the extent there's a difference in the metering, I don't know.
Is Buena Vista 1 connected separately from Buena Vista 2?
I believe they are metered separately, but they do have, I believe it is under one interconnection agreement.
Is it fair to characterize your testimony then that you would expect April 1st to be the outside date for both Buena Vista 1 and Buena Vista 2?
I don't know that I could say that for Buena Vista 2. They're putting something that's a month out. I do know that the amended agreements suggest June 1st. It looks like they're making progress well ahead of that date, but I certainly couldn't foresee whatever issues they're dealing with in the field right now. So do I have a level of confidence on April 1st? It seems reasonable.
Then is it your testimony that you're not really clear what the different issues are for each of them? Is that correct? Is that fair to say?
Which I'm a little confused at what issues you're referring to.
That prevent either Buena Vista 1 or Buena Vista 2 from commercial operations?
I'm not aware of any issues regarding Buena Vista 1 at this point.
And Buena Vista 1 is the large capacity plus battery, correct?
That's correct.
The issues you're aware of are with Buena Vista 2, is that correct?
That's correct.
Very well. That's all my questions for Mr. Hawkins. Mr. Hawkins, thank you.
Thank you, Ms. Souls.
Thank you, Ms. Souls. Mr. Downs?
I have no questions for Mr. Hawkins, Madam Hearing Examiner.
Thank you. Doña Ana County, Mr. Herman?
Nothing for Doña Ana, thank you.
Thank you. And finally, staff, would that be you, Mr. Borman, or?
Yeah, that could be me, and I can confirm that we do not have any questions for Mr. Hawkins.
I do have a couple of questions, Mr. Hawkins. In that most recent exchange with Ms. Souls, with respect to Buena Vista 2, you said something about June 1. Did you mean April 1 or did you mean, or is it in fact June 1?
Well, I believe the amended PPA dates state June 1 as the expected commercial operation date when we executed those agreements last summer.
Okay. All right, but the goal at the current time is April 1. Is that fair to say?
I'm not sure how April 1 came out. Maybe that was Mr. Martinez's testimony. I'm not sure where April 1 came from.
Oh, well, that was my note on Mr. Martinez's testimony. So.
Okay, if
yeah, I can't vouch for that. I don't know. Okay. Well, I think that really that was all I had for you. Thank you.
Thank you very much, Madam Hearing Examiner.
Do you have any redirect, Mr. Olson?
I do not.
Okay, with no redirect, then I believe, Mr. Hawkins, you can be released and we would move on. EPE, do you have any other witnesses?
No further witnesses for EPE.
Okay. Thank you, Mr. Hawkins. And so next we would turn to the Office of the Attorney General, and I believe we'll take a 10-minute break. So we'll be back in 10 minutes, which on my computer, that would be 2:52. On my phone, that would be 2:54. So we're going to go off the record for 10 minutes. Thank you.
Thank you.
Wow. Anastasia.
Madam Hearing Examiner?
Yes, Mr.
I
Herman.
have a conflict at 3 o'clock. I will try to rejoin as soon as I can, but I just wanted to give you notice that if my time for cross-examination comes up, I will waive that cross.
Thank you, Mr. Herman.
I'll send you a email to notify you if I'm in the waiting room
Okay.
to rejoin. Thank you.
All right, we are here in the matter of 22-00093. We're going back on the record for presentation of testimony by the Office of the Attorney General. Mr. Elliott?
Thank you, Madam Hearing Examiner. Is I think Ms. Glick is in the waiting room.
Thank you. I will admit her. And then our first order of business will be to have Ms. Glick sworn by Ms. Gonzalez.
Raise your right hand, please. Oh, there you are. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you.
Good afternoon, Ms. Glick.
Good afternoon.
Do you have what's been marked as OAG Exhibit 1 in front of you?
Yes, I do.
And this is your testimony in the case?
That's correct.
Okay. And was it drafted by you or under your direct supervision?
Yes, it was.
And is your testimony true and accurate to the best of your belief?
Yes, it is.
And if you're asked the same questions today, would you give the same answers under oath?
I would.
And I should have asked sooner, but do you have any corrections to your testimony?
I do not, no.
Great. Madam Hearing Examiner, I pass the witness.
Exhibit 1 is considered admitted. And
Thank
with
you.
respect to cross-examination, EPE. Mr. Wexler.
Yes, Your Honor, I have just a few questions, if I may. Good afternoon, Ms. Glick.
Good afternoon.
I plan to just focus on your recommendations surrounding PPAs and amendments to PPAs. And I want to make sure we have a common understanding about the issues in this case. Can we agree that the purpose of this case is to evaluate EPE's 2022 RPS plan?
Yes.
And as part of this case, EPE is requesting approval of the Carne PPA. Do you understand that?
Yes, I do.
And for that reason, the Carne procurement is at issue in this case. Is that your understanding?
That is my understanding, yes.
Will you agree with me that there has never been an amendment to the Carne PPA?
Not yet.
Let's hope never, but
But yes, I agree.
Yeah, if you look at page 11 of your testimony, lines 9 to 10.
1 second while I get there. Okay, lines 9 through 10, the beginning of an answer?
Correct. And really, I'm just focusing on the case, the consolidated cases of 19-00348 UT and 19-00099-UT, which you referenced there. And you have submitted testimony in that consolidated case. Is that correct?
That is correct.
Some of the testimony that you've submitted in that case is closely aligns with the testimony that you have submitted in this case. Is that correct?
Yes, that's correct.
The issues in that consolidated case, and I won't go through the numbers again, I'll call it the PPA amendments case, is whether the commission should approve of the PPA amendments to Buena Vista's 1 and 2 and Hecate 1 and 2 projects. Is that your understanding?
That is my understanding, yes.
Is it also your understanding that the approval of those PPA amendments for Buena Vista and Hecate are not at issue in the present case, the RPS case?
Yes, I understand that.
All right, with that as a little bit of a background, just a couple questions about your recommendations. And the first one, if you turn to your page 7, your recommendation 2, which is found at lines 15 through 17.
Yes, I see that.
Here's where you're talking about the increased transparency, and we heard some testimony from Mr. Hawkins about that. Now, are you aware that in cases before the commission, the parties have the opportunity to conduct discovery?
Yes.
Did you develop any discovery questions in this case for EPE?
We did file some discovery, yes.
And were you involved in developing those?
I believe so.
Were any of those discovery questions that you were involved in, were they aimed at addressing why the cost of Carne PPA went up?
I'd have to look back, honestly. I don't have them right in front of me.
Did EPE provide answers to the discovery questions as far as you recall?
Yes, as far as I recall, they did.
Do you happen to know how many discovery questions were asked of EPE in this case?
I'm sorry, this case and the Buena Vista were going on at the same time. I really can't separate them out, which ones I asked in which docket.
But yeah, fair enough. Let's turn quickly to your recommendation number 3. And I do want to focus, as Mr. Hawkins did in his testimony, on your phrase about all future PPAs, which shows up on line 18. And so as I take your recommendation number 3, you're making this recommendation not just for purposes of this case and the Carne PPA, but for all future PPAs. Do I understand that correctly?
Yes.
Are you familiar in your work with the concept of a rulemaking?
Yes, I am.
What's your understanding of that procedure?
That dockets are opened to create rules that influence and that, I guess, drive you to like the PUC process. So there's IRP rulemakings, interconnection rulemakings, and so there are matters that are more general across all utilities that are addressed not in individual dockets, but in the rulemaking process.
And those rules then are generally applicable in your experience?
Generally applicable, sorry, could you explain what that means?
Happy to. By that, I mean they apply broadly, not just to a single situation or a single utility.
Yes, that's my understanding, is they apply to whatever situations they explicitly outline that they apply to.
And they also apply prospectively, meaning they apply to any future PPAs in this case. Is that your understanding?
If there was a rule that applied to all future PPAs, then it would apply to all future PPAs. If there's something more specific you're asking, I apologize. I'm not totally following.
That's okay. I think you got to the heart of my question. Have you had a chance to review rules for PPAs in New Mexico?
Is there a specific rulemaking docket you're referring to?
Not a docket. I'm just asking if you've looked at the rules from the commission that govern PPAs. So, for example, we have a rule for LTPPAs, and then we have a rule for RPS procedures. Have you had a chance to review those?
I'm not sure if I have. I did not for this particular docket, but I don't recall if I have in prior dockets.
Let me just ask you generally, as your recommendations apply to prospectively to future PPAs, would you support addressing those issues in a future rulemaking proceeding?
Yes, I would.
Turning to your recommendation number 4, and this is the one about EPA providing additional information about damages, as I understood it, how they're calculated, you say, and the time period for replacement energy. Are you familiar with the provisions of the Carne PPA?
I have reviewed it to the best of my expert and non-legal abilities.
Yeah, I don't intend to ask you any questions. My only question is, based on your review, does the Carne PPA contain provisions going to damages, calculation of damages, replacement energy?
So the PPA does contain quantities of damages, but what it does not contain, in my understanding, is what resources EPE would actually use to replace the energy from, for example, Carne. So would it ramp up your existing gas plants, buy energy at the Palo Verde hub price? Like, what are the actual replacement resources that EPE would use? What are the estimated costs? And therefore, what period of time would the damages cover if Carne doesn't happen, if it's delayed 6 months and EPE has to instead procure alternatives?
And is your idea that, or is your recommendation that type of information would then be presented as part of the hearing procedure?
Yes, because I mean, we've seen many PPAs in New Mexico from EPE around the country being delayed, and when projects are delayed, the company has to procure energy from another source. Those costs are passed on to ratepayers, generally through fuel dockets or other places that are and dockets that are disconnected generally. And it really should be all part of one proceeding so that the risks associated with delays are clear to the commission, to stakeholders from the start. So you understand, are these damages actually sufficient to protect ratepayers from a likely 6-month year delay?
And so is your recommendation that that there would be a condition in the final order that said in a future proceeding addressing PPAs, EPE should be prepared to present the following information as part of its case in chief? Is that what you're thinking?
Yes, in future ones, but I would also like that information provided in this docket so that the commission has an understanding of what level of replacement energy is covered in this current market context. So with current market prices, with current gas prices, with the current resources that the company relies on.
Well, that was one reason I asked you about the discovery process is you had the opportunity to ask for that information. I don't recall if you asked for those specific things or not. But I didn't see any of that information included as part of your testimony. Am I correct, at least about that part?
You're correct. We asked for it in the other docket and did not receive we did not receive that information. And so, I did not ask for it in this docket, but we did not receive it in the concurrent docket when we asked for the identical analysis.
How do you foresee presenting that information as part of this docket?
I see it as informing the commission on whether the damages that are currently in the PPA are sufficient. And that should be part of the commission's evaluation of whether to accept the PPA or whether there needs to be a renegotiation, just to understand what is covered by the damages.
And that helps me understand the purpose, and I appreciate that. I meant to be asking about how do you, as a procedural matter, foresee that information being presented in this case?
So unfortunately, I don't know. I'm not a legal expert, so I don't know I could say exactly the best way to do that. You'd probably be a better person to suggest where it could best be incorporated if you believe it's something the company can provide or would be useful in this process.
My last question has to do with or a couple of questions has to do with recommendation number 5. And here you're asking about or making a recommendation about increased oversight. And my general question is, what is it well, first let me ask, do you understand that there is some oversight that EPE currently exercises over PPAs or the development of PPA projects?
Yes, I do understand there is some level of oversight currently.
My question is, what additional oversight is it that you're discussing or describing here?
So in my experience, there's different levels of oversight from different companies in PPAs. So in generally, the oversight that is transparent does not occur until construction starts usually. So I know there's construction reports. So for like the Buena Vista project, for example, there were several construction reports provided, but for the Hecate project where construction has not yet started, I did not see any sort of documentation of the oversight the company has provided, actions the company has taken. So it was not clear to me if there is consistency in what the company is doing, both prior to construction and during construction, to conduct oversight and then communicate that oversight to the commission across all different projects. It seemed to me that it was mostly concentrated after construction started.
I see. Is that kind of guidance to utilities about the oversight that they should do both before and after construction begins, is that the sort of thing that could be included within a rulemaking proceeding?
Yeah, I believe that would be a good place for it as well.
Thank you. I have no further questions.
Thank you.
Thank you. Ms. Soul, or I'm sorry, City of Las Cruces, Ms. Stevens, do you have any cross-examination?
I do, thank you. Good afternoon, Ms. Glick. How are you?
I'm good. How are you?
I'm good. I have just a few questions for you, and I'm going to start with where you and Mr. Wexler were at. You indicated that you have read the contract, the contracts in this case, and it seems that your testimony and your recommendations center around the contractual terms. Is that correct?
Testimony focuses on recommendations for terms to amend.
Now, what about the contract itself? I mean, are you concerned? The damages provisions, I guess you're concerned about. Did you hear Ms. Solz's cross-examination of Mr. Hawkins a little while ago about the damages provisions?
Yes, I was listening during that exchange.
Okay. The delay clauses. Are you concerned, having read these contracts, that there were provisions in those contracts that would allow delays of at least 360 days for various reasons without any access to delay damages?
Sorry, so can you ask again? Let
me start first. Do you understand from the terms of the contract itself and from the testimony you've heard already that there are extension provisions that preclude EPE from recovering damages, and there are 180 days relating to force majeure and another 180 days regarding interconnection issues? And under those circumstances and possibly others, the quantum of available damages doesn't really matter much, because if the availability of damages is extended, you don't have damages. That's what I'm asking you. But you do appreciate that concept, that it doesn't matter how high the damages are if they're not accessible because of the terms of the contract.
Well, I don't know if I agree with the premise of the whole question, but I understand there are like if you're asking me if I understand there are damages provisions and there are different provisions, I can agree that yes, but there was some editorializing in there that I don't know that I want to necessarily say I agree with. I apologize.
So let me go. So the damages provisions, are you aware, have you given some thought to the section 3.6.1 provisions that were discussed earlier this afternoon that would extend the deadline dates, or extend the dates at which the delay damages would essentially kick in?
Can you, sorry, say that section again? I would need to navigate.
3.6.1?
3.6.1?
Yes.
It's in EPE
It's in
exhibit,
Victor Martinez's testimony, EP3.
EPE exhibit 3, and it would be at page 454 of 821.
You're really.
I have exhibit 4. Am I looking in the wrong document? Oh, exhibit 3. Yes, exhibit 4.
Would be it. That's it. Yeah.
Okay, 3.3.
3.6.1.
3.6. I am in 3.6. The extension.
Right. Do you understand that if one or both of those extension provisions were applicable, that there would be no delay damages in any dollar amount recoverable?
I have to read this. I haven't memorized. I apologize. I have to take a second to read this. I have not memorized the provisions. Okay, yes, I understand these are extensions without damages.
So your pre-file testimony, maybe I'm misreading it, but it seems to focus on the amount of damages available and the duration for which you could obtain damages. I just was wondering to what extent the possibility of them being pushed back or pushed so far back by an extension that they never are available. How does that play into your recommendations?
So my recommendation 3 on page 7 of my testimony, which was focused on renegotiating the commercial operation date, it does not use the exact language, but it's based on basically this is aimed at targeting extensions that occur outside of damages provisions. So under the Buena Vista and Hecate PPAs, there was a original commercial operation date and then a negotiated one, I believe. I think it went from May to December, and that occurred without damages. So this recommendation 3 is intended to address the extensions without amendments, without damages. So if that is what that section is referring to in the PPA, that's what this recommendation is also referring to. And the estimation of the costs of this delay and the cost of replacement resources is also, I also recommend that even without amendments and damages in this recommendation.
And without asking to give a legal opinion, because if the commission approves the contract as EPE is asking them to do, and that provision is in there, those delayed provisions, those extension provisions are in there, what would ratepayers, what would customers gain from your recommendation number 3?
Well, recommendations 3 says in this and all future PPAs. So there would be an understanding of what level of extension, what the cost of the extension incurs. And that should allow the commission to understand whether this language in this current PPA is acceptable or not. My testimony was focused. Go ahead.
No, I'm not supposed to interrupt you. Please go on.
No. So I don't believe the purpose of this case is to consider whether the PPA as it is acceptable, or if there should be changes to the language. This recommendation is laying out changes that should be made to increase protection to ratepayers.
So is it your opinion then that with these provisions, with the provision you're looking at and the other provisions that you've read, that this contract has adequate protections and should be approved by the commission?
No, so I base my testimony has 2 purposes. The first is to lay out the additional protections that I believe ideally should be incorporated into the PPA. But my second purpose is to recommend, even if there are no changes, is to still recommend acceptance of the project based on my understanding of the risks and costs of alternatives. So the testimony has 2 purposes. It's to say, how can we protect ratepayers and make it better, but also to answer the question, based on where we are right now, what is the best action to protect ratepayers from future risk and future price increases of gas and of market prices.
So basically you're saying that your reporting provisions are not a condition of approval of the AG supporting approval of the Carney contract?
No, we strongly recommend that the commission recommend and encourage modifications be made to the PPA. But it is still my opinion that even without any of these amendments, ratepayers will still be better off than if the Carney project is not accepted. Now, I do think that ratepayers will be much better off with additional protections. So in my mind, there are ratepayers will be better off if there are more protections in this PPA and future PPAs. But given the alternatives, unfortunately, I do think that moving forward with this project will protect ratepayers better than continuing to rely on the market or on the company's existing gas plants.
And what is the standard that you used in determining it? It sounds like you just said relying. Do you see you said relying on existing gas plants?
Yeah. So I've done analysis in the Buena Vista and Hecate docket. I've done analysis for the Tucson Electric Power Company's rate case, where I looked at the cost of current solar PPAs, and I looked at the cost of Palo Verde Market Energy and the cost of gas that regional companies are paying, and the risks that are facing existing gas plants and coal plants as they age and they shut down. And then the company has to scramble. And so I did not do the specific analysis in this particular docket, but I've done analysis in New Mexico and in Arizona and other parts of the country that answer this same question, and that really show that the implicit assumption that the status quo, that continuing to rely on the existing resources is the lowest risk, is no longer true. We can't continue to procure resources exactly when we need them and assume they're going to be online, because projects are delayed, supply chains are messed up. So this project might not be perfect, but I see it as an insurance policy, because the costs and the risks of continuing to rely on the status quo, on the existing gas plants, on market energy, which is very expensive and minimally available, it's just much higher risk for EPE's ratepayers.
Tell me what you know about EPE's existing gas plants.
I know there are 4. I know several of them are quite old, and several. I know there are a couple that are newer, but especially the older ones, I know that they're not fully utilized, so they can be ramped up more if necessary. But they are, I mean, I'd have to look at the IRP to get the specifics on the size of each one and the exact age. But I know they're not, in my mind, it's not an ideal strategy to ramp up those power plants instead of building a new solar and battery storage facility.
You mentioned the need. Do you have the IRP, the Integrated Resource Plan? Is your support for this project based on EPE's Integrated Resource Plan?
I looked at the resource plan, but no. So need is both an economic construct and a physical construct. So if you don't have enough capacity resources physically, you need more resources. But if you can supply energy more cost effectively and more economically than an existing resource, so if you can, for example, bring online a solar PPA that provides energy at a lower cost than operating the company's existing plants, that's also meets a need. In Martinez's testimony, I believe one of the exhibits was the 2021 Renewable Energy Plan filing, and it had in it a table, and I can point us to the exact source if you'd like, that showed the dollar per megawatt cost of operating the company's current units. And they're all very high, and I believe they're all higher than the current, the LCOE of the Carne PPA.
Why don't you take us there? I'd like to see that.
Sure, I would be.
I
So it's
was not seeing anything quantitative in your analysis.
Sure. No, I'm happy to. It's exhibit 1, we're in EPE exhibit 3. And in there's a Renewable Energy Act procurement plan, and it is on page, sorry, I had it earlier. It may take me a second to find it.
If I may, and I apologize for interrupting, but as an attachment to Victor Martinez's testimony, which is EPE Exhibit 3, and then I'm looking at page 437 of 821 is what's entitled the 2022 New Mexico Renewable Energy Act Procurement Plan. I don't know if that's what you're referring to.
Page 437.
That's right.
I only see 309 pages in the EPE exhibit. Oh, you know what? I think I need to open the second document. I think that's why I'm struggling here. Wait, sorry, exhibit 3, I only see 309 pages. Am I doing something wrong here?
Ms. Cliff explained that the stamping is different from the number of the PDF numbers because the company took a big application and chopped it into little pieces. It's difficult.
That's right. Yeah.
Can you say the page number again?
If you're using the date stamp numbers at the bottom left-hand corner, it's page 437.
Yeah, I'm not seeing what I was looking at. I apologize. It was I should have prepared it. I apologize.
Could it have been?
Oh, no, I'm sorry. It's in novellas. It's in a different
Novella. I was
testimony.
going to say, could it be an attachment to novellas?
Wait. Two of you are talking at once. So I have that it's in Miss Witness, it's in novellas, and then I don't know what you were saying, Miss Stevens, if you have something.
Oh, yeah, I was just going to say, it looks like it's in novellas.
Yes, my apologies for that wild goose chase. It is in novellas. It is, let's see, Bates page number 52 of 821, table 2.
And is it and are you looking at the fuel column or the operating column or the capital column or the total cost column?
Yeah, so if you add the fuel and the operating O&M, you would get the variable cost. So the total cost would be basically equivalent to the cost of the solar project and the battery storage project together. So you could compare that to the entire project LCOE. But even if you were just looking at the cost of the solar PPA on a marginal basis to say how much is each incremental megawatt hour of solar electricity, you compare that to the fuel and operating cost, you can see that all of those costs are significantly higher than the solar PPA for the variable cost, and the total cost is significantly higher than the solar and battery storage project combined, the LCOE. So when I look at what are the alternative resources that EPE has to rely on, and these are some of them, they're quite expensive. And in my mind, this is concerning. This is the alternative.
And do you know what EPE is EPE proposing in this case to remove any of these existing plants from service and from base rates?
That's not part of this case.
So there's no plan to do that. Is that right?
No, not that I know of.
Does that mean that New Mexico customers will be continuing to pay the on this table the capital and the operating costs until some sort of abandonment case is concluded?
The capital, I'm not sure on the operating if that's all variable or if there's a level of fixed O&M, but what would be avoided would be the fuel costs and the variable O&M component, which I assume is a part of the operating dollar per megawatt hour. So the capital costs, you're correct, would be incurred regardless of how often the plant is operated.
Do you believe that is it your understanding that in New Mexico, the operating costs are passed through a fuel clause on an ongoing basis or embedded in base rates?
It's my understanding that O&M costs are in rates. They're not in rate base, that they are in rates, not in fuel dockets.
So until those plants are removed from service, if totally and finally, would you then the net savings, if it's actually all realized to New Mexico customers on a one-for-one basis, would be based on the fuel column here?
So the savings, if you reduce use of the gas plants, then you reduce the variable costs. And the variable costs are composed of the fuel costs, which are recovered through fuel dockets, and the variable operating costs, which are recovered through rate cases. So it is those variable costs that would be avoided.
Now, would those variable costs be avoided until the next rate case after those plants are actually removed from service?
So it's my understanding that fuel costs are reconciled during fuel dockets at a regular basis. I don't know if it's every year or how often, but variable costs are reconciled through rate cases. And while they might be set at current rates, they will be changed in the next rate case to reflect the actual updated operating costs.
Okay. So did you apply in your analysis, did you take into consideration the specific requirements of either Rule 551 on long-term PPAs or Rule 572 on Renewable Energy Act procurement plans?
I don't believe my testimony references those rules in any way.
So you did not try to fit compare EP's application to either of those commission established standards, did you?
I don't believe my testimony touches on those at all.
Did you make any conclusions about the need for the capacity to be provided by Carney?
I did not make any conclusions in my testimony on that, no.
Did you make any did you do any analysis of the need for capacity?
No, I did not. But as I said earlier, I can easily look at a load and resource table, but the decision to procure new resources should not be based on matching perfectly the megawatts of capacity needed at the exact moment, because that's a recipe for things delaying and then not having what you need in the timeline that you need.
Did you evaluate the need for energy, additional energy?
I looked at the load and resources table. I did not discuss that in my testimony, though.
The loads and resources table, did you look at the energy or just the capacity? And the traditional loads and resources focuses on capacity, is that right?
There are, I can look in Mr. Martinez's testimony and tell you which tables I looked at. I don't remember off the top of my head what number they are.
Sure, tell me.
Sure, it'll take me a few minutes to find it. 1 second.
Ms. Stevens, where are you going with this? Because
Okay.
Ms. Glick has testified that she has not reviewed a number of these items for purposes of preparing her testimony.
Well, I want to know whether I guess I'm thinking maybe she should have, and I'd like to know why she reached the conclusion to approve this absent that sort of analysis.
Well, because as I stated earlier, my conclusions are not based entirely on perfectly matching energy and capacity needs to the exact year. It's based on understanding the risks and the fact that the cost, so need is not just based on capacity, it's also based on energy. If you can provide energy at a lower cost through Carney than the company's existing resources, then that is a benefit. The battery storage is essential for shoring up renewables both now and into the future, and you reduce curtailments, and therefore you have additional energy available from the solar relative to what you would have before. So I certainly appreciate, I do a lot of integrated resource planning too. I am an IRP expert. I absolutely appreciate the role of understanding capacity and energy needs, but that alone is not the only factor to consider in deciding what resources to bring online and when.
And getting back, and did you address the specific need for RECs, renewable energy credits, certificates under the New Mexico Renewable Energy Act?
No, I did not discuss those in my testimony.
Did you consider them in your analysis leading to your testimony?
Ms. Stevens, I would really ask you, if Ms. Glick states that she did not include that in her testimony, then you're going beyond the scope of her direct testimony.
Okay.
So cross-examination should be limited to the scope of the direct testimony.
Did you look at cost other than, you talk about alternatives in Arizona and PNM, I think. Did you look at it at cost else in other jurisdictions?
Can you be more specific on costs of what?
Cost of, I think you basically concluded that this is a well-priced project, isn't it?
I concluded that this project is lower cost than alternatives available to EPE ratepayers. I did not say that it was necessarily lower cost than PNM's projects or other projects.
Okay, and if that were a requirement under the Renewable Energy Act that you did not address, would that be an item of concern?
I didn't know there was a requirement under the REA Act that projects be cheaper than PNM's projects. I guess I'm not clear on what you're asking me.
We'll just look at the act, since you said you can renew it. If you review it, there's nowhere else to go. So I'll just thank you and bye.
Thank you.
Thank you, Ms. Stevens. Ms. Souls, do you have any cross-examination for Ms. Glick?
Yes, ma'am, I do. Excuse me. Good afternoon, Ms. Glick.
Good
My name
evening.
is-
It's evening for me out here on the West Coast and the East Coast.
I'm Mary Lee Souls. I'm a pro se party in this proceeding. And I'd like to ask you to go to page 7 in your recommendation number 3.
Give me 1 second. I've got too many documents here now. Page 7, number 3. Yes.
And I know Ms. Stevens asked you questions here, but maybe we could summarize it. Did you find the Carne PPA and ESA to sufficiently limit risk to ratepayers?
That's a very broad question. I don't think any document can thoroughly alleviate risk. It's about the balance between the risks and the costs of the project.
Very well. What then is your understanding of the conditions provided for in the Carne PPA under which the commercial operation date could change without breaching the contract or incurring damages or otherwise requiring a formal PPA amendment as you recommend here?
Formal PPA what? I'm sorry.
Amendment, as she recommends right there.
So going back to the section of the PPA that I was just reviewing with Ms. Stevens, there was language that indicated, I believe, there were certain force majeure conditions and interconnection conditions. These were similar to what I believe were in one of the Buena Vista or Hecate PPAs, but I was concerned that in that docket, it wasn't clear why the COD was being extended from the original one. So their conditions are outlined, but in my mind, it's not clear that the company has to report on why it's extending or which of those conditions have happened and why the COD is being extended and what the potential costs are to the ratepayers of that extended COD without damages within the current document.
So would you agree that your testimony references conditions under which renegotiation would take place?
So I use the term renegotiation, and I apologize if it's imprecise. I believe that was the language that was used in the Buena Vista case to indicate the COD being changed from the original COD without an amendment. So it was renegotiated within the original PPA without a PPA amendment. That's what I'm referring to as a renegotiated date.
And we're talking about the Carne PPA. Would you
Right.
agree it has different
Yes.
language?
Right, it has different language.
And so I'm trying to understand, do you mean that term conditions under which renegotiation is permitted? Do you mean that to reference a renegotiation or all of these conditions for extension of the commercial operation date?
Sorry, I don't understand what your question is.
Would you agree that the Carne PPA does not require a renegotiation or extension of the commercial operation date?
Could, Madam Hearing Examiner, I would just ask that Ms. Sewells be more specific. Under what circumstances specific?
Let's go to this section 3.6 extension in the Carne PPA, not the Buena Vista PPA, the Carne PPA.
.6.
I believe this is what you looked at before when you were speaking with Ms. Stevens.
I'm sorry, please repeat. I'm sorry.
I believe this is where you were looking before in your conversation with Ms. Stevens. It's Bates, page 484 of 821.
Yep, I am there. Sorry, I had navigated away in my wild goose chase for the other document.
And in this section 3.6 extension, do you see the term renegotiation?
So, sorry, I'm not trying to argue about semantics. I am concerned about the ability to change the COD within the existing contract. If you want to use the word change, I think I'm in agreement with you that it's concerning that something can be changed. So I don't want to get caught up on if the word renegotiate is making you uneasy. I can use the word change. I'm concerned about changes within the existing PPA of the COD without damages, without a new amendment.
Let's work on the language again, because do you understand that an extension of the COD is a change to the PPA?
I take your word at that. I'm not a legal expert. I'm not a lawyer. So if that's what you're saying, I believe you.
Ms. Souls, I'm concerned that you're asking Ms. Glick to reach a legal conclusion. I mean, it's a contract document and its interpretation, I think Mr. Hawkins appropriately described as being subject to legal interpretation.
Yes, ma'am, and I'm not an attorney either, though I often feel the victim of these very specific language things, which is why I'm trying to get clarity from Ms. Glick as to what she means.
I mean that I'm concerned about changing the COD in this for Carne without damages and without an official amendment. That is exactly what I mean. If there's more legal implications to that I don't understand, then you can get mad at me for not being a lawyer, but that I don't know how to be more explicit than that.
Thank you for that. Yes, without renegotiating and without amendments. There's another part of this that I wanted to bring to your attention.
Sorry, you stepped away from the mic. I couldn't hear you.
Yeah, I'm juggling a lot. On the next page, there's this section about solar capacity shortfall damages.
We're back on to Ms. Glick's testimony.
Well, it's related to damages, and therefore, yes, I do believe that this is related to her testimony.
Yeah, I'm just asking what page we're looking at.
Oh, I'm sorry. The next page in the PPA, section 3.8.
Oh, okay. Sorry, I went back to my testimony. Okay, 3.8, yes.
Did you review this paragraph as you were preparing your analysis and testimony?
The solar capacity shortfall damages?
Yes, ma'am.
I believe I did.
Would you take a moment and refresh your memory about this?
Sure. Yeah, I've reviewed it.
All right. And do you see the additional 180 days after the commercial operations date that it is allowing operation with less than the full 130 megawatts without damages? Do you read it that way?
I see that's written in here, yes.
So I want to take you through whether this is your understanding of what these provisions would mean.
Madam Pearlington, I just go back to the statement that you made earlier, which is that we stay within the scope of Ms. Glick's testimony and not ask her to opine on specific provisions that aren't addressed in her testimony.
I'm going to allow this, but very limited, Ms. Souls. My other concern is whether or not this is friendly cross-examination, which is prohibited under the terms of our pre-hearing order.
Madam Hearing Examiner, if El Paso Electric was allowed to cross-examine when Ms. Glick is basically recommending acceptance of everything, how is this friendly cross-examination?
Well, you appear to be asking Ms. Glick to testify with respect to I think confirming your concerns about whether or not the PPA should include provisions for extensions of the COD under specifically identified conditions, and in some instances allowing those extensions of the COD without damages. And so
It's
she
my-
has expressed a concern about that, and so you seem to be asking her questions that are in support of her testimony of those concerns.
I understood Ms. Glick to testify that even though she was concerned, she is recommending that the commission accept this PPA as it is. And my position is the PPA is inadequate and cannot be accepted as it is. I don't think that's friendly cross.
Okay, I appreciate that. So your question, why don't you repeat your question? Or we can ask Ms. Gonzalez to play it back.
I hadn't gotten to my question, I don't think. Very well.
Okay, well then, why don't you ask your question?
So Ms. Glick, you understand that at the moment, the expected commercial operation date is identified as May 1st, 2025. Is that correct?
Yes.
And that these provisions for extension would allow 180-day extension without damages to take it past the critical summer period in 2025. Is that correct?
I haven't interpreted this clause. I mean, I accept that it's very likely the interpretation, but I'm not a legal expert. So asking me to interpret provisions of the PPA I haven't written testimony on would just be in my opinion. It wouldn't be anything legally binding.
Then let's just talk about a 180-day delay without damages as provided in that section on extension. Would you agree that takes it from the May 1st date to a November 1st date without damages?
That sounds about right for 180 days.
And you would expect that that summer period is when the greatest cost burden to New Mexico ratepayers would occur. Is that correct?
Yes. Yes.
So do you find that acceptable?
I find that suboptimal relative to a PPA that had more protections, but I also recognize there is a trade-off between risks and costs and that they have to be taken in totality of this PPA. So I don't disagree that perhaps that particular provision would be, the ratepayers would be protected if that particular provision was changed. But the reason that I don't think the entire PPA should be thrown out, even if there are no changes made, is it's my assessment that even this not great PPA is still better than the alternative. I don't disagree that there are many changes that would improve this and improve protection to ratepayers.
What protections did you find for ratepayers in this PPA?
There are damages in this PPA. I mean, I'm not a legal expert, but there are provisions that provide some level of damages that would cover some level of replacement energy.
Would you conclude that this Carne PPA provides more protection, less protection, the same protection as the Buena Vista PPA that you referenced earlier?
I didn't do the analysis for this particular PPA on the comparing the damages to replacement energy. I certainly could do that analysis. It's relatively straightforward. As I put in my testimony, I prefer if the company did that analysis, but it wouldn't be that hard to compare the damages in this PPA to those in the Carne and Buena Vista ones. You just have to have a common assumptions around the cost of, the Palo Verde price hubs or the gas prices for the company's existing gas plants.
And in all of what you read and heard in this case, has anybody done that calculation?
The calculation on the cost of replacement?
What
No.
the risk, quantify
No.
the risk to payers? Very well.
No.
Quantify I'm sorry.
Quantify the risk to ratepayers. I may be about done. Let me make sure, please. Would you go to paragraph 1.3.2 in the Carne contract?
In the what?
The Carne contract, the Carne PPA?
1.3.1, you said?
Correct. 1.3.2.
Oh, 0.2. Okay.
Had you recognized this particular paragraph previously?
This is about an interconnection agreement. My testimony did not touch on the interconnection agreement.
And do you see that this is related to the transmission provider? Do you understand that to be El Paso Electric?
My testimony didn't have anything to do with this provision of the PPA. I'm sorry.
Very well. One more minute. I think I'm almost done. I'm done with my questions. Thank you, Ms. Blake. Thank you, Madam
Ms.
Hearing.
Sills.
Thank you, Ms. Souls. Mr. Downs, any questions for Ms.
No,
Glick?
ma'am, I have no question. I have no questions for Mr. Clerk. Thank you.
Doña Ana County, I don't see that. Let's see. I don't see that Mr. Herman is back online yet. Well, let me make sure he's not in the waiting room. No. Okay, so we'll move forward then to staff.
Staff has no questions for Ms. Glick.
Okay, thank you. Just I don't believe I have any questions for Ms. Glick. Mr. Elliott, is there any redirect?
There is not.
All right, in the circumstance, Ms. Glick, I believe you may be released, and thank you for your testimony today.
Thank you.
Mr. Elliott, does the Attorney General have anything further to present for its case?
We do not. Thank you, Madam Hearing Examiner.
Thank you. We would now turn to the City of Las Cruces. Ms. Stevens, sorry. It appears Ms. Stevens is in the waiting room and I'm just readmitting her now. Hi, Ms. Stevens.
Madam Hearing Examiner, I'm gonna
Yes.
have to ask to be excused as well to join another meeting.
That's fine, Mr. Elliott. Of course, you understand the conditions, which is that you would not be able to cross-examine or object to any portions of testimony that you weren't present for.
Yes, and I agree to those conditions, and thank you very much.
You're welcome. Thank you, Mr. Elliott. Ms. Stevens, I believe we are now on your case. Or the presentation of your
Yeah,
case.
and do you have Ed Reyes in your waiting room, or do I need to send him a?
He is not in the waiting room.
Okay. I know he's expecting to be on this afternoon, so I don't know where I've lost him. Hold on.
Well, we're going to take a 5-minute break
Okay.
while you get Mr. Reyes online. So we're going to go off the record and we'll reconvene in 5 minutes. All right, we are going to reconvene in the matter of 22-00093 UT. I believe we have our next witness, Edwin Reyes, for the city of Las Cruces. Ms. Gonzalez, could you swear in Mr. Reyes?
Certainly. Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Mr. Reyes. Would you please state your full name for the record?
Edwin Reyes Jr.
And what is your profession?
I'm an energy consultant.
Did you submit pre-filed direct testimony in this case on behalf of the city of Las Cruces?
Yes, I did.
And is the document in front of you marked CLC Exhibit Number 2, your pre-filed direct testimony filed on January 9th, 2023?
Yes.
Was that testimony prepared by you or under your direct supervision?
Yes.
Are there any changes that were made in the document that was uploaded after you filed it?
No, ma'am.
And are there any changes that you need to make right now?
No substantial changes, no.
If I were to ask you the same questions today, would your answers under oath be the same?
Yes, they would.
And is your testimony true and correct to the best of your knowledge?
Yes, it is.
With that, I offer Mr. Reyes for cross-examination because I believe his testimony has already been admitted.
That is correct. So for cross-examination, we would start with El Paso Electric, Ms. Olson.
Good morning or good afternoon, Mr. Reyes.
Good afternoon, Ms. Olson.
Sitting in this chair for a long time and the hours are passing and I have no idea what time it is. So I'm just going to start with the beginning of your testimony. I'll refer to the Bates numbers in the bottom left-hand corner, which I think are 2 pages ahead of the page numbers. I'm going to try to stick to that convention. So starting with Bates, page 3 of your direct testimony, you identify the purpose and you state generally that you're addressing certain aspects of EPE's request for approval of its 2022 plan and revised RPS cost rider and whether that request, and I'm quoting this, complies with rules, orders, and requirements of the commission. Is that fair representation?
That's fair.
And by certain aspects, are you referring to EPE's request for approval of the Kearney project?
Yes.
And what are the rules, orders, and requirements of the commission you're referring to?
The rules around the procurement of renewables and the requirements of the REA.
Okay. If we move to page 10. Oops. I'm getting myself confused. Bates, page 10 of your testimony.
Okay.
And starting on line 8 there, you answer the question of what your testimony addresses. And you raise 2 issues. The first I'm going to talk with you about is EPE's proposal to include the Kearney storage ESA as part of EPE's REA plan and to recover the capacity related charges incurred under the ESA through the RPS cost rider. Your ultimate recommendation is that EPE be required to refile its application for approval of the Kearney project as an application for CCN or approval of the PPA as defined in Rule 17.9.551. Is that correct?
Correct.
And when you say as defined in Rule 17.9.551, are you referring to the definition of PPA provided in that rule?
Yes, a long-term PPA for the purpose of serving load.
Of certain what? I'm sorry.
serving load.
And you recognize that the Kearney project is a renewable energy resource as defined under the REA. I think that's it. Page 10, lines 8 through 12, correct?
I do.
Is the basis for asking for this project to be denied in this proceeding and refiled under 551 because under the Renewable Energy Act, EPE would have the option to recover the capacity charges through the cost rider?
Correct.
And you contend, I think we're looking at page 10 here, lines 15 through 16, that the writers only meant to recover the cost of renewable energy being provided to comply with the REA. Is that a fair summary?
That is essentially correct. Yes, it's essentially meant to recover renewable energy costs.
Okay. And are you aware that the legislature defined renewable energy under the REA?
Yes,
And are you familiar with the provisions of both the REA and by REA, I'm referring to the New Mexico Renewable Energy Act, and Commission Rule 572, which is 17.9.572 and MAC. Are you familiar with the provisions of the REA and Rule 572 authorizing cost recovery?
yes,
And so you recognize that the REA and Rule 572 authorize recovery of reasonable costs of complying with RPS?
yes,
And under that rule provision, costs consistent with an approved REA plan are deemed to be reasonable?
ask the question again.
That under Rule 572, costs consistent with a commission-approved Renewable Energy Act plan are deemed to be reasonable?
I mean, they're not automatically deemed to be reasonable. They're deemed to be reasonable within the reasonable cost threshold.
I'm sorry, reasonable.
Cost threshold. And they're not deemed to be reasonable if it was $500 a megawatt hour. I don't think we would deem that to be reasonable, even if you had it in your plan.
Okay, but are you familiar with that rule provision? Can we agree that the rule says what it says?
We can agree that the rule says what it says.
Okay. Are you familiar with the procurement costs that EPE includes in its cost rider?
For this project and a couple others, not every project that's been included, no.
But I'm talking about the procurement costs that have been identified by EPE for recovery in the 2023 cost rider.
Yes,
You're familiar with those costs?
correct.
And you agree it includes things like Regis fees?
Yes,
And costs for rec purchases under commission approved rec purchase program?
yes.
Okay. And I want to turn to the second issue you addressed, which is pricing of the battery storage under the ESA, the energy storage agreement.
Mhm.
In your opinion on the battery storage cost is largely informed by price proposals received by PNM that are discussed at page 17 to 18 of your testimony.
Yes.
And your testimony on those pages state that those price proposals received by PNM were, I think you used the term virtually contemporaneous with EPE's BAFO process.
I'm sorry, describe that again.
Yeah, if it helps, I'm looking at page 17 of 25,
Okay,
lines 20 through 21.
correct.
And you describe those price proposals as being received by PNM virtually contemporaneous with EPE's BAFO process.
Yeah, the renegotiations that were going on with under the one of the PNM replacement processes. I don't remember the docket number off the top of my head, but there were two separate dockets. One docket was for the replacement of their Palo Verde 3 lease, and those were essentially going on based on the information that was provided in this docket, going on at about the same time when this was being renegotiated.
Okay, and are you involved in that PNM proceeding?
Not as a, no, I'm not as an intervener. I'm actually, I am actually working with the developer and with the Hickory Apache Nation on development of one of the facilities that was initially proposed as a replacement resource under that docket. And unfortunately, as it turns out, it was one of the resources that was repriced in the renegotiation and was not accepted due to the price increase.
Okay, so you're aware that, I think this is what you were just saying, that those resources were initially approved in February 2021.
Yes.
And so the RFP process to obtain those resources presented in that proceeding would have been issued sometime before that, correct?
I believe those RFPs were issued, published and released back in 2019.
Okay. Those are all the questions I have. Thank you, Mr. Reyes.
Okay, thank you, Ms. Olson. We would turn next to the city of Las Cruces.
No,
Oh, I'm sorry, to Ms. Souls. Sorry, Ms. Stevens. This is your witness, Ms.
yeah, and
Ms.
I'm sorry
Souls.
because I'm having camera problems.
I have no questions for Mr. Reyes.
Thank you, Ms. Souls. Mr. Downs?
I have no questions either. Thank you, Madam Hearing Examiner.
Doña Ana County, Mr. Herman.
Nothing from Mr. Reyes. Thank you.
Finally, Utility Division staff.
Gloria Regensburg here, Madam Hearing Examiner. We have no questions. Thank you.
All right. Is there any redirect, Ms. Stevens, based on
I have a couple of questions. I have a couple of questions. Do you hear me? I have a couple of questions, and I apologize. My camera is kind of going in and out. I'm afraid. I hope I'm not losing connectivity altogether. Mr. Reyes, there you are. Relatively early in her cross-examination of you, Ms. Olson asked whether the basis of your recommendation, was the basis of your recommendation was because of the opportunity to recover, recommendation that the Carne ESA be treated separately. And I've understood your answer to be, question to be, is the basis for the recommendation because of the opportunity to recover costs through the RPS cost rider, and you seem to assent to that. My question for you is the only reason that that you challenged the battery cost, the battery portion of this PPA because of the cost recovery methodology? And I guess
no, and I think that's where we were going at the very end of the questions with Ms. Olson with respect to the price level of the ESA. The ESA is roughly $2.77 a kW month higher than one that was done by PNM. and others that I've seen as well that were significantly lower, and don't include a price adjuster for the cost of lithium. So at this particular time, it doesn't seem like a a prudent time to be adding battery storage, given that there are supply constraints. There seems to be significant inflation in most of the inputs, and the project wouldn't be online for another couple of years anyway. So in the 2 years that would it would take to get that project online, by the time we get to 2025, significant changes are going to be happening in the supply chain, and we'll expect significant changes in general inflation. So it just didn't seem to me that this is the right time, and as we did state, the right venue to be collecting capacity charges in an RPS rider.
And if I could direct you to your direct testimony at page 14 of 25 or page 12, can you explain why the capacity purchase aspect of the Carney ESA creates a reason why the proposal should not be considered through the RPS requirements, the REA requirements?
Yeah, well, the ESA itself is a capacity resource. The battery is a capacity resource. It doesn't generate renewable energy. In fact, it consumes renewable energy. It provides system resource. It provides system support. It does provide other ancillary services, but it's not an energy. It's not an energy resource. And for that matter, it seems more appropriate to have it admitted as a resource for capacity under a CCN rather than under the RPS. If you separate the energy that's going to be provided under the ESA from the battery system, you end up with a much higher cost energy resource or resource itself. The energy that would end up coming out of that facility would be significantly higher than the reasonable cost threshold if you separate that out from the solar facility itself. I mean, the solar facility is at $29.96 or $30 a megawatt hour, and once you add the $11 a kW month, if that's what it ends up being after potential adjustments for lithium, then you end up significantly over the reasonable cost threshold for the energy that's coming out of the battery facility on a 4-hour dispatch a day on 365 days a year. So that's the reason that I just believe that those particular resources, battery resources, ought to be separated. Now, I do understand that there are tax implications and other issues around that, but with the investment, with the IRA the Inflation Reduction Act, there are different ways to handle the tax credit issue.
Is there any evidence in this case that pairing battery storage with renewable energy, with solar PV, is necessary to meet the RPS requirements under the Renewable Energy Act?
This testimony is going way beyond the scope of my cross-examination.
Well, I'm going to allow a little bit of leeway on this, but do try to stay within the scope of the cross, Ms. Stevens. But you can go ahead with his question.
Okay, please, can you repeat that?
Yeah, is there any evidence that you've seen in this record that shows that the pairing of the battery with renewables is necessary to achieve the renewable energy requirements of the Renewable Energy Act for El Paso Electric Company?
No.
Thank you. Good. Madam Hearing
anything?
Examiner?
You don't have any, is that, does
That's
that
it.
conclude your redirect, Ms.
That
Stevens?
concludes my cross, unless there's something that follows up. Direct. I don't know whether Miss.
I do not have any questions for Mr. Reyes. Thank you. So I think Mr. Reyes can be released and your next witness can be called.
Thank you, Madam Hearing Examiner.
Thank you,
Mr.
Madam
Reyes.
Hearing Examiner. Thank you, Mr. Reyes. Released. It sounds like you're getting out of jail.
Thank you.
And if he's in your waiting room, the city would like to call Jose Provencio.
I don't see anyone in the waiting room. You want to,
I know he's been watching on Zoom. Let me send him a text message. Take a second.
I do want to let everyone know that we will be ending at 5 today. So we'll have to stop a few minutes before 5 to discuss the remaining witnesses and scheduling. But I hope hopefully we can get a good start or even complete Mr. Provencio's testimony. He's in the waiting room now, so I'll admit him.
Good afternoon.
Good afternoon, Mr. Provencio.
Good afternoon, Mr. Provencio. Would you please state your name for the record?
Ms. Stevens, before we
start, I'm sorry.
Mr. Provencio, Ms. Gonzalez, our court reporter, will swear you in.
Okay. Got excited.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Yes, I do.
So, hello, Mr. Provencio. Would you put your full name and your new profession for the record?
Okay. Jose F. Provencio. Current profession is rate consultant with assisting matters with the city of Las Cruces.
And did you have the opportunity to prepare and pre-file direct testimony in this proceeding?
Yes, I did.
You have a document in front of you that's been marked CLC Exhibit 3.
Yes, I do.
And is that the prepared direct testimony that was, it's January 9th, and it was actually filed a little bit late, but the hearing examiner suggested that we use this version because it's the one I mistakenly uploaded. But the content of this testimony, is this the testimony that you submitted in this proceeding?
Yes, it is.
And are there any changes that were made in that document prior to its being submitted into the Dropbox?
No, there were none.
Are there any changes that you need to make right now before we release you for cross-examination?
No, there is none.
Was this testimony prepared by you or under your direct supervision?
Yes, it was.
And seeing as you've noted no changes, if you were asked the same questions today under oath, would you give the same answers?
Yes, I will.
Is the testimony true and correct to the best of your knowledge?
Yes, it is.
With that, I pass Mr. Provencio for cross-examination.
Thank you, Ms. Stevens. El Paso Electric, Ms. Olson, do you have any cross-examination for Mr. Provencio?
I do, Madam Hearing Examiner. Hi, Mr. Provencio. It's nice to see you again. I think we said goodbye in the last proceeding, so.
Well, yeah, probably a little bit premature, but good to see you, Ms. Olson.
So I'll dig right into it to try to get through. I'm going to do my best to refer to the Bates numbers in the bottom left-hand corner of your testimony. Well, I thought that was true. Okay, so starting on page 10, you provide your understanding of the history of EPE's RPS cost writer, is that correct?
Yes, that's correct.
And you testify, well, to start, you've been a witness on behalf of the city in a number of these RPS proceedings, is that correct?
Yes, that's right.
And you testify that the city has opposed the RPS cost writer since it was first approved by the commission, is that correct?
Yes, we've had some differences of approach and some really different matters in viewing on how the RPS would be proceeded and calculated.
And is it fair to say the city generally opposes the use of rate writers?
Yes, that's correct. Earlier testimony says that at some point, a lot of these resources become actually part of the system network for the specific utility, and it's better just to handle that through regular rate proceedings.
And that might be an issue that the city is at odds with the legislature on.
Well, that's my opinion, and at least that for the current period, it's one for that city holds also.
It's one for what? I'm sorry.
I'm sorry?
It's one for?
It's one that the city holds also.
But I think you clarify in your testimony in this proceeding that you're not recommending to terminate the rate writer in this proceeding, correct?
Oh, that's right.
And you agree that the future use of the rate writer, the RPS cost writer, is an issue that's being addressed through commission rulemaking?
Yes, that's ongoing.
Do you agree generally that the commission could also address the issue of application of carrying charges through that rulemaking?
It would be an opportune time to address and raise those issues. It's part of the ongoing discussion that we've had in these proceedings.
Okay, and turning to this case, so we're in agreement that EPE is currently authorized to recover its costs consistent with the commission approved REA plans through through its RPS cost writer, correct?
Yes, the actual costs and as projected costs also for the plan year have been approved by the commission.
And did you hear Mr. Reyes's testimony a few minutes ago?
Yes, I did.
And do you generally agree with him that EP's procurement costs recovered include purchases from previous RPS procurements?
Yeah, those are in place as whatever plans that the company has submitted and received authorization to recover those costs to meet the goals of the REA.
Okay. I want to turn quickly to your proposal on carrying charges. And in this case specifically, you're recommending that the rate writer balance be subject to the carrying charges at the weighted average cost of capital. Is that correct?
Yeah, that's correct, Ms. Olson. That's really based on, I explained it earlier in my testimony that company does tend to has over-recovered during the whole series of renewable plans that have been filed, and that the customer balance or customer the customer deposit is minuscule, is very small, and maybe their needs, and there is a reasonable proposal that something a little bit more substantive would be considered to improve or tighten up the recurring over recoveries that the company has sustained over the past several years.
And are you proposing that those carrying charges would be reciprocal?
Yes, I mean, if you're applying it on one side, it would apply on the underside in terms of under recoveries.
And you recognize that the current rider rate includes a substantial credit to return the amounts returned to customers, the amounts previously collected from the CRLEF rec payments.
Yes, I'm aware of that.
And I think your testimony raises a concern that because the revised rider that's proposed in this proceeding has been suspended and therefore likely won't take effect until a final order is issued, in this case sometime in the summer, that the rider is likely to over return the amount previously collected from customers for SIRLIF.
That's likely.
And you speculate that SIRLIF credit would be offset by the amount included in the rate that's currently in effect for BV2 that was not actually incurred by EPE.
Yes.
Did you read the rebuttal testimony from Mr. Rene Gonzalez?
Yes, I did.
And so you saw that EPE accepted or does not oppose your recommendation to credit the 2023 rider rate to offset that amount included for BB2 in the 20.
Yeah, I read that portion of his rebuttal. Right.
Okay, and so that and did you hear Mr. Martinez's testimony that BB2 is projected to be in service prior to the June 1st, 2023 date that was used for the procurement cost projections?
Yes, I heard that in his portion of his testimony.
And you recognize that if that occurs, the procurement cost for that resource will likely be higher than projected in EPE's plan?
It would, and it sets a stage of finally kind of wrapping up a lot of the issues that we have, and I presented my testimony in regard to some of the recoveries, looking forward, and getting stopping the train and getting actual costs that were involved, and truly coming down to what should be adjusted and returned back to the customer.
And so with that understanding that those things collectively are increasing the projected procurement costs, do you still agree, or you continue to propose the increased carrying charges?
Yes, as our position is, as we filed, I still support that, and we're behind that proposal.
Okay. I want to turn very briefly to your section on CRLEF regarding SIRLIF rec costs and the credit to return those amounts in 2022. You don't make any specific recommendations on that issue in this proceeding, correct?
The return of the over-recovered cost of the CLREF. I mean, part of that is to get that back, returned to the customer through this whole process and recognize what that refund or money returned to the customer would be.
Right, and we're in agreement that the rate that's currently in effect is designed to return that amount.
Oh,
Is currently
the existing rate has and factors that in, yes.
And will you agree that the accounting of that return of SIRLIF cost should be addressed as part of EPE's reconciliation of the 2022 rider rate?
Certainly, yes.
Yeah, in EPE's next plan.
Right.
Okay. Next, I'd like to just turn to the large customer issue. You worked for EPE for quite a long time, correct?
Yes, yes. It seems like a lifetime ago, but it's been a while.
And you recognize EPE as a public utility in New Mexico?
Yes, certainly.
And as a public utility, EPE is regulated by the NMPRC?
Yes, that's the going rules of the game with El Paso Electric in New Mexico jurisdiction.
And one area that the PRC regulates is rates that the utility may charge to its customers.
Yes, yeah, that's certainly what how the rate doctrine works. However, we've had differences in pointing out the ongoing over collection or under collection, or what miscollection in terms of the large use customers. We were party to the last reconciliation and REA plan by the company, and it's still a lot of this is focused on this just has to be resolved in terms of when was it reasonable that this factor or this event of waiving away an exemption or the cap for these large customers address the over collection for the rest of the customers in the New Mexico jurisdiction.
Okay, but you recognize as a regulated public utility, EPE is only authorized to charge rates that have been approved by the commission, correct?
That's generally correct, with subject to my prior discussion as to if there's something that's sticking out that doesn't make sense or it needs to be addressed, that's a matter to be discussed and fully litigated.
Sure, but your position is not that EPE could charge a rate different than its filed tariff. Is that
that's
correct?
right. That's right. That charging any different rate that's published in the tariffs is a no-go.
Okay, and on page, I think I was mistaken. I think my notes are the page numbers, not the Bates numbers, but I believe it's Bates page number 27. You start talking about the history, starting with the 2019 plan filing in docket number 19-00099.
Yes, that's right.
And you were a witness in that case.
Yes.
And on page 27, I know you're not a lawyer, but your testimony recognizes that the change in law regarding the cap on large customer billing took effect in mid-year in June 2019.
Right, yeah.
And your position in the 2019 case was that EPE didn't necessarily need to adjust its billing mid-year based on your understanding of treatment of the other IOUs. Is that correct?
Yes, that's right.
And your focus was primarily on the 2020, the rate that was in effect for 2020.
Yes.
And on page 27, line 17, you recognize that EPE filed its 2019 REA plan application in October of 2019.
Yes, totally aware of a lot of the tight timing schedules and a lot of the compliance dates that have to be met. I understand that.
I'm sorry, compliance, what that needs to be met, compliance requirement? requirements?
Compliance requirements and compliance dates.
Do you recall that EPE proposed a revised rate for its RPS cost writer in that application filing?
Yeah, yes, there was, I recall that.
And I believe it's summarized on Mr. Novella's rebuttal testimony on page 30. But do you recall that that revised rate sought to recover plan costs, as it always does, adjust for the 2018 reconciliation, and also eliminate the cap for billing large customers, large non-governmental customers?
Yes, I recall that.
And then on line 19, you referenced the November 18th, 2019 commission order. And is your understanding of that order that EPE was asked to withdraw that proposed rate and file a new rate to affect the 2018 reconciliation?
Yeah, so there was some additional activity going on with seeking approval for that charge back then, but I'm aware of that.
And then on December 17th, 2019, EPE filed the new rate pursuant to that order. And that was the rate that was in effect for 2020.
Yes, that would have been the rate that would have been in effect for the following year.
And I believe your counsel admitted that as CLC Exhibit 8, that rate that was in effect for 2020. And the city objected to that proposed rate. Is that correct? They
Yes.
filed objection.
Yes.
And in part, their objections were because that replacement rate included the large customer cap.
That's right.
And the commission allowed that revised rate to take effect in January 1st, 2020 over the objection of CLC, correct?
Yeah, that's what the outcome was.
And then on page 28, line 14, you then acknowledge that EPE provides another revised rate in its amended application on March 31st, 2020, which proposed to remove the cap on large customer billing. Is that accurate?
Yeah, that's the events that occurred.
And do you recall that EPE's proposed rate was suspended by order of the commission until the commission issued its final order in that case?
Yes.
Okay, and the hearing examiner could take administrative notice of that order issued April 8th, 2020 in docket 19-00099 UT.
I'm sorry, which order are you referring to? Oops, I'm sorry, that also was my video.
The April 8th, 2022 order issued in docket 19-00099 UT that suspended EPE's proposed rate with the cap on large customer billing removed. The last issue I want to briefly cover with you is the 2022 reconciliation calculation, or excuse me, 2021 reconciliation calculation. Were you here for Mr. Gonzalez's testimony? Apologize if I asked you that already.
Yes, I listened to his testimony.
And you heard his testimony that the 2021 reconciliation amount reflected in his direct testimony did not adjust for the $657,823 over recovery in 2019.
Yes, I listened to the discussion.
And if you make that adjustment, the 2021 reconciliation amount would be the $171,655.61 that you identified on page 49 of your testimony.
Yes, that's right.
And with that correction, the reconciliation used by EPE in this case would be consistent with the reconciliation methodology previously applied by EPE.
It would address that one exclusion of that one value, we still believe that a more definitive reconciliation with actual numbers would settle the dust on a long and ongoing trail in terms of a lot of the costs that have been just kicked down the road up until present day.
Sure, and that gets to your testimony about a proposed new reconciliation methodology, correct?
Yes.
Okay. And on page 52, lines 20 through 21, just make sure. Right.
You said page 52, right?
Yeah, I apologize. I think I mean page 54, the Bates page 54.
Okay, I'm trying to get there.
Sure.
Okay, I'm at page 54. Ms. Olson.
Okay, thank you. And this is where you discuss this new reconciliation methodology, correct?
Yes.
And your testimony is that you would subtract the cumulative net over collection amount from the 2023 cost rider. Is that essentially it?
Yes.
And the net over collection amount you identify reflects, oh, I'm sorry. So for example, if we look at your JFP1,
Okay, I'm there.
and specifically the first two tables, is it your testimony that the projected costs in the 2020 plan year case should have been reduced by the cumulative over recovery amounts from both of those tables? Meaning the 1.6 million for 2018 plus the 657,000 for 2019.
Yeah, those are the over recoveries for those two periods would be addressed.
How about for the 2021 plan year case, would you subtract the cumulative over under recoveries from the 2018, 2019, and 2020 tables?
I'm not sure I understand what operation would be happening here. These are cumulative under recoveries, over recoveries, and the process would be the same going forward for the following plan year.
So do you agree that using your proposal to subtract cumulative balances from each plan year's projected costs could double, triple, and quadruple count prior over and under recoveries?
No, the whole concept here is to recognize the over recoveries, return those over recoveries to the customers. Getting the final factor would ensure that there is no over or no continuing tripling or doubling of the over recoveries or under recoveries.
Well, you filed testimony in case number 21-00111 supporting the stipulation, correct?
Yes.
And do you agree that the 2022 rider, which was determined in that case, included an adjustment to return the 427,000 to customers from the 2020 table, which is the third table in exhibit JFP1.
Yes, that's part of the ongoing process of carrying this thing forward.
Does the net over collection amount that you identify in this proceeding reflect the 427,000 from the 2020 reconciliation amount?
Can you repeat your question again?
Yeah, how does the how does the net cumulative over collection amount you identify in this proceeding reflect the 427,000 from the, and that's just a round number, it's 427,931 from the 2020 reconciliation amount?
Okay, I think if I can just back up a little bit. And I mentioned earlier that this whole process has carried forward a lot of issues, a lot of over recoveries. And there's all, and it's used, and it's based on forecast sales kilowatt hour forecast. As we've identified all the different pieces here, what we want to do is get current with what should be returned. And I know there's there is a value here that was returned in the 2021. Let me look at this. In the 2021 filing. And to get closure on this whole issue in terms of what's been accumulated, you want to refund what's been over collected in total. You don't want to double up any kind of over recovery or any return to the customer. But you want to make sure, and this addresses the exclusion of one of the factors in this case. Get to a set of value, get to a value and a factor that addresses all these moving parts so that everything's clear based on actual sales and actual costs.
Okay, thank you, Mr. Provencio. That's all the questions that I have. It's nice to see you again.
All right, thank you.
I think this would be an appropriate time for to have a discussion about the continuation of the hearing. Clearly, we will not finish today. I see that, aside from Ms. LaRoque, who we have scheduled for the 16th, Ms. Souls, you have 3 witnesses and staff have 2 witnesses. So I'm wondering about the February 6th and 7th dates. Obviously, I'd also be inquiring about Ms. Gonzalez's availability. We originally had hearing dates in the related 19-00099 case and 348 cases on February 6th and 7th. Do you have any availability then, Ms. Gonzalez?
I don't know. I can look if you give me 2 minutes. 1 minute.
Go ahead. Sure, go ahead.
Madam Hearing Examiner, while Ms. Gonzalez is looking, I was just going to say I don't have any questions for Mr. Provencio, and we might be able to finish with him today if other parties don't have additional cross for him.
I have no cross for Mr. Provencio.
Mr. Downs?
I have no cross either. Thank you.
Okay.
Staff has no cross also.
Okay. Well, I have a few questions for Mr. Provencio, but perhaps we can get through those relatively quickly.
I was not intending to step on anyone's toes, but just thought we might be able to get Mr. Provencio out of here or save him another trip back.
No, absolutely. That makes sense.
From his library, looks like.
So we have, yeah. How
Madam
about,
Hearing
So
Yes, Ms. Souls.
I'm sorry, I'm not clear what dates you're proposing. I had previously written down February 16th. Are you proposing something different at this point?
We would keep February 16th for Ms. LaRoque. I was wondering about adding another date, which would be February 6th or 7th. I don't know whether we could complete all of the remaining 6 witnesses on February 16th.
Yes, ma'am. I have the same problem with a Monday hearing.
As I was, as we're
Ms.
discussing.
Let's, Ms. Gonzalez, go ahead.
Oh, okay. I am available on either day. At this point.
Thank you.
Madam
Do you
Hearing,
want to go back on the record for the rest of this discussion?
Yes,
or-
let's, no, we can stay off the record for this conversation, I believe. Ms. Olson?
I was just gonna say, if it's largely dependent on EPE cross, I'm very confident we would be able to complete on a single day on February 16th. I think we have some cross-examination for Ms. Sewell's and Ms. LaRoque, but I'm not anticipating having cross-examination for the other witnesses.
Yeah, yes, and staff would note that I think the cumulative amount of cross it would have for the remaining non-staff witnesses would probably be 15 minutes tops.
Okay. Anyone else? Do you see that you would have any
believe-
significant time of cross-examination on the remaining 6 witnesses?
I believe I have some cross-examination, very little bits for the 2 staff witnesses and none, I'm pretty sure it's none for Ms. Souls and her witnesses.
Okay.
I don't anticipate additional cross-examination of any of the remaining witnesses.
Well, it sounds as if February 16th then, does everyone agree would probably work? And I think we'll, I haven't sent out the order on that yet, so we'll probably start at 9 again, just to give us that additional time to make sure we can complete on the 16th. If everyone is good with that. Okay, well, we can go back on the record. I do have a few questions for Mr. Provencio. All right, we're back on the record in the matter of 22-00093 UT. And Mr. Provencio, you know, as you've addressed in your testimony, an issue with respect to an undercharge of several large customers occurred, and previous PRC rulings determined that that should be addressed in this case, correct?
Yes, Madam Examiner, that's correct.
All right. And so just to be clear, because those customers were undercharged, why did that result in an overcharge to the remaining EPE customers?
Under the previous conditions, under the Renewable Energy Act, large customers above a certain energy threshold were capped at 2%.
Right.
If the costs, you know, the projected revenues the projected revenues from those customers that are capped, that were not collected to ensure the proper recovery for the entire company, would then, that differential would have been placed on or rolled in with the recovery for all the other customers that were in the jurisdiction. So what was capped and unrecovered, because they were capped, it couldn't charge anything more for the large consuming customers. That delta was recovered from the rest of the customers.
Was there a true up or reconciliation that resulted in that year that would have redistributed costs that weren't covered by those large customers?
Well, yeah, there would have been the reconciliation under that condition, the cap applying to those large consumption customers. When the time came that the amendments to the Renewable Energy Act eliminated or absolved and made all customers, or at least almost all customers, subject to the cost for renewable energy, that continued in the calculations and the filings that El Paso Electric filed. So it was known that, okay, yeah, you were still reconciling what was the game rules at that time, but it continued further down until it came to a point that, okay, where do we stop and just get caught up and reconcile everything and all the facts and reconcile all the differences that have been accumulated because on the timing as to when the large energy users would fully pay what the act required, and of course the CLREF matter that we had specific with El Paso Electric.
Well, it's a separate matter, right?
Yeah. But that's the underlying. It's a matter of timing as to when you stop and clear the deck and account for what should have been paid by all customers.
But the city of Las Cruces was not one of those large cap customers.
Not to my knowledge, Madam Examiner. I don't believe the city itself has any large facilities that met that criteria, that sales criteria.
Okay. And as far as you know, none of those customers intervened in this case.
Not to my knowledge, and it's the El Paso Electric was to reach out and inform and provide notice to the customers of the upcoming changes, especially in light of this filing that we're undergoing right now.
Do you know whether or not Doña Ana County would be in that category?
I wouldn't know, Madam Examiner.
Okay. So beyond your concern about, I guess what I would call how, EPE has handled charging its customers. I mean, that's your primary concern in this proceeding, Mr. Provencio?
I'm sorry, can you repeat that, Madam Examiner?
Sorry. Okay. Would it be accurate to say that the primary focus of your testimony is this series of billing issues by EPE?
Yes. The billing that eventually was implemented with all the chaos that got rolled into setting the charges. It's important not just for the city as an individual user, but for the citizens of the city as well.
Okay. And do you otherwise have express an opinion in your testimony with respect to the Carne solar project?
I do not.
And do you have anything to add with respect to this issue of, I guess I would call it sort of long-term reconciliation of all of these different overcharges?
My perspective, and in 30 years plus of just being a rate design, rate setting type of individual, that it's a moving target. A lot of these costs that are based on forecasts are slippery, and I fully understand the challenge that the El Paso Electric has. As for the compounded with a lot of the changes that were going on in the REA, especially with in light of the large consumers that no longer have an exemption or are capped, and the legal issue that came out with the CLREF. That just added a lot of mix and to a factor that had to be, number one, calculated to recover legitimate renewable energy costs. And with all that going back and forth, trying to sort that out and get that into a single rate charge for customers that reflected all those positions. We're at this point, we're at a time that we can, okay, let's get all the numbers together, find out what should be excluded, what should be refunded, and what should be recovered going forward for this plan year for the El Paso Electric Company.
Did you listen to Mr. Gonzalez's testimony earlier?
Yes, I did.
And you understand that he is going to submit a amended calculation for the rate rider that's proposed in this case?
Yes, I heard that, and that's welcomed.
And does that, in your opinion, take into consideration this issue with the large cap customers? Yeah,
I mean, subject to the filing of his work papers, it remains to be seen as to how we get this one point cleaned up as we go forward for the new plan year for El Paso Electric.
And is it do you have an opinion on whether or not his discussion about amending the rate rider takes into account the CRLEF overcharges?
Yeah, I mean, the ultimate resolution of the CLREF is also part of the reconciliation, and make sure that whatever costs that should be refunded to the customer are ultimately identified based on actual costs and flow back through the bills, or at least through the factor.
And do you think amendment of the rate rider as opposed to another reconciliation process would be the place to do this?
Amending of the rate rider or the proposed charge?
Well, the proposed rate rider number 38 that's at issue in this.
Yeah, it would have to reflect a change, an adjustment for these items that have been that were not included in this filing.
Okay, I don't have any. Thank you, Mr. Provencio. I don't have any further questions for Mr. Provencio. Is there any redirect, Ms. Stevens?
There is, and I'm sorry, my video just keeps going off. I think it's probably a slightly marginal bandwidth problem here. Mr. Provencio, let me work backwards through the hearing examiner's questions. She asked you about whether the city or Doña Ana County might possibly be amongst the large customers who enjoyed the cap provisions prior to the change in the law. Would you look at your, well, let's see, I was trying to find my way through. Would you look at, well, let's make it easier. Would you look at CLC Exhibit 8, please?
CLC Exhibit 8. All right. I need to.
And are you with me?
CLC Exhibit 8, yeah.
Okay.
And I'm digging it up. Okay, all right.
I believe this is buried somewhere in your testimony too, but it's easier to find it as a standalone exhibit. And do you agree that this is the rate rider 38 that was in effect during 2020?
Yes.
So this is one of the ones that's at issue on this continued granting of a discount, right?
Yes.
And would you just to refresh your memory, would you just read to yourself the description of the statutory cap on billing for certain large customers?
Yeah. NMPRC rule 17.9.572.7 open parent M close parent NMAC limits billed amounts for additional costs associated with RPS procurement for non-governmental customers with consumption exceeding 10 million kilowatt hours per year at a single location of facility.
So by definition, under the old statute, the city and the county were not non-governmental customers, right? They could, no matter what their consumption level, they
Right.
could have enjoyed
Yes,
that.
that's right. Yeah.
benefit. Okay, while we're in this tariff language here, do you see anything in this tariff that would require EPE to continue to give a so-called statutory cap to customers after there was no statutory cap?
My training and my and my experience, a stated tariff such as this that's approved by the commission pretty much is the nexus or the purpose of charging customers for the renewable resources to comply with the act.
Once there was no longer a statutory cap, would there be any customers who were subject to the customer cap?
My understanding is with no statutory cap, you wouldn't have this additional verbiage in this tariff.
And if you look at the reconciliation filing language, which I think is, I again, just because we're running late here, and Ms. Olson, if you can interrupt me if you think the language has changed in the current one, but in this language for reconciliation filings, the last paragraph on that page, does it mandate a 2-year alternating reconciliation process? Just read it out loud. Just read it and tell me whether you think that there's a requirement in the commission tariff to do this on an every other year basis.
Are you asking me to do that?
Just yeah.
I'm not sure if you can direct me as to where this is at.
On the same page here, rate 38.
Oh, I'm sorry.
The paragraph
All right,
that says
okay.
reconciliation
The
filing.
writer shall be reconciled.
Wait. Okay. I'm sorry. The paragraph.
You don't need to read it out loud. I just would like you to refresh your memory and tell me whether there's a 2-year requirement, an alternating year requirement.
No, there's not. There is no such language in the reconciliation filing.
And if we flip to your JFP Exhibit 1,
okay. Exhibit 1.
This is page 64 of 175 of the date stamping on your exhibit. Oh,
yes. Okay, I'm in JFP Exhibit 1.
okay. Can you do from the you and the company have done a sort of a narrative written version of the progress from case to case, but can you sum up that the writer, the $1.6 million figure, the top, the over recovery amount, did that end up as an adjustment, which shows?
I'm sorry, did that end up as a what?
Does that show up as an adjustment two boxes down on the 2021 plan filing? Do you remember that $1.6 million amount being ordered by the commission or by the hearing examiner?
I see it down in the third table to answer that one part of the question. But I'm trying to remember how it was addressed.
Do you recall 2 cases, 2 years worth of annual plans got melded into one.
Okay, there was, okay.
Miss
And-
Stevens, I don't want to,
Okay.
belabor this point, but I'm really not sure where you're getting this from my questions.
Oh, I thought it was from Miss Olson's questions.
Oh,
When she was asking him about the history.
Well, I do recall that there was combined cases and combined reconciliation periods. But, your question to this would be?
Let's move on then. At the very early part of Ms. Olson's cross-examination, she asked you about whether the carrying charge issue could be addressed in a rulemaking. Do you remember that?
Yes.
And in the last rulemaking that was just completed, although I guess it's still potentially subject to an appeal, what did the commission address the carrying charges issue? A generic, standardized requirement for all utilities?
I cannot recall, Counselor. I can't recall.
Okay, I think that's it. Thank you very much, Mr. Reyes. Provencio.
Okay, not a problem.
do you have any recross, Miss Olson?
Recognizing that everybody wants to be done, I do not have any regret.
All right, well, I will then release Mr. Provencio. And when we start on February 16th, we will start with Miss LaRoque, the city's next.
Thank you, Madam Hearing Examiner.
Yeah, and then we'll pick up so we'll actually pick up the order that it was always going to be. Isn't that a weird coincidence?
Thank you. Anything that anyone else feels needs to be addressed at this point? Yes, Miss Gonzalez.
I'm sorry, I have one question. Yesterday, we had some exhibits that were gonna be uploaded or fixed.
Oh, yeah.
And I have a question. I think some others were renumbered and whatnot, and I have a bunch of exhibits that I downloaded, but I'm wondering if when they get uploaded, I can download them again and just throw all those out and start with whatever is in there that's new. Does that make sense?
And
yes, I will
I was going to raise that at lunchtime. I put a note to myself and then forgot. But yeah,
because I don't want to be confused and grabbing the wrong one and putting it.
Yeah.
I'm going to send out a new Dropbox link and a set of all of the exhibits by each party thus far that have been admitted should be re-uploaded and renumbered as appropriate so that Miss Gonzalez has an accurate set as of this point.
Very good.
And then we'll do another Dropbox link prior to February 16th for any exhibits that might be used on February 16th. Does that work does everyone understand that?
I think so, but I do have, so there's going to be this one, the existing one or the new one for February 16th. I think at this point I have 2 exhibits, 5 and 6, the ones that were admitted, which were 14 and 15, and then 5 and 6 that are in the Dropbox that are not intended to be admitted because they're a commission order and a rule, but
correct.
Remote chance they might be used for examination. Should I just dump them or give them like A or B or something?
Well, what I'm saying is that all exhibits that have been admitted as of close of the hearing today should be uploaded to the Dropbox link that I'm going to send you tomorrow. And then if you have additional exhibits that you intend to potentially use for February 16th, I'm going to send out a new Dropbox link for those exhibits so that Ms. Gonzalez has a complete set of exhibits for yesterday and today properly numbered.
Yes.
May I ask a question, Madam Hearing Examiner? Would you like for
Yes.
for us to mark Mr. Tupler's response to the bench request as Commission Exhibit 3 and upload it?
Yes,
Okay,
for the next hearing. Yes,
Got
for
it.
February
Right.
16th. Yes.
right, okay.
And I'll
my-
try to provide some additional or
Oh, boy.
repeat this instruction in the email that I send out with the new Dropbox link.
I do have one little one here.
Yes.
So when I upload the ones that were changed to be 5 and 6 instead of 14 and 15, should I put formerly CLC 14 or just 6, 5 and 6?
5 and 6.
That's all I need to know. Thank you very much.
All right.
Madam
Yes.
Examiner, I
Ms.
apologize.
Olson.
I just have one question for Ms. Gonzalez. I think the EPE paralegal confirmed with you that 10 days is fine for the transcripts for this proceeding. And I just wanted to check for the February 16th date for transcripts from that. I'm just a little bit concerned if we go 10 days out from that, it might interfere with a briefing schedule. So when would we need to let you know?
If you want that fast, you can let me know right now and I'll get the necessary help in place so that we don't have a problem.
So we'll
Okay,
get the transcript for yesterday and today in 10 days.
Yes.
And then we'll separately deal with whether or not February 16th is going to be on a 10-day schedule or whether it's expedited.
Right. Yeah, if you think you want that expedited. I usually get help and I wasn't aware anybody needed it fast. I hope I didn't miss an email from Anna telling me that. I'm okay. Yeah, because
So we
usually
didn't ask for it. Yeah, I'm inclined to think that we should expedite the February 15th. Madam Hearing Examiner, do you have thoughts on that?
I tend to agree.
Okay.
Yeah, I think it would be nice. Yes, Ms. Stevens.
Right now, I'm looking at my calendar. Right now, based on the original procedure, oh, darn, I'm gonna have to do some, my bandwidth here. Pardon me. So my calendar shows that we had in the procedural order, there was a briefing deadline of February 23rd. Is it safe? That's going to be shifted a little bit. That's a week after the second hearing. Okay.
Well, I'll give it some thought.
Okay.
I mean, there should be, a significant portion of the testimony has already been presented. We'll have the transcripts. I don't know that anyone should necessarily wait to start their briefing until February 16th. So I'll give some thought as to whether or not we'll adjust that deadline.
Is it 10 business days, Ms. Gonzalez, or 10 days?
10 business days.
Yeah, so we're looking at.
So look myself, I don't even know. So it's the end of the month, that's my problem.
Well, I think that would make it the 14th, correct?
Yeah, I think I think because it would go, so I'm just not seeing down the calendar. Here we go. Yeah, the 14th and the 15th. And actually, I probably will have both days done by the 14th. I mean, I try to get them all done together, so yeah.
Okay, I'll give it some thought. Obviously, if anyone wants to file a written request for revision of the briefing schedule, they can do that as well.
Would you appreciate our doing that in advance, or remember, this is my trip to Mexico. No, seriously, would it help to ask, would it help for us to discuss amongst ourselves a schedule before
Sure. That would be fine.
Okay, thank you.
You're welcome. All right, I think we're going to conclude today's hearing and I will see everyone on the 16th.